ತಿಂಡಿ ತಿನ್ನಕ್ ಹೋದೆ ಸರ್ ಅಂತ ಇವಾಗ ಹೋದ್ ನಾನು ತಿಂಡಿ ಮುಗಿಸ್ಕೊಂಬರ್ಬೇಕು ತಾನೆ ಮುಗಿಸ್ಕೊಂಬರ್ಬೇಕು ತಾನೆ ಏನೋ ಒಂದ್ ದಿವಸ ವಾರದಲ್ಲಿ ದಿವಸ ಇದೆ ಅಂತ ಫೋನ್ ಹಚ್ಚಿದ್ರಿ ಹೇಳ್ಬಿಟ್ಟು ಹೋದ ಇದ್ರ ನೋಡ್ರಿ ಇದ್ರ ನಿನ್ನೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ದೂರ ಇವತ್ತು ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು ನಾವು ಮಗ ಎರಡು ತಿಂಗಳಿಗೆ ಏನ್ ಹೇಳ್ಬಿಡ್ತೀನಿ ತಪ್ಪ ಆದ್ರೆ ಎಲ್ಲ P1 ಮಾಡ್ತಾರೆ ಅದ್ರ ಕೆಲಸ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೆಲಸ ಮಾಡೋದನ್ನೇ ಮಾಡಲ್ಲ ಬೇರೆ ಮಾಡ್ಬೇಕ್ರಿ ಅಂದ್ರೆ ರೆಡಿ ಇದ್ರೆ ಯಾವ ಮ್ಯಾಟ್ರ್ ಅಲ್ರಿ ಯಾವ ಇಯರ್ ಹೊಸದಾದ್ರೆ ಮಾಡ್ಬೇಕು ಹಳೇದಾರ ರೆಡಿ ಅದರ್ ಸೈಡ್ ರೆಡಿ ಇದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಮೆನ್ಷನ್ ಮಾಡಿ ಲಿಕ್ಬಿಡಿ. ಆಯ್ತು. ಎಲ್ಲಿಗೇನು ಆಫೀಸ್ ಹೊಸ್ದಾಗ ಹೋಗ್ತಾನಲ್ಲ ಎಲ್ಲ ಚೆನ್ನಾಗಿ ಇರ್ಬೇಕಾಯ್ತಾ ವರ್ಷ ಇದೊಂದು ಇವನ್ನೆಲ್ಲ ಸರಿಸಿ ಇಡಬೇಕಲ್ಲ ಕರೆಕ್ಟ್. ನೀನು ಡಿಸೈನ್ಮೆಂಟ್ ಇತ್ತು ದುರ್ಗೂರು ಇಟ್ಟಿದ್ದ.
Sir, sitting later.
ರೆಕಾರ್ಡ್ಸ್ ಹೇಳಿದ್ರು ಅದು ಬಂದಿಲ್ಲ.
ಇದು 43 ಹೇಳಿದ್ನಲ್ಲ.
ಹಂಗಲ್ಲ ಆಗಲ್ಲ ಸುಮ್ಮನೆ ಯಾವಾಗ ಅದರ
Sorry for free service.
With my lord's leave, my lord, a submission with respect to yesterday's principal bench matter, my lord.
Yes, Abhinay.
My lord, sir, I would like to make a request for return of original documents by the trial court. Could the matter be taken up tomorrow for being spoken to, my lord?
No, but you have to move an application before the trial court. But
My
we
lord,
should
now
leave-
the issue is, my lord, yesterday we received a notice where the respondents are contending, my lord, that they are entitled to the document despite not participating. Now the trial court can't
you
adjudicate
work
this.
out your remedy before the trial court. You have
Lord,
produced the
again-
documents, only you are entitled to collect it back. Where's the question of giving it back to the
My lord, now the
respondents?
issue, one more issue, because the my lords have given me liberty under 15. I'll have to move it, my lord. Again, if I get delayed, I'm stuck.
Now you can produce this order before the civil court and get back the documents to pursue the remedy before the concerned court.
Just some
Now, how
observation.
can this court pass any order?
Grateful.
My lord, one submission, my
Work
lord.
out your remedy. We'll release the judgment in another 2 days.
Grateful, my lord.
My lord, one submission, my lord. For the memo for posting, my lord, for 6th, my lord. My lord, my colleague over there has a memo, my lord. We have served the other side, my lord. For B group matter, my lord. My lord, matter pertains to cooperative society bank, my lord. Bank is now trying to start a process for appointment, my lord. They have issued the appointment letter also, my lord. If that process goes off, my lord, my writ petition become infructuous, my lord.
6th.
6th, my lord.
Service matter.
Yes, my lord, please, my lord.
Right? Service day, whichever.
Please, my lord.
No adjournment, mister, on that day. I'm telling you seriously.
Please, my lord, please, my lord.
No adjournment. If you
Please,
move it,
madam.
you should be present.
Please, my lord, please, my lord.
ನಾಳೆಗೆ ಹಾಕ್ತೀರಾ?
My lords, one matter, urgency is there, end of the list, matter pertains to no confidence,
Nice, good.
please.
End of the list, my lord.
End
For
of-
what?
Please executing the position warrant of petition.
I told.
Lord, my lord has already disposed of one writ petition on 24th January. There are certain corrections. I made an IFR correction. Tomorrow,
ಯಾವ matter ಅದು?
GMCPC. Dismissed, I am respondent.
Good, good.
There are certain corrections.
ಏನ್ corrections? Judgmental corrections.
Dates, dates correction.
Dates,
Dates.
ಆಯ್ತು ಕೊಡಿ.
Tomorrow. Grateful.
ಬರುತ್ತೆ ಕೊಡಿ. It will come up on the assigned date, Friday. Friday.
Okay.
ಅದು ಕರೆಯಲ್ಲ.
Your Lordship, serial number 59.
Hmm.
On behalf of Rupa Sagar Patil, Your Lordship, kindly a week's time you grant. I already intimated to the petitioner.
And
also.
counsel for the response 2136 time list on
59.
Hmm.
Serial number 63, my lord. I'm for the
59
respondent.
ಅಲ್ಲಿ entry ಮಾಡಿದ್ಯಾ? 59 entry ಮಾಡಿದ್ರೆ ನೋಡಿ extend ಮಾಡ್ರಿ ಇದ್ರೆ. Yes.
Serial number 63, my lord. I'm for the respondent number 4. Kindly week time may be granted.
Basuraj Nadagoda.
Yes.
Learn counsel for the respondent before 6 time list on
May I make my lord one, serial number 54,
uh,
62, both 54 and
serial number
54 and 62. Lordship has directed to produce certain documents. I am unable to, my lord, next,
serial number 54 learn counsel for
Next
the
week it-
petitioner 6 time list on so and so.
please.
Hmm.
62 also.
62 ಅಲ್ಲಿ kindly have it on day after. ಅದು ವರ್ಕ್ ಪೆಂಡೆನ್ಸಿ ಇದೆ, ರೋಡ್ ವರ್ಕ್ ಸ್ಟಾಪ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ರಿಪೋರ್ಟ್. ಅವ್ರು ನಾಡಿದ್ದು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇಟ್ ಮೇ ಟೇಕನ್ ಆನ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಇಟ್ಸ್ ಅನ್ ಅರ್ಜೆನ್ಸಿ.
I will take it up today itself.
Survey report our last time ಹಾಕಿದ್ದಾರೆ, but I have to secure instructions from my client. I called upon them, my lord,
The
they
6 time list on. South.
ಡೇ ಆಫ್ಟರ್
day
ಟುಮಾರೋ.
after. Please.
Great.
Hmm. 63 note 8 ಕೇಳಿದಿರಾ?
Other side.
Yes, next.
My lord, serial number 70, kindly have it next week, my lords. I am appearing on behalf of Sangarusa B. Patil.
ಯಾಕೆ ಇನ್ನ ಬಂದಿಲ್ವಾ?
Bandara, but kindly have it next week, my lords.
ಎಷ್ಟು ಹೊತ್ತಿದ್ದಾರೆ?
ನಿನ್ನೆ late ಮಾಡೋದು.
ಬಂದಿದ್ದಾರೆ ಗೌರೀಶ್
ಇಲ್ಲ.
ಬಂದಿದಾರಲ್ಲ.
ಅಲ್ಲ ಬಂದಿದ್ದಾರೆ, ಎಲ್ಲರೂ ಅವರು ಬಂದಿದ್ದಾರೆ, ಬರ್ತಾರೆ ಸ್ವಲ್ಪ. ಇವತ್ತು ಏನೋ ಸ್ವಲ್ಪ.
For the petition 6 time list on. Hmm.
That's a weak recommendation
1 week time is granted to do the needful.
published.
1 week. Harshvardhan.
I'll do that.
1 week.
Yes.
Next 2 weeks granted as a last chance, failing which the petition shall stand dismissed. Without reference to bench.
A week's time may be granted to sir answer this.
Whether R71 is necessary,
Yes, Your Lordship.
huh? 1 week time is granted to do the needful. Suit is filed, yeah, the suit alla, okay. 1 week time is granted to do the needful.
Much.
Yeah, R6, who is R6? R6 dead, and
Private party, my lord.
what is issue to respondent number 6? Despite the order dated 20, Arun Kumar. Bro, ಏನು steps ತಗೋತೀರಾ ಇಲ್ಲ?
My lord, cover is returned with a
I
shara
agree.
that he has refused to accept the note.
That happened in the August 2024 ಅಲ್ಲಿ ಆಗಿದೆ ಆರ್ಡರ್ ಅದು. ಏನು?
Due to,
It will be dismissed ಅಂತಿದೆ. August 2024 ಅಲ್ಲಿ.
in view of endorsement, my lord, substituted service may not be required.
This
Sorry.
August 2024, there's an order. The application to be filed for subservice on or before 13/9/2024, failing which the petition shall stand dismissed.
During the course of day.
The learned counsel for the petitioner undertake to take steps during the course of the day. List on,
Please,
if application is filed, list on so and so.
please.
R6 to 11,
My lord, needful done, my lord.
huh?
Needful done.
What needful done? What have you done?
We have
Process ತಗೊಂಡಿದ್ದೀನಪ್ಪ.
Yes, my lord.
What is there to show you paid the process? 25-1.
ಪಾಸ್ ಅವ್ರ ಮೇಲೆ ಕಟ್ಟಕ್ ಹೋಗಿದ್ದಾರೆ
ಅದ್ ನೀಡ್ಫುಲ್ ಡನ್ ಅಂತ ಯಾಕೆ ಹೇಳಿದೆ?
ಕಟ್ಕೊಂಡ್ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ವಿ.
Yes.
In the morning, I paid the notes process and taken the.
I already dismissed the
paid
writ petition.
I
ಏನ್ ಮಾಡ್ತೀರಿ?
there is some mistake on my part. My clerk has not paid it. In the morning, I have.
Pass over. Steps in respect of R5, deceased R5.
Week's time may be granted.
1 week time is granted to do the need. 1 week Saka.
Yes, yes.
When did the respondent number 5 die?
Your lordships, it was in fact informed through
Postal receipt ಯಾವತ್ತು
sir.
ವಾಪಸ್ ಬಂತು? Hmm? One, 2 weeks time is granted to do the needful. Yes.
So week's time may be granted in this matter.
Do it today.
Your Lordships, he is out of town. The council is out of town. I'm proxy counsel.
I'll give you my file. Please do it today.
Please apply.
ತಿರ್ಗಾ ನೀವು ಅವ್ರಿಗೆ ಹೇಳೋದ್ ಮರ್ತೋಗ್ತೀರಾ, ಅವ್ರು ಮರ್ತೋಗ್ತಾರೆ, ಇವ್ರು ಮರ್ತೋಗ್ತಿರ್ಗಾ ಹಿಂಗೆ ಆಗುತ್ತೆ. All these preliminaries, please don't ask for time.
Please.
Once it is notified, it should be done.
Please.
Not in this matter, the other side has filed the objections.
For disposal,
Adu memo, there was a one judgment I produced. The similar issue was dealt. But however, my lords, in the objections, they have produced the order of writ appeal. I will, my lords, file the entire judgment set, my lords, and argue next week, 18th.
Memo dated 17/9/2024 for disposal of the petition based on an order passed in WP number.
I have produced my lord writ appeal copy along with my objections.
Writ appeal number so and so.
Illa writ petition.
Maybe, not it may
In
be.
WP number 202162/2022.
202162/2022 is rejected
That
in
are-
view of a writ appeal filed there.
ಇಲ್ಲ ಅದ್ರ ಮೇಲೆ writ appeal ಇಲ್ಲ.
ಮತ್ತೆ ಅವ್ರು
ಇಲ್ಲ.
ಹೇಳ್ತಾರೆ,
ಇಲ್ಲ ಅದ್ರ ಮೇಲೆ ಇಲ್ಲ.
ನೀವು ಕೊಟ್ಟಿಲ್ಲ ನಮ್ ಕಾಪಿನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಇವ್ರು.
Like what I have produced, my lords,
copy.
relied on learned
You have
single judge
produced,
order
the
in the writ petition. They have, my lords, went in writ appeal and there was some modification of that order. Therefore, I need to, my lords, go further and to inquire about that.
It may be heard in B group, not next week itself, not. I have no objections at all.
ಆಯ್ತು, you say that an appeal is filed against this order.
Yeah,
ಇಲ್ಲ ಇಲ್ಲ ಇದ್ರ ಮೇಲೆ ಇಲ್ಲ.
ಅದು ಯಾವ್ದು ಗೊತ್ತಿಲ್ಲ ಅವ್ರು ಯಾವ್ದು.
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ನಾ ರಿಟ್ ಪಿಟಿಷನ್ ಯಾವ್ದು ಒಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ರಿಟ್ ಪಿಟಿಷನ್
No,
ಅಲ್ಲಿ
no, no.
ಪರ್ಟೈನಿಂಗ್ ಟು ದಿಸ್ ಇಶ್ಯೂ, ನಾಟ್ ದಿ ರಿಟ್
No, no.
ಪಿಟಿಷನ್.
Correct. 201262.
ಇದ್ರ ಮೇಲೆ ಆಗಿಲ್ಲ.
ಹಾಕಿಲ್ವಾ?
ಆಗಿಲ್ಲ.
And I have,
The memo dated 17/9/2024 shall be taken up for consideration at the time of disposal. Yes, list on date. When do you want it? If both of you are ready,
18th.
please
this
take a
week,
date.
next week,
18th.
not in B group,
No, both of you, if you are ready, you take a date in February. Otherwise, we'll list it in March.
ಇಲ್ಲ 18th.
Unnecessarily, I don't want to list the matters if
it
you
has
are
to
not
be heard,
ready.
my lord. My learned friend is making it very simple, my lord. It's not so. My lord, when the writ
No,
appeal
what
was
I am trying to
pending-
tell you is if both the
ma'am.
parties are willing to address arguments, I will list it in February. Otherwise, we'll list it thereafter.
Your
If
lordship,
both of you are ready, I don't want to list it and adjourn the matter unnecessarily.
my lord, my submission is this, my lord. It cannot be disposed of in at a memo stage, my lord. That's my
Sir,
submission, my lord.
Are you willing to address arguments on the main if it is listed in February?
Yes, my lord. Yes, my lord. I will.
18th,
on
my lord,
date.
sorry.
List on date.
18th.
18th ಬೇಡ, my lord. I am not out of station, my lord. 21st ಆದ ನಂತರ ಒಂದು.
ಯಾವತ್ತು ಬೇಕು?
21 ಆದ ನಂತರ ಕೊಡಿ.
Mobilize.
Harshvardhan.
lordship time. For produce from the additional documents, lordship, I seek 2 weeks time, lordship.
Learned counsel for the petitioner seeks time. List on.
11.
2 weeks and
2 weeks, Lordship. 18. Please. In service for what? 1
After
to 3.
service of notice to the concerned respondents.
1 to 3. There's an interim order.
Interim order granted earlier is extended till the next date. Geeta Anna Rao.
My lords, I seek dispensation of notice to respondent number 10 and 11.
File a memo. Learned counsel for the petitioners filed a memo seeking dispensation of notice to respondent number 10 and 11. In your
My lord.
memo, notice to respondent 10 and 11 is dispensed at the request and risk of the petitioner.
Contesting respondents are only respondent number 4 and 5. They've been served. They're not represented.
List
I
for
may be heard.
preliminary hearing in B group. ಯಾವತ್ತು ಬೇಕು?
Next week, any day.
ಯಾವತ್ತು ಅನ್ಕೊಳ್ರಿ?
Obliged.
ಅಣ್ಣರಾಯ.
Affidavit as per the direction of the Honorable Court, affidavit is prepared and I have to serve the copy upon the other side. Kindly pass it to her, I'll serve.
Pass.
Please. Illila, I have to serve the copy.
ಎರಡರಲ್ಲೂನಾ? Both the matters?
933.
ಅಲ್ಲ 14.1 also? 14.1.
203933 ಅಲ್ಲಿ ಇದೆ.
ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ 203931.
31 ದಲ್ಲಿ
31 ನೀವೇ ಇದ್ದೀರಲ್ಲ?
ಇದೆ but affidavit that video is not.
Yes, pass over. Next. 22 and 27.
14.1.
14.1.
This is where?
Office objection. Is overruled by accepting the submission of the learned counsel for the petitioner.
Already interim order granted, my lord.
Huh?
Interim order granted on 24/1. Awaiting service of respondent number 5 is awaiting.
List after service of notice to respond number 5.
Office objection is with regard to the furnishing entire set of the ROR. RORs are produced only for reference. Since lands of the petitioners are already acquired and award is passed. Page number 16,
You're not relying on those documents.
no, my lord, it is only for reference to show that our lands were acquired and the award is already passed showing our name.
The office objection is number 22 is overruled by accepting the submission of the learned counsel for the petitioner. List. Ian, what is it?
Seeking
about?
mandamus, my lord, our lands were acquired way back in the year 2013. Award is passed, my lord, as per annexure B.
What are
Page
your
number 70.
representations?
Till today, we are not been paid a compensation, my lord, though in spite of.
Government. Get instructions, mister. We'll list it next week. Why you're not paying the compensation? AJ is directed to accept notice for the respondents. He is directed to secure instructions as to why the compensation is not paid to the petitioners. List on 11 to 2 weeks.
Obliged.
Appearing on behalf of the Malad, the Raghavendra Naik Malad is the obtained the NOC Malad, the security documents purpose Malad is 2 weeks time for the Malad.
Learned counsel for the respondent 4A, R3E.
Please.
R5A to R5E seeks time. List on.
Please.
During the
Vacancy of writ petition, petitioner is dead. Therefore, my lord is,
IA 2 of 25 is filed to bring the, filed by the applicants to come on record as the legal representatives of the deceased petitioner by setting aside, by condoning the delay in filing the application and setting aside the abatement. Since the cause of action has survived the death of the petitioner, the applicants are entitled to pursue this petition. Hence, IA 2 of 25 is allowed, and the delay in filing the application to come on record is condoned, and the abatement of the writ petition is set aside. The applicants are permitted to come on record and contest the writ petition. Counsel for the petitioner is directed to amend the cost rating. Amend it.
please, next week it may.
Office objection is so. Mantesh, but office
do it.
objection notary.
Only one objection, sir. I will,
Notarize ಮಾಡಿಲ್ಲ ಅಂತ.
I will verify.
Please do it.
I will do it within a 2 days.
List down on date. Next.
Great.
ನೀವು ಹೋಗ್ಬೇಡಿ ಮಾಡಿದಿ
Please,
ತಿರ್ಗಾ ಇನ್ನೊಂದ್ ದಿನ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ರೇಟ್
I'll
ನಾನ್
carry.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅದೆಲ್ಲ ಬರ್ತದೆ
I'll carry.
ಮಾಡಿ.
I am for respondent.
I appear for the petitioner in this case, Your Worship.
Senior counsel personal
Huh?
inconvenience. I am for appearing for respondent number 4.
Respond number
4.
ಶ್ರೀದೇವಿ
Yes.
ಶರಣ ಬಸಪ್ಪ.
Yes.
Worship, respond number 5 on the last date of hearing.
Jaikumar S. Patil ಅವರು personal inconvenience ಇದ್ದಿ ಸಲುವಾಗಿ next week.
So, who-
Pleadings complete ಆಗಿದೆ ಸ್ವಾಮಿ ತಗೊಂಡ್ರೆ
ಆಯ್ತು, ಯಾವತ್ತು ಬೇಕು?
ನೆಕ್ಸ್ಟ್ ಕಾಲ್ ಡೇಟ್ ಕೊಟ್ರೆ
Next week particular ಆಗ್ತದೆ.
Copies of the objections. You received the copy of the objections?
please I have received the Lordship.
So copies of the learned counsel for the petitioner submits that he has received copy of the objections filed by the respondent number 5. So learned counsel for the respondent 4 seeks time, list on.
ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ರೆ ಸ್ವಾಮಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ interim order to be continued.
Interim order is extended to the next date.
I appear for the petitioner. 1812 order, my lord, to produce the original documents of annexure D is directed. On last 3 occasions, my lord, government has sought time.
Yes.
My lord, I have sent letter, my lord. It has not received, my lord.
ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು? Who is the one who has to,
My lord,
the one who has to give the documents to you?
Tahsildar.
the respond number 3, Tashildar.
The learned AGA submits that he has addressed a communication to the respondent number 3 as per the order passed by this court dated
1812-2024.
18/12/24. He submits that till date he has not received any instructions. Hence issue bailable warrant to the respondent number 3 in a sum of rupees 25,000, requiring him to produce the documents, requiring to appear before the court along with the documents. Yes, list on.
11.
My lord, instead of 11th, my lord, 17th, my lord,
Take whatever date you want.
18th.
Yes.
The dispensation of
IA
annexure
1
F,
of 25 is allowed.
but annexure F is in challenge, whereby the petitioner's land has been declared as acquired, not the petitioner and other villages who had, the fifth respondent is a company, Sri Cement, which is acquired, is proposed for acquisition of sliding connectivity to the railways, my lord, dead end railway to the company individually. Earlier, my lord, the petitioner and other villages had consented on the ground that, my lord, the outright purchase will be taken. But outright purchase, not the petitioner, since there was a litigation, has not even taken a compensation or outright purchase. He has not executed any deed or GPA, my lord. Now, my lord, the fifth respondent claiming to be owner of the entire land and has taking benefit from the railways. My lord, the Railways Act, my lord, the section 2 has been invoked in the Railways Act, my lord. My lord, the Railways Act, invocation of the Railways Act is not at all the public purpose, my lord. It is for public purpose, whereas the fifth respondent is a individual beneficiary for that project, my lord. Under section 227A, my lord, capital A. Lord, may I read? Definition itself, my lord. Special railway project means a project notified as such by the central government for time to time, providing national infrastructure.
237A.
237A. Means a special railway project means a notified as by the central government for time to time for providing national infrastructure for public purpose in specified time frame covering one state or more states or union territories. Whereas, my lord, in this case, the fifth respondent, my lord.
Public purpose defined here?
No, my lord. But whereas in this case, my lord, the fifth respondent is individually benefited from the Railways Act, my lord. The invocation of the Railways Act itself is totally illegal, my lord, on the part of second respondent. Since, my lord, the fifth respondent is alone a beneficiary, and now, my lord, the compensation is to be taken by the company on the ground that, my lord, they have already purchased and they are the owners of the land on the higher rates. Whereas the petitioner and other villages have got a meager compensation from the fifth respondent. This was suppressed before to the petitioner and other villages, my lord. It is a dead end, my lord, that, to the company. For the individual benefit of the private company, the Railways Act has been invoked.
So please read what is the definition of a railway?
Yes. Railway means a railway, any portion of railway for the public carriage of passengers or goods and includes all lands within the fence or boundaries, marks indicating the limits of the land approved tenants to the railways, all lines of the railway, slidings, yards, branches used for the purpose of or any connectivity with a railway, all electric transition equipments, power supply and distribution installment used for the purpose of or in connection with a railway. All rolling stocks, stations, office, warehouse, warehouse, workshops, manufactories, fixed plant and machinery, roads, streets, running rooms and restrooms, institutions, hospitals, water works, water supply installation staff, dwelling and other works constructed for the purpose in connection with the railway. All vehicles which are used for on any road for the purpose of traffic or railway are owned and hired work by the railway, and all the ferries, ships, boats and raft which are used on any canal, river, lake or other navigable inland water for the purpose of traffic or railway and owned, hired and worked by the railway administration, but not include a tramway wholly with a municipal area, a line of a rail inbuilt in any exhibition ground, fair or park any other railway solely for the purpose of recreation. My lords, in the definition of railway, the notification will not be covering because it is a benefit of private fifth respondent company, my lord. And moreover, my lord, the fifth respondent has taken a benefit from the state government for the sake of approval, my lord. They have informed the state government that they have purchased the land. Now, after this approval of establishing the.
Where have they said that?
My lord, Annexure B, my lord.
Annexure?
B. Page 21. May I take that? Government was pleased to accord in principle approval of the investment proposal for so and so or unit for unit of rail sliding between cement manufacturing plant and storage and baggage plant with the investment of so and so crores, generating employment of about 54 persons in so and so village with following associates. This, my lord, these lands have been shown that, my lord, they have purchased. My lord, may I take to another?
Last line.
My lord, page 27.
No, page 20 will be.
Yes.
Land to be purchased by the company.
Yes. And in page 27 as well. 27 para, fourth para. my lord. This is the extension of the approval granted by state government, my lord. Amendment. Further, as per the decision of so-and-so meeting on 5/3/22, government has accorded grant permission of to so-and-so company for purchase of additional land of 20 acres, 5 guntas of so-and-so for construction of Lord so-and-so has been issued. Lord, now the state government,
Yes, Mr.
Our notification page number 47, Malash.
Page number
47.
47.
Notification dated 26th September.
Hmm.
Purpose of the first para, my lordship. Whereas by notification of the Government of India in the Ministry of Railways Board, so and so number 26 published to the purpose, the project name is Special Railway Project, namely proposed seeding connectivity to Kodla Cement Plant of Messrs. CH-3 Cement Limited with the extension from dead end of their existing Gati Shakti multi-modal cargo terminal served by the Sulehalli station on the SC Wadi. That is the purpose for the extension of the our.
No, correct, but you're doing it for some private entity. What is the public purpose that you're achieving by laying a line to a cement factory? You're trying to help the cement factory to evacuate the cement or whatever raw materials from Wadi Junction to their cement factory. This is not a public purpose.
Take instructions, I am fine.
Then don't proceed, let the notification be stayed. Yes, who appears for Sri Cement
One-
here?
individually I have to take hand summons. my lord.
Is there any lawyer for Sri Cement?
No, no, my lord. No, my lord. Lord,
Good.
193 is
192 I
Sudhir
am-
Singh. 2 and
192.
4 is government.
Sudhir Singh Vijapur is directed to accept notice for respondent number 1
And 3. 2 and 4 state government.
AG is directed to accept notice for respondent 2 and 4. Issue hand summons to the respondent number 5. Till the next date of hearing, the respondents 1 to 4 are directed not to take any precipitative action pursuant to the notification dated 26/9/2024. Insofar as the land bearing survey number,
My lords. Survey number 25, measuring 1 acre stand.
survey number 25 of
Dongaon.
Donagaon.
Donagaon.
Donagaon, Chittapur Taluk, Kalaburagi district, measuring 1 acre 10 guntas. Yes. List down on date, good.
Okay.
Shivanand Patil.
Yes. Dispensation.
Yeah, 125 is allowed. Yes, next.
In this matter, this petitioner has purchased one extent of land of 5 acres, 11 guntas. Now this land, right from the year 1965, when the survey settlement took place and the Akar Bandh was prepared, it has been always shown a extent of 3 acres, some odd guntas therein, has always been shown as Fort Karab A. Now Fort Karab A is in inalienable land, which vests with the landowner, available for use in course of time. Now, all of a sudden, this respondent number 4, after 60 years roughly, he seeks to unsettle that, stating that by oversight it has been recorded as Fort Karab AL. Now, if your lordship is pleased to look into annexure, page 106, man.
But there should be an appeal against this order along.
Yes, appeal ಮಾಡಿದ್ದೀನಿ.
106.
ಅಪೀಲ್ ಮಾಡಿದ್ದೀನಿ, ಅದರ ಮ್ಯಾಗೂ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
What is 106?
Page number 106 may invite the attention of. ಆಕಾರ ಬಂದದ್ದು ಇದು ಇದೆ. ಇದೆ ಸರ್ವೆ ನಂಬರ್ 341 ತೋರಿಸಿದ್ದಾರೆ. Your lordship will find 3 acres 33 guntas as A. And 4 guntas as B. That is for the road. Now, this officer now states that by oversight 3 acre 33 gunta is entered in A, not in B. Now, how can there be an oversight when there is very consciously at the time of settlement, it has been stated as A and B. B 4 guntas, A nalli 3 acre 33 guntas. This entry, your lordship will find it at annexure. Page number 32, annexure C nalli.
Annexure?
C nalli bandaga. This is a continuous RTC that has been affected. Your lordship will see at column number 3. Fort kara A one ಬೇರೆ ತೋರಿಸಿದಾರ, Fort kara B one ಬೇರೆ ತೋರಿಸಿದಾರ. A ನಲ್ಲೇ ತೋರಿಸಿದಾರ 3 acre 37. So this entry continues from 1965. Now, whether the assistant director of land records has the authority to unsettle it, that your lordship will find it at, it's only because when the survey settlement takes place, the report is submitted to the deputy commissioner. The deputy commissioner sends it to the state legislature where it is approved. Thereafter, it is only the state.
No, they want to declassify only 6 guntas of land.
No, 3 acre 30 guntas.
Please come to page number 42, annexure here.
40?
42.
ಇಲ್ಲಿ ಲಾಸ್ಟ್ ನಲ್ಲಿ ಕಾರಣ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿ 341 ದಾಖಲಾಗಿರುವ 3 ಎಕರೆ 33 ಗುಂಟ ಅ ಖರಾಬನ್ನು ಬಿ ಖರಾಬ್ ಆಗಿ ತಿದ್ದುಪಡಿ ಮಾಡಲು ಕರ್ನಾಟಕ ಭೂಖಂಡ.
ಕೆರೆ ಹಾಗೂ ಹಳ್ಳದ ಜಾಗ.
ಪಡನ್ ಅವ್ರಂತಾರೆ ಕೆರೆ ಹಾಕುವ ಹಳ್ಳದ ಜಾಗ ಅಂತಾರೆ. ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಕೆರೆ. And the photos I have already produced before the lordship did that annexure. E series nalli photos ನೋಡ್ಕೊಂಡು. Your lordship will find them at page number 40, 41. ಅದೆಲ್ಲ ಲ್ಯಾಂಡ್ ನಾವು ಕಲ್ಟಿವೇಬಲ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ, ಕ್ರಾಪ್ಸ್ ಬೆಳೀತಾ ಇದ್ದೇವೆ. And this has been going on for decades.
Your clients are here. Your clients are here. Ilva?
ಇಲ್ಲ, ನಂದು ವಯಸ್ಸೇ ಆಗಿದೆ. Because I have this, ಇದರದ್ದು ಆಪರೇಷನ್ ಆಗಿದೆಲ್ಲ, I put more force on that, my lord.
Yes, government.
I am taking instruction. It is.
Appeal ಹಾಕಿದಿರಾ?
ಅಪೀಲ್ನು ಹಾಕಿದ್ದೇನೆ. ಅಪೀಲ್ನು blindly, casually, it has been attended very casually.
ಇಲ್ಲಿದೆ ಅಪೀಲ್.
Page number
Annexure
96.
96 ನಲ್ಲಿದೆ.
Annexure P.
Against this, there must be an order, the appeal before the KT ಅಲ್ವಾ?
ಇಲ್ಲ, ಅದು ಜಾಯಿಂಟ್ ಡೈರೆಕ್ಟರ್ ಮೇಲೆ ಬರ್ತದೆ. Against an order of the assistant director, it lies before the joint director.
ಕಮಿಷನರ್ ಮುಂದೆ ರಿವಿಷನ್ ಇಲ್ವಾ? ಕಮಿಷನರ್ ಮುಂದೆ ರಿವಿಷನ್ ಇಲ್ವಾ?
ರಿವಿಷನ್ ಬರೋದಿಲ್ಲ actually, because
ನೋಡಿ ಚೆಕ್ ಮಾಡಿ ನೋಡಿ.
I had once applied there once in one matter. They said that, second appeal ಆಯ್ತಪ್ಪ ಅಂತಂದ್ರೆ there is no further appeal.
ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲ.
ಇದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಆಗಿದೆ ಅದರಲ್ಲಿ. ಯಾಕಂದ್ರ ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ he has considered himself as an appellate authority. Sorry, deputy director has considered himself as a.
There is a power of revision under the.
Yes, my lord, I know. It's
56 alva.
ಇದು 56 ನಲ್ಲಿ ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ.
How can he answer it under 56? This is under 49.
50L second appeal. Section 50 second appeal.
ಇಲ್ಲ 56.
If such an order is passed by the joint director of land record.
Yes, my lord.
To the tribunal. So you have to file an appeal before the tribunal. 50C noti.
54 hours of appellate.
50C noti. 50 subclass C.
Yes, ma'am.
1C.
A second appeal shall lie against an order if such an order is passed by assistant commissioner to the deputy commissioner. Such order passed by deputy commissioner to the tribunal. Now, second appeal has already been exhausted.
Now, how can this be a second appeal? This is a first appeal.
ಅವ್ರು ಅದೇ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ.
Who treat ಮಾಡಬಹುದು? It is treated as a first appeal only.
That's for one reason that why I have come before this honorable.
ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಹಂಗಂತ?
ಸಮೀರಿಂದ ಪೀಠಿಕೆದಲ್ಲೇ ಬರ್ದಾರ. ಅವ್ರ ಅಪೀಲ್ ಆರ್ಡರ್ ವಿರುದ್ಧ ನನ್ನ ಹತ್ರ ಬಂದಿದ್ದಾರೆ ಅಂತೆ.
ಪ್ರಕರಣದಲ್ಲಿ ನೀಡಿದ ತಡೆಯಾಜ್ಞೆಯನ್ನು ತೆರವುಗೊಳಿಸಿ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಲಂ 50 ಅಡಿಯಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರದ ಮೇರೆಗೆ ಈ ಕೆಳಕಂಡಂತೆ
ಭೂ ದಾಖಲೆ ಉಪನಿರ್ದೇಶಕರು ವಿಜಯಪುರ ಇವರ ಮೇಲ್ಮನವಿಯ ಸಂಖ್ಯೆ ಸಂಬಂಧಿಸುವಂದು ಹೊರಡಿಸಿದ ಆದೇಶದಿಂದ ಬಾಧಿತರು ಅರ್ಜಿದಾರರು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ. ಅಂದ್ರೆ I have already exhausted the remedy according to them also by under second appeal. ಕಾಯ್ದೆ ಕಲಂ ನಂಬರ್ 50 ಅಡಿಯಲ್ಲಿ ಎರಡನೇ ಮೇಲ್ಮನವಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
Where is the first appeal order?
First appeal order is your lordship will find it at once. Page number 18 ಅಲ್ಲಿ ಇದೆ ಮೇಡಮ್.
Page number 80.
75.
Operative portion.
This is some communication sent by the
assistant
ADLR Vijaypura.
Yes. That is which, so against which an appeal is being taken up by the assistant director, deputy director of the land records, and against which now the joint director says that the second appeal has been filed.
No, but is this the order passed in the first appeals? Page 75.
Page 75 first appeal.
ಅದು ಹೆಂಗಾಗುತ್ತದು?
ಅವರೇ ಅದೇ ರೀತಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಅದೇ ರೀತಿ ಎಂಟರ್ಟೈನ್ ಮಾಡಿದ್ದಾರೆ.
Please read the page, at page 76 ಏನಂತ ಹೇಳಿದ್ರು?
70
first paragraph.
Yes, ma'am.
ವಿಜಯಪುರ ಜಿಲ್ಲೆ ಬಸವನ ಬಾಗೇವಾಡಿಯ ತಾಲೂಕಿನ ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ದಾಖಲೆ ಪ್ರಕರಣ ಕೆರೆ ಹಳ್ಳದ ಖರಾಬನ್ನು ಅಖರಾಬು ಎಂದು ಬಿ ಖರಾಬು ಹೊಂದಿಸಲು ತಿದ್ದುಪಡಿ ಆದೇಶ ನೀಡಲು ಕೋರಿ ಭೂ ದಾಖಲೆ ಸಹಾಯಕ ನಿರ್ದೇಶಕ ಬಸವನ ಬಾಗೇವಾಡಿ ಇವರ ಉಲ್ಲೇಖ ಪತ್ರದ ಮುಖಾಂತರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಉಲ್ಲೇಖ 2 ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
So this is the original request made by the ADLR. to the
Actually, it
deputy
should
dir-
be, in fact, even that was what I also felt,
Ah,
that it is the ADLR who has passed and who has made a requisition. But in fact, ADLR also cannot make a requisition, that is secondary, but it has to be treated as a requisition by ADLR. So that requisition is challenged before the joint director.
director.
That should be treated as first appeal. Joint director, he entertains it as only a second appeal. only.
Then we'll treat it as a first appeal and we'll direct you to file a revision before the tribunal.
Yes. But neither of them have the power, my lord. There is no power of the authority illa avrige yakappa antandre under section 120 of the Land Revenue Act, they don't have the power. They are only the custodians of those records. They cannot pass any orders.
Oh, this could be a wrong order, but you have to challenge it in the manner known to law.
And that is why I am challenging it before the writ, my lord, because when they don't have jurisdiction to have passed such an orders.
Then you should have come to the High Court directly. Why did you go to the joint director?
Otherwise, High Court bandino ondsari avunu.
Correct. Why did you go to the joint director? You went to the joint director, so you follow that line only.
But that will be totally illegality.
Correct. You have filed an appeal against the order passed by the deputy director before the joint director. The next level is before the tribunal. Go to the tribunal, come back to the High Court.
But they have mentioned it a second appeal.
You can't burn your bridges.
I will convince you.
Barkold. Yen madodu?
Interim orders.
Interim order, you convince me regarding maintainability.
Maintainability I have, because I have gone by what is stated by them only. They state that it is a second appeal. And he has entertained the appeal under section 50.
You please have a look at the petition that you have filed. You filed not under section 50. You filed it under section 55. I don't know under what provision you have filed. Appeal nodi joint director ಬಂದು ಯಾವ provision ಹಾಕಿದಿರಿ? You have filed it under 56.
I had filed a revision before the joint director. He converted it into an appeal.
Even if it is considered as a revision.
56 ನಲ್ಲಿ ಬರುತ್ತೆ ಅವರಿಗೆ.
Yes. ನೀವು ಯಾರ ಮುಂದೆ ಹೋಗ್ಬೇಕಾಯ್ತು ರಿವಿಷನ್ಗೆ?
ಜಾಯಿಂಟ್ ಡೈರೆಕ್ಟರ್ ಬಳಿ ಹೋಗ್ಬೇಕಾಯ್ತು.
Not inferior in rank to a
Deputy
director of land records or an assistant settlement officer.
Not inferior to the rank of a deputy director of the joint director.
Please come to section 57.
Yes, ma'am. Whenever in this act, it is declared that an order of revenue officer shall be final, such expression shall be deemed to mean that no appeal lies from such order. The tribunal alone shall be competent to modify, annul, reverse any such order under the provisions of section 6. And this very same authority, my lord, at the time of my purchase in the year 2015, ಅವರೇ ಫಾರ್ಮ್ ನಂಬರ್ 11 ಮಾಡ್ಕೊಡ್ತಾರೆ, ಅವರೇ ಇದು ಎಲ್ಲ ಮಾಡ್ಕೊಡ್ತಾರೆ. That also I have filed it at the starting itself.
This request is made under what provision? Section 32, no?
Pardon, my lord?
Under what provision they made a request for,
ಆ ಪ್ರೊವಿಷನ್ ಹಾಕಿಲ್ಲ, ಅದೇನು ಹಾಕಿಲ್ಲ.
yes, government.
My lord. Initially, my lord, notice has issued, he has, petitioner has approached this honorable court, my lord. And honorable court giving direction to file a reply, opportunity given before passing an order, my lord. He has submitted relevant records based on this, my lord. Order has been passed, my lord.
Yes. ಯಾವ್ದ್ರಲ್ಲಿ?
Writ petition they have filed, my lord.
202873.
No, my lord, 202-333/24.
ಎಲ್ಲಿದೆ ಅದು?
Page number 70.
H ನಲ್ಲಿದೆ. At ink page number
73, relevant portion.
70th ಇದೆ.
73.
Yes,
70, page number 70.
operative portion.
Operative portion is at 73, madam.
Yes.
Order notice dated 21/8/24, bearing so and so, issued by respondent number 2, annexure F. The petitioner having already replied to the same, respondent number 3 is direct to consider the said reply, has also provided an opportunity of being heard to the petitioner. Petitioner shall appear before respondent without requirement of any further notice, so and so date. Respondent number is direct to pass necessary order after perusal of all documents and hearing the
N ಯಾವುದು?
my lord.
N ನಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಇದು ಫಸ್ಟ್ H ಏನ್ ಮಾಡ್ತಾರೆ, that your lordship saw page number 73. They directly said that we have already changed the entry. We are going to change the entry ಅಂತ notice ಕೊಡ್ತಾರೆ. I come up before this honorable court. Honorable court directs them to hear me and then pass the order. Next ನಲ್ಲಿ to annexure N ನಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, the municipality, sorry, the Tahsildar orders the, directs the municipality telling them that we are handing over the possession of this land to you. Without there being any proceedings at all. So that was also challenged. That is also this honorable court has granted stay. I filed the copy of that stay order, my lord. That is at in page number 95 now.
Barcode. It appears that the petitioner had invoked section 756 of the Karnataka Land Revenue Act against an order passed by the respondent number 7. And had filed a revision petition before the respondent number 3. The respondent number 3 has purportedly passed, has passed an order in exercise of its power under section 50 clause C 50 of the Act of the Land Revenue Act 1964. In either case, the petitioner is entitled to work out his remedy before the tribunal. Therefore, the question whether this writ petition is maintainable in view of an efficacious remedy available before the tribunal is kept open to be considered at an appropriate stage. The petitioner, since the petitioner contends that 3 acre 33 guntas is identified as cultivable kharab and recorded as such in the revenue records as well as the Akar Band from the year
1965.
From the year 1965. And that the respondent number 7 has now attempted to get the same declassified as B Kharab land. The further proceedings pursuant to the order passed by the respondent number 4 and 5.
Respondent number 3 and 4.
3 and 4 is state. List on. So AG is directed to accept mailed. AG is directed to accept notice of 2, 3, 4, 5, 6, 1 to 5 and 7. Show emergent notice to respondent number 6 admal idum bariri, huh?
7, Mr.
6 year town municipality.
7, Mr. Tingley can be directed to take.
Mr. Tingley.
TMC.
6 gaya.
7.
Commissioner.
In town municipality.
Tingley.
Yes.
TMC 6.
6 Shivkumar Tingley for R6. List down on date Kodi regarding maintainability of the writ petition.
Yes.
Full stop.
18.
25.
25 ಆಗ್ಬೋದು.
18th.
18.
Yes, I'll have to hear this matter.
Yes.
Mr. Chak Shetty.
Appearing for the petitioner, my lordship. The suit is already decreed, my lordship.
Emma?
The suit is decreed. I am the plaintiff before the trial court.
So
the writ petition become infructuous.
the learned counsel for the petitioner submits that the writ petition has become infructuous. Since the suit filed by the petitioner in OS number? OS number?
1.
OS
Case number 207 of 2019.
207 of
2019.
filed against the respondents.
My lordship.
Filed against the respondents hearing.
Yes, my lordship.
Filed against the respondents hearing is decreed on
31st 1, 2025.
31st
One.
January
January.
2025. Full stop. In view of the aforesaid submission, this petition is dismissed as having become infructuous. The KM Gate?
Yes.
Annexure at A order passed by the Assistant Commissioner.
Annexure A.
Yes, my lord.
A now.
12/3/2022, that was without any notice to the parents of the petitioners herein.
Now, what is the ground on which it is cancelled?
My lord, it was only some complaint was filed. Based on that complaint, my lord, it was cancelled one.
ನಿಮ್ಗೆ ಬೇರೆ ಲ್ಯಾಂಡ್ಸ್ ಎಷ್ಟಿದೆ? What is the reason on which it is cancelled?
No, reason, my lord, it was not cultivable.
What?
And another is,
Please read, sir. Please read the order at page 19.
yes, my lord. ಕ್ರಿಟಿಕಲಿ ವಿವರಿಸಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅತಿವಾಳ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 1ರ ವಿಸ್ತೀರ್ಣ 3 ಎಕರೆ 30 ಗುಂಟೆ ಭೂಮಿಯನ್ನು ವಿರ್ಶೆಟ್ಟಿ ತಂದೆ ಚೆನ್ನಪ್ಪ ಮತ್ತು ಶ್ರೀಮತಿ ಈರಮ್ಮ ಗಂಡ ವಿರ್ಶೆಟ್ಟಿ ಇವರವರು ಸದರಿ ಭೂಮಿ ಸಕ್ರಮೀಕರಣಗೊಳಿಸುವ ವೇಳೆ ತಾವು ಹೊಂದಿರುವ ಪಟ್ಟಾಭೂಮಿ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡದೆ ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ನಿಯಮ 108ರ ಅಡಿಯಲ್ಲಿ ಕೆಲವು ಜಮೀನುಗಳು ಸಕ್ರಮೀಕರಣಗೊಳಿಸಲು ಅರ್ಹರಿಲ್ಲದ ಕೃಷಿ ಯೋಗ್ಯವಿಲ್ಲದ ಭೂಮಿಯನ್ನು ತಾಲೂಕಾ ಸಮೀಕರಣ ಸಮಿತಿ ಪರಿಶೀಲನೆ ತಪ್ಪು ಅಭಿಪ್ರಾಯಕ್ಕೆ ಬಂದು ಸದರಿ ಅವರಿಗೆ 2 ಎಕರೆ ಸಕ್ರಮೀಕರಣಗೊಳಿಸಿ ಶಿಫಾರಸು ಮಾಡುವುದರಲ್ಲಿ ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಕಾಯ್ದೆ 1964ರ ಕಲಂ 94A ಉಪಕಲಂ 4ರ ವಿರುದ್ಧವಾಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ನಿಯಮಗಳು 1966ರ ಅನುದಾನಕ್ಕಾಗಿ ಅರ್ಹತೆ ನಿಯಮ 108F5 ಉಲ್ಲಂಘಿಸಿ ಸದರಿಯವರಿಗೆ ಸಕ್ರಮಗೊಳಿಸಿದ ಸಕ್ರಮೀಕರಣ ವೇಳೆ ವಿಧಿಸಿರುವ ಷರತ್ತುಗಳು ನಿಯಮ 108J ಅಡಿಯಲ್ಲಿ ವಿಧಿಸಿರುವ ಷರತ್ತುಗಳು 108J2 ಎಂದಿಗೆ 3ಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿರುವುದರಿಂದ ಮತ್ತು ತಾಲೂಕಾ ಸಕ್ರಮೀಕರಣ ಸಮಿತಿ ಶಿಫಾರಸು ಮಾಡಿದ ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ ಹೊರತಾಗಿ ಸಾಗುವಳಿಗೆ ಯೋಗ್ಯವಿಲ್ಲದ ಖರಾಬು ಭೂಮಿಯನ್ನು ಕಡತ ಸಂಖ್ಯೆ ನಂಬರ್ ರಲ್ಲಿ ದಿನಾಂಕ 19/8/2094ರ ಮೂಲಕ ಪಡೆದಿರುವ ಸಿ ಫಾರ್ಮ್ ಅನ್ನು ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ನಿಯಮ 1966 ನಿಯಮ 108K ಅಡಿಯಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸುತ್ತಾ ಇದನ್ನು ರದ್ದುಪಡಿಸುತ್ತಾ ಸದರಿ ಕಡತ ಮೂಲಕ ಸಕ್ರಮೀಕರಣಗೊಳಿಸಿದ ಭೂಮಿ ಸರ್ವೆ ನಂಬರ್ 1ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 3 ಎಕರೆ 30 ಗುಂಟೆ ಭೂಮಿಯನ್ನು ಮರಳಿ ಸರ್ಕಾರದ ವಶಕ್ಕೆ ತೆಗೆದುಕೊಂಡು ಆದೇಶಿಸಿದೆ. This order was passed. By that time, my lord, the father of the petitioners was no more. I have produced the death certificate. He died in the year 2009, my lord. And mother of the petitioner was not served with any notice. All these proceedings have taken place behind and back of the parents of the petitioners. And so far as the ROR entries are concerned, my lord, still they are continued on the name of the petitioners, my lord, as per page 28 of the repetition. And even a TT fine was also imposed, and land revenue was collected by the respondent authorities. Produced the taxpayer receipts, my lord. Until today, they are in cultivation of this. Petitioners are in cultivation of the property, my lord. Under the similar set of facts, my lord, the one more grantee who was challenged the order of the Assistant Commissioner, my lord, I have produced the Annexure G. That this honorable court, my lord, directed the said person to approach the Deputy Commissioner, my lord, by way of filing the appeal under the Karnataka land grant rules, my lord. In 1994, my lord, till 2012, more than 20 years, my lord, there was no complaint as such.
Please come to page 20.
Yes, my lord.
ಓದಿದ್ರು.
Yes. ಸಿಫಾರ್ಮ್ ಪಡೆದವರು ತಮ್ಮ ಸ್ವಂತ ಪಟ್ಟ ಭೂಮಿ ಅತಿವಾಳ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 4/2 ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 6 ಎಕರೆ 16 ಗುಂಟೆ ಮತ್ತು 5/1 ಅಲ್ಲಿ 2 ಎಕರೆ 20 ಗುಂಟೆ ಭೂಮಿ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 8 ಎಕರೆ 36 ಗುಂಟೆ ಪಟ್ಟ ಭೂಮಿಯನ್ನು ಸದರಿ ಭೂಮಿಯಲ್ಲಿ ಸಕ್ರಮೀಕರಣಕ್ಕಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಸಮಯದಲ್ಲಿ ಹೊಂದಿದ್ದು ಸದರಿ ಭೂಮಿಗಳ ಪಹಣಿ ಪತ್ರಿಕೆ 87, 88ರಿಂದ 92, 93ನೇ ಸಾಲಿಗೆ ಪಹಣಿ ಪತ್ರಿಕೆಯಿಂದ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಕಾಯ್ದೆ 1964ರ ಕಲಂ 94A4ರಂತೆ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಇಂದ ಆಗಲೇ ಹೊಂದಲ್ಪಟ್ಟಿರುವ ಜಮೀನೊಂದಿಗೆ ಆ ರೀತಿಯ ಅನುದಾನ ಮಾಡಲಾಗಿರುವ ಜಮೀನು ಡಿ ವರ್ಗದ ಜಮೀನು ಅಥವಾ ಅದಕ್ಕೆ ಸಮನಾಗಿರುವ 2 ಹೆಕ್ಟೇರ್ಗಳಿಗೆ ಮೀರತಕ್ಕದ್ದಲ್ಲ. ಆದರೆ ಸದರಿ ಇವರಿಗೆ ಸಕ್ರಮಗೊಳಿಸುವ ಮುಂಚೆ ಇವರು ಸ್ವಂತ ಪಟ್ಟಾ ಭೂಮಿ ಹೊಂದಿರುವ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ done.
Yelli, where have you mentioned that
Please.
these two lands do not belong to you or your family?
No, if the lands are belong to my lord, the type of land, D group, C group what land, and the farmer who holds a less extent of land, my lord, he can seek for regularization once he was in unauthorized cultivation of the government land. Here, my lord, it was unauthorized cultivation since a pretty long time, my lord. And when the act introduced by the year 1990 regarding regularization, by that time, my lord, who were there in cultivation, unauthorized cultivation of the government land, those persons have made the
Now,
application.
let us see what was the prescription under section 108C.
So 108K, my lord, that is amended after this grant order was passed. my lord. When the grant order was passed, that's 1994,
What was the prescription?
108, my lord.
I'm not 8C.
Yes. Yes, my lord. 108. One not 80, my lord, that is regarding notice of assessment who unauthorized cultivates the land, my lord. The regularization of unauthorized occupation of 108B nalli, as per 20th 9, 1994, that was the notification issued, my lord.
Yes.
Based upon that, the regularization was taken into effect. And so far as 108C, my lord, there was a procedure to challenge the grant order, my lord.
Yes.
That is 4 years, 4 months and all those things. Now here in this case, my lord, as per the order of the Assistant Commissioner, no appeal is being filed, my lord. And only some complaint was filed, and while passing the order, the Assistant Commissioner invokes Rule 108K, my lord.
Yes.
My lord, 108K.
Yes.
Yes, my lord.
ಎಲ್ಲಿದೆ ನಿಮ್ ಸಿ ಫಾರ್ಮ್?
Annexure B,
ಫಾರ್ಮ್
my lord.
50 ಎಲ್ಲಿದೆ?
Annexure B, my lord.
ಫಾರ್ಮ್ 50.
Annexure C, my lord. ಅದು C form issued to the parents.
Where is
of
your
the-
form 50?
C form what they have issued.
ಫಾರ್ಮ್ 50 ಎಲ್ಲಿದೆ ಸರ್?
Pardon, my lord?
Where is the form number 50 that you have filed?
That I have not enclosed, my lord. I have to get it there.
Have you mentioned in your form number 50 that you don't have any other land?
I have to go through, my lord. That information.
Please produce form number 50. Learned counsel for the petitioner is directed to place on record form number 50. Yes, list on ಯಾವ ಮಾಡ್ತೀರಿ?
After 2 weeks, my lord, I have to apply.
Yes, list on date code. Form number 50 in view of the finding of the respondents
Second
that the
respondent,
petitioner is in possession, was in possession of more than 8 acres of land when he had filed form number 50.
Please.
List on date.
Counsel for respondent. Kindly posted on day of tomorrow. Our senior is out of station.
What is this petition?
Lord, short form, Lord, questioning of Lord, annexure C and E. Lord, the property, my lord, in question belong to one Chennappa. There are two set of, my lord, claimants for that. One is, my lord, his direct LRs. The others, my lord, are, my lord, his brother's LRs.
Yaro?
One Chennappa, my lord, is the
Chandappa.
He was, my lord, the owner. He purchased that property. The
From?
petition from, my lord, the third party, my lord, in the 70s. And his name, my lord, stands from, my lord, 1972. Petitioners are, my lord, his direct LRs, his sons and, my lord, daughters. The respondents are, my lord, claiming to be wife and children of, my lord, brother of Chandappa. They say that, my lord, brothers, my lord, LRs. They say that, my lord, he had given up this property in a partition in 1989. Based on that, my lord, they are seeking for, my lord, mutation entry in their name. Lord, this man, in 2023, my lord, they file a suit for, my lord, seeking for declaration in the alternative suit for, my lord, partition. Lord, that is still pending. In 2024, my lord, the Assistant Commissioner entertains their, my lord, appeal and, my lord, enters their name. And, my lord, long-standing entry of 35 years, my lord, is set aside, my lord, in 2024. Lord, this is, my lord, the
But
grievance.
the suit is still pending. How can you get the revenue entries changed?
And the reason assigned is that, my lord, since suit is pending, it will be subject to result of suit. But so that the entry should, my lord, stand as they stood prior to, my lord, the suit.
Yes, Barcode. Ages that would accept notice for respondents, 1.
5 to 9.
Respondents, 5 to 9. Full stop. Next para. The learned counsel for the petitioners contend that the property bearing survey number
101/4.
101/4 of so-and-so village.
Bantanur. Yes.
ಯಾವ village?
Bantanur village.
Bantanur.
Bantanur.
Bantanur village.
Talikote district Vijay.
Was purchased by Sri Chandappa, their predecessor, in the year 1972. And from then on, his name was entered in the revenue records. He contends that the respondents 1 to 4 are the children of the brother of the said Chandappa, who claimed that at a partition between Chandappa and their predecessor, this aforesaid property was allotted to their share in the year 1989. Full stop. The respondents 1 to 4 had also filed a suit in OS number 152 of 2023 for declaration of their title and in the alternative for possession for partition of their share in the aforesaid property. During the pendency of the suit, the respondent number
Assistant Commissioner,
8
respondent 8
has entertained a request of the respondents 1 to 4 and had ordered mutation of and had ordered entry of their names, the revenue records, and that a revision petition filed there against was also dismissed by the respondent number 9. Full stop. Next para. Since the parties are litigating before the civil court and without there being any document to establish there was a partition between the predecessor of the petitioners and the predecessor of the respondents 1 to 4, it was not proper for the respondent number 8 to entertain a request for transfer of the revenue records to the names of the respondents 1 to 4. In that view of the matter, the mutation, in that view of the matter, the order dated 20th of September 2024 passed by the respondent number 8. And the consequent order dated so and so passed by the respondent number 9 are state.
Great. This 6, my lord, and for the petitioner. My grievance is against, my lord, annexure A. The order of revision is passed in my favor. However, my lord, there are 2 observations made, my lord, page 22, my lord.
Page
Operative portion.
22.
Yes.
Yes, please.
Revision is, my lord, allowed in my favor, my lord, regarding the form number 10. Item number 5 and 6, my lord. After the, my lord, the revision court holds that, my lord, the entries and the extents which are mentioned in my name are proper. They say that, my lord, the entitlement has to be decided by the revenue authority. And, my lord, there is one survey, my lord, of 1963-64. If that appears to be wrong, my lord, ADLR can give a proposal. My lord, this was, my lord, not called for, and this
Take
is
out notice.
Yes.
AG has directed accept notice for respondents.
4
to
only, R4.
R4.
issue emergent notice to response 1 to 3.
Yes.
IR Biradar.
Appearing for the petitioner, my lordship. In this, the petitioner is seeking to quash the order dated 29/6/2024, which is produced at Annexure J, my lordship.
Annexure J.
J. The
Yes.
petitioner father-in-law is the owner of land bearing survey number 595 old and survey number 219 new, my lordship, for the extent of 8 acre 9 guntas. In the year 1978, he sold the property in favor of Lingappa for the extent of 8 acres 9 guntas, my lordship. After the death of Lingappa, the 6th respondent filed an application for measurement and fixing of boundaries before the revenue authority. In that, the respondent 6 came to know that the extent of survey number is 9 acres 26 gunta. So he filed an application before the Tahsildar to add his name in for the excess land, my lordship. Against that, the Tahsildar made an application for the competent authority. And after that, he filed a revision petition before the 3rd respondent. In that, the revision petition, the 3rd respondent ordered that to give separate survey number to the extent of 1 acre 17 guttas and show the name of state government. In all the proceedings, petitioner was not made a party, my lordship. It is admitted fact that petitioner father-in-law was the absolute owner of the suit property.
Petitioner's father-in-law.
Father-in-law.
And he sold it to whom?
Lingappa in the year 1978, my lordship.
That is the father of the respondent number 6.
Father of the respondent.
No, what have you retained then?
My lordship, for the extent of 1 acre
Correct,
17
madam.
guntas.
See, you have sold the entire survey number.
Only 8 acre 9 gunta was sold by the.
Because you knew that it is only 8 acre 9 guntas.
My lordship, after measurement of survey, it comes that survey number 595 is for the extent of 9 acres 26.
So therefore, did you retain any land when you sold? When did you sell?
In the year 17/4/1978, my lordship.
78 ಅಲ್ಲಿ, did you retain any land? You thought it is 8 acres.
Yes, my lordship.
ನೀವು ಅನ್ಕೊಂಡಿದ್ದು 8 ಎಕರೆ ಇದೆ ಅಂತ. So you sold 8 acres.
8 acres 9.
Now it is revealed that it is 9 acres. So where did you retain the land is what I am asking you. You retain ಎಲ್ಲಿ ಮಾಡಿದ್ರಿ?
After measurement, he came to know that there is the land extent of survey number is 9 acres 26 guntas.
Correct. Whether the boundaries prevail or the survey measurements prevail.
Measurement prevail, my lordship.
Please point out. Where is the sale deed that you executed?
The sale deed is not
Source
produced,
it.
my lordship.
You produce it as annexure A.
Annexure A.
Odi. What are the boundaries of the property that you sold? East by land of Gudu by Ballari, Usman Ali, and Imam Saab, west by land of Qatal Ahmad, north by land of Vendar,
Vendor, land of.
south by land of Qasim Saab Mullah. So you also thought it is 8 acres, 9 guntas. You are under the impression that it measured 8 acres, 9 guntas.
I'm under the impression that it is 8 acre 9 guntas, my lord. After survey report, I came to know that the extent of land is 9 acres 26 guntas, my lord.
Yes,
My lordship. I'm claiming only in the respect of 1 acre 17 guntas, my lordship.
yes. And
So,
create more and create
thought-
and create trouble for the respondent number 6.
my lordship.
And create trouble for the respondent number 6.
No, my lordship. Actually,
No,
I am
you
not a
sold
party.
it in 1978. Where have you retained? Where have you retained this to any land? You thought that it's only 8 acres. So you sold 8 acres.
8 acre.
Now you say there's a survey and survey says it is 9 acres. And you want that 1 acre to be made in your name. So between you and respondent number 6, all was well. Now suddenly you want to create trouble for him.
Not trouble, my lordship. I am claiming only my rights, my lordship. Only.
Madam, did you retain any land in 1978 when you sold? ನೀವು ಮಾರಾಟ ಮಾಡಿದಾಗ did you retain any land? ಎಲ್ಲಿದೆ ಸರ್ವೆ ಅದು?
Survey report at annexer H.
Annexa? ಕಂದಾಯ ನಿರೀಕ್ಷಕರು.
D6, my lordship. It is a spot.
Annexa?
D6. ವೈದಾಪುರ ಹುಬ್ಬಳ್ಳಿಯ ಚಂದಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 200 ಮೂಲ ಟಿಪ್ಪಣಿ ಶಿಥಿಲವಾಗಿ ಲಭ್ಯವಿಲ್ಲದರಿಂದ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ಅಳತೆ ಮಾಡಿ ಟಿಪ್ಪಣಿ ಪುನರ್ ರಚಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ಲೆಕ್ಕಾಚಾರ ಮಾಡಲಾಗಿದೆ. ವಿತ್ತಲಾಯಿತು ವಿಸ್ತರಣೆ 9 ಎಕರೆ 23 ಗುಂಟೆ ಇರುವುದು ಮತ್ತು ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 219 ಮೂಲ ಆಕಾರದ ಬಂದ ದಾಖಲಾತಿಯಂತೆ 2 ಎಕರೆ 9 ಗುಂಟೆ ಇದ್ದು ವಿಸ್ತರಣೆ ವ್ಯತ್ಯಾಸ ಕಂಡು ಬಂದಿರುವುದಾಗಿ ಮತ್ತು ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಭೂಪಕರ ತಯಾರಿಸಿದ ಹೊಸ.
You get a declaration from the court. You get a declaration from the civil court.
But I was not made a party before the revenue authority, my lordship.
For what?
At least notice may be issued that.
Revenue authority for what? Revenue authority for what?
For the extent of 1 acre 17 guntas, my lordship.
It is made in the name of the respondent number 6.
No, my lordship. It is made in the name of government, my lordship.
ಎಲ್ಲಿದೆ ಅದು?
As per annexer J, my lordship.
Annexa?
J. The respondent number 3 has ordered that to give separate survey number and show the name of government, my lordship. Operative portion at page number 71.
ಓದಿ.
Point number 3. ಚಂದಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 219 ಆಕಾರ ಬಂದು ಕ್ಷೇತ್ರದ ಪ್ರಕಾರ ನಿಯಮ ಅನುಸಾರ ಹೊಸದಾಗಿ ಟಿಪ್ಪಣಿಯನ್ನು ಪುನರ ರಚಿಸುವುದು. ಸರ್ವೆ ನಂಬರ್ 215, 216 and 27 ಟಿಪ್ಪಣಿಗಳಿಗೆ ಆಕಾರ ಬಂದ ಕ್ಷೇತ್ರದಲ್ಲಿ ಹೊಂದಾಣಿಸಿ ಮಾಡುವುದು. ಸರ್ವೆ ನಂಬರ್ so and so, my lordship. As per survey number 7, survey number 209 ಪಶ್ಚಿಮ ಭಾಗದ ಕಡೆಯ ಜಮೀನ 1 ಎಕರೆ 17.
ಪೋಕಳ ಅಂದ್ರೇನು? ಖರಾಬ? ಪೋಕಳ ಅಂದ್ರೇನು?
ಖರಾಬ್.
ಪೋಕಳ ಅಂದ್ರೆ
ಕಟ್ಟಿ
ಅಲ್ಲ, ಪೋಕಳ ಅಂದ್ರೇನು?
that is not for use for
Not assist.
not assist.
ಏನ್ರಿ ಪೋಕಳ ತೆಗಿರಿ, ಕೆಟಲ್ ಡಿಕ್ಷನರಿ ತೆಗಿರಿ. ಪೋಕಳ. ಪೋಕಳ ಅಂತ ತೆಗಿರಿ, ಕೆಟಲ್ ಡಿಕ್ಷನರಿ ಇಲ್ವನ್ರಿ ಕನ್ನಡ ಟು ಇಂಗ್ಲಿಷ್. ಪೋಕಳ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಯಾರಿಗೂ? ಎಸ್ ಅರುಣ್ ಕುಮಾರ್. ಅನ್ಅಸೆಸ್ಟ್ ಇರಬೇಕು. Uncultivable, unassessed, what is that? AG has directed to accept notice for the respondents 1, 2, 3, 4.
5, my lordship. 1 to 5.
Issue notice to, emergent notice to respond number 6.
In the meanwhile, I am praying for.
Yes. Next. Abdul Muqtadir.
Hearing my lords. My lords, respondent number
Eh,
5's name has been entered in
Naresh
column.
Kulkarni. AG has directed to accept notice for response 1, 2, 3,
Four.
and 4. Mr. Naresh V. Kulkarni is directed to accept notice for respondent number 5. Since the name of respondent number 5 is entered in column number 11 of RTC without following the due process of law, comma, the same is state. List on date put.
The matter of Panchayat Raj election, my lord.
My lord,
Two
this
notices. have-
petition may be allowed because beyond 30 days already over, my lord.
It is beyond 30 days.
One meeting was adjourned because of police has informed there is
Other side, private response either,
either, my lord.
private
For
respondent.
caveat, sir, I had filed caveat on behalf of two respondents.
Yes, what is your, you have any objection?
Yes, it was one meeting on 7/1 was not conducted due to police non-availability of police and police bandobast. That was the reason. And they tried to give subsequently, they tried to give the representations also, but that was not received by.
Okay, we'll give you liberty to file a fresh representation.
Yes,
But
yes.
good. The who are these petitioners? The members,
No, my lord, they are Adhyaksha and Upadhyaksha.
the Adhyaksha and Upadhyaksha of Gram Panchayat Kollur. Kollura, Kolhara,
Kollur.
Kollur, Sedam Taluk, Kalaburagi district. I have filed this writ petition challenging a notice dated
17/12/2024, annexure
2024,
C and D.
issued by the 17/12/2024 and 22/1/2025, issued by the respondent number 2, proposing a meeting on
6/2,
first is yavattu
7/1,
7/1.
7/1.
on 7/1/2025 and
6/2/25,
and
6/2/25.
6/2/2025 to consider a motion of no confidence moved by the members of the Panchayat. Next part. The petitioners contend that they were elected as the Adhyaksha and Upadhyaksha of the Panchayat. Full stop. Panchayat at the elections held on 26/8/2023. Full stop. They contend that 11 members of the Panchayat moved a motion of no confidence by submitting an undated representation in form number 1. Full stop. The respondent number 2 issued a notice dated 17/12/2024, fixing a meeting of the members on 7/1/25. Full stop. However, the meeting could not be held on 7/1/2025. The respondent number 2 then again issued another notice dated 22/1/2025, convening a meeting of the members on 6/2/2025. Full stop. The petitioners being agreed by the notices, agreed by the notice dated 17/12/2024 and 7/1/2000 and 22, sorry. The next notice are the 22/1/25
22/1/2025.
and 22/1/25 are before this court. Next para, the learned counsel for the petitioner contends that petitioners contend that the respondent number 2 was bound to conduct the meeting on 7/1/25. And if the same was not held on the said day, the proceedings abated and the members could have initiated fresh steps by submitting a fresh application in form number 1. He contends that the respondent number 2 on his own issued another notice dated 22/1/2025, convening a meeting of the members on 6/2/2025. He therefore contends that the respondent number 2 has acted beyond his powers to convene a meeting of the members of the Panchayat. He contends that if a thing has to be done in a particular manner, if he contends that if a statute prescribes that a particular act has to be done in a particular manner, it should be done in that manner alone or not at all. He contends that since the consequence of a motion of no confidence was the removal of the petitioners, every bit of procedure prescribed under the rules of 1994 has to be strictly followed. Full stop. In this regard, he relied upon the judgment of the full bench of this court in the case of Anta Gowda, which is that Puttegowda, 19 ILR 1992, Karnataka, so and so, as well as the judgment of the full bench of this court in the case of so and so. Full stop. Per contra, the learned AGA submitted that the meeting dated 7/1/2025 could not be held since police bandobast could not be provided at the meeting, and there was a likelihood of a law and order situation. Hence, the respondent number 2 felt it appropriate to conduct a further meeting on 6/2/2025. He submits that the petitioners are not prejudiced in any manner whatsoever, and therefore the meeting could be held on 7/2/2025. The learned counsel for the private respondents also supported the contention of the learned AGA and submitted that the private respondents cannot be held responsible for a mistake committed by the respondent number 2, and that the meeting of no confidence has to be held and has to be proceeded with. Full stop. Next para. Go to the rules. The members of a panchayat are entitled to move a motion of no confidence, and is a statutory right which is recognized under section 49 of the Karnataka Panchayat Raj Act 1993. You know the act, Karnataka Panchayat Raj Act 1993.
Gram Swaraj and
Full stop.
Panchayat Raj Act.
The procedure for moving such a procedure for moving a no confidence motion is prescribed under the Karnataka Panchayat Raj bracket motion of no confidence against Adhyaksha and Upadhyaksha of Gram Panchayat bracket close rules 1994 bracket henceforth referred to as the rules of 1994. Full stop. As per the rules, a written notice of the intention to make a motion under section 49(1) of the Act shall be in form number 1 and shall be signed by not less than 1/3 of the total number of members. Full stop. 2 members submitting the form number 1 have to sign the notice and the proposed motion shall be delivered in person by the said 2 members. Full stop. Later, the assistant commissioner shall convene a meeting for the consideration of the said motion at the office of the Gram Panchayat on the date fixed by him, which shall not be later than 30 days from the date on which form number 1 is filed. Before doing so, he is bound to give to the members a notice of not less than 15 clear days. Full stop. The quorum prescribed for a meeting shall be 2/3 of the total number of members of the Gram Panchayat. Under rule 3, sub-rule 5, a meeting convened for the purpose of considering a motion of no confidence shall not for any reason inverted comma close be adjourned. Full stop. If there is no quorum within 1 hour after the time appointed for the meeting shall stand dissolved and the notice in form number 1 shall lapse. Full stop. There is no provision for the respondent number 2 to postpone the meeting that was supposed to be held on 7/1/2025. It is not known how the respondent number 2 has exercised power to convene a fresh meeting beyond the 30-day period prescribed under Rule 3(2) of the Rules 1994. Therefore, the impugned notice issued by the respondent number 2 fixing a meeting of the members on 7/2/2025, 6/2/2025, he falls foul of the rules of 1994 and hence is liable to be halted. Is liable to be quashed. Full stop. Hence, the impugned notices dated so and so issued by the respondent number 2 proposing to hold a meeting of the members of the Panchayat on 6/2/2025 to consider a motion of no confidence against the petitioners is quashed. It is however open for the private respondents or the members of the Panchayat to move a fresh representation in accordance with law. Please.
Petitioner.
Yeah.
Writ petition was challenging the order on lots,
The defendant's petition.
house.
Uh,
Page number 30 is the impugned order.
uh,
Lots suit for specific performance.
uh.
At the time of lots marking of the agreement of sale, lots objection was raised with regard to insufficiency of stamp duty. Lots matter was referred to lots jurisdictional district registrar. He lots
Oh, we thought you were the plaintiff in the suit and we allowed the writ petition on the last.
yes.
Hmm.
Lots may kindly peruse 23 lakh 10,000.
Hmm.
Lots is the amount lots which is.
So the possession was delivered.
Yes, lots. Well, I have produced the lots agreement of sale.
ಎಲ್ಲಿದೆ?
Annexure A, page number 10, 11.
ಓದಿ ಎಲ್ಲಿ ಹೇಳುತ್ತೆ?
11ನೇ ಪೇಜ್ ಫಸ್ಟ್ ಲೈನ್ ಇಂದ ಓದ್ಬಿಡ್ತೀನಿ.
ಹ್ಮ್.
ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ, ಖಾಲಿ ಜಾಗ ನಗರಸಭೆ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ, ಇದರ ಅಳತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ, ಉತ್ತರ ದಕ್ಷಿಣ ಈ ಕೆಳಗೆ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ತೋರಿಸಲಾಗಿದೆ. ಸದರಿ ಜಾಗೆಯನ್ನು ಹಾಗೂ ಅದರಲ್ಲಿ ಇರುವ ಶೆಡ್ ಸಹಿತವಾಗಿ ಸಂತೋಷ್ ತಂದೆ ನಾರಾಯಣ್ ಆದ ನಿಮಗೆ ನಾನು ಪ್ರತಿ ತಿಂಗಳಿಗೆ ರೂಪಾಯಿ 5,000 ರಂತೆ ಬಾಡಿಗೆ ಹಣ ನಿಗದಿಪಡಿಸಿ ದಿನಾಂಕ 1/2/2011 ಅನ್ವಯವಾಗುವಂತೆ ಒಟ್ಟು 10 ವರ್ಷಗಳ ಅವಧಿವರೆಗೆ ಅಂದರೆ 30/11/2021 ವರೆಗೆ ನಿಮಗೆ ಬಾಡಿಗೆಗೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಈ ದಿನ ಬಾಡಿಗೆ ಪತ್ರವನ್ನು ಸಹಿತ ನಿಮ್ಮ ಹೆಸರಿಗೆ ನೋಂದಣಿ ಮಾಡಿಸಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಬಾಡಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಭದ್ರತೆ ಠೇವಣಿ 1.5 ಲಕ್ಷ ತಮ್ಮಿಂದ ಪಡೆದಿರುತ್ತೇನೆ. ಆದರೆ ನನ್ನ ತಾಯಿ ಪಾರ್ಶ್ವ ಆಗಿದ್ದರಿಂದ so and so. So lots, here the possession is already lots given to the.
Not given under this agreement.
Yes, lots kindly.
ಇದನ್ನ ನೋಂದಣಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೇವೆ ಅಂತ ಇದೆ ನೋಡಿ ಲೀಸ್.
ಹೌದು, ಅದನ್ನು ಕೊಟ್ಟು
ಅದೇನ್ ಹೇಳ್ತಾರೆ,
ಬಾಡಿಗೆ ಮಾಡಿಕೊಂಡು
ಈ ದಿನ ಬಾಡಿಗೆ ಪತ್ರವನ್ನು ಸಹಿತ ನಿಮ್ಮ ಹೆಸರಿಗೆ ನೋಂದಣಿ ಮಾಡಿ ಕೊಟ್ಟಿರುತ್ತೇವೆ. So therefore possession is given under different agreement, not under this agreement.
But lots, it also indicates that under this agreement, lots the possession of the property was parted. Lots may kindly peruse lots section article 5E. It is lots I may be lots explanation alli where a reference of a power of attorney, alli power of attorney ಬಗ್ಗೆ there is a reference.
Then all the three have to be treated together ಅಂತ ಇರೋದು.
ಇಲ್ಲ.
ಓದು.
If 5E lots, if relating to sale of immovable property when possession is delivered or is agreed to be delivered without executing the same as conveyance lots, stamp duty payable. Explanation lots at the bottom, where a reference of a power of attorney granted separately by the seller to the purchaser in respect of the property which is subject matter of such is made in the agreement. The possession of the property is deemed to have been given for the purpose of this clause. So lots, for the purpose of this lots, even assuming that the possession was parted or given under a lots lease deed. Lots, my submission is that for the purpose of lots section article 5E, lots it is deemed to be lots the possession is given.
But it doesn't say so. You can't draw a parallel. See, this is a fiscal legislation. If it's a fiscal legislation, you cannot say because it is said in respect of power of attorney, it also applies to lease. If it is mentioned
And
the legislation that lease hold ಕೊಟ್ಟಿದ್ರೆ ಅದು apply ಆಗುತ್ತೆ ಅಂದ್ರೆ what you say is right.
That is the only, lease deed ಕೆಳಗಡೆನೆ possession ಕೊಟ್ಟಿದ್ದಾರೆ. Apart from that.
ಅಷ್ಟೇನಾ? ಅಷ್ಟೇ ತಾನೆ?
ಅಷ್ಟೇ.
ಬರ್ಕೊಳ್ಳಿ.
ತಾವು
Different,
on last date of hearing, my lord.
Correct. Thanks for changing or reminding me.
Yes.
The defendant in OS number 232, na?
House.
232 of 2023 on the file of so and so. He is before this court. 232 of so and so on the file of so and so is before this court challenging the correctness of an order dated so and so by which the court directed the plaintiff to pay deficit stamp duty of
3,300.
3,300 and 10 times the duty as penalty.
Alla, it is inclusive of what, sir?
3,300 as duty and penalty.
Yes.
On the sale agreement sought to be marked by him. Next para. A suit in OS number 252 of 2023 was filed for specific performance of an agreement of sale purportedly executed by the defendant in favor of the plaintiff. Whereinda he had agreed to sell the suit property for a total sale consideration of rupees 35 lakhs and had received a sum of rupees 20 lakhs as part of the agreed sale consideration. Full stop. The suit was contested by the defendant who denied,
No.
who denied the execution of the sale agreement. Who inter-alia denied the execution of the sale agreement. And also denied the entitlement of the plaintiff for the relief of specific performance. Based on these contentions, the trial court framed issues and set down the case for trial. Full stop. The plaintiff tried to mark the agreement of sale which was opposed by the defendant on the ground that sufficient stamp duty was not paid on the agreement, as possession was delivered to the plaintiff much prior to the execution of a sale deed, and therefore the plaintiff was bound to pay the stamp duty as provided under Article 5E1 of the Karnataka Stamp Act 1957. Next para. The plaintiff opposed the application and contended that possession was not delivered under the agreement of sale, but was delivered under a lease executed by the defendant in favor of the plaintiff, which was separately registered. Full stop. He therefore contended that the possession of the suit property was not delivered under the agreement, and hence he was not bound to pay stamp duty under Article 5E1 of the Karnataka Stamp Act 1957. Full stop. The trial court, after considering the recitals in the agreement, held that possession was not delivered under the agreement and that the plaintiff had paid rupees 200 as stamp duty on the agreement and was bound to pay rupees 300, which was this deficit stamp duty, and hence directed him to pay duty and penalty amounting to a sum of rupees 3,300. Full stop. Being agreed by the said order, this petition is filed. Next, the learned counsel for the petitioner defendant submitted that though possession was purportedly delivered to the plaintiff under a lease deed, it has to be construed as possession delivered under the agreement as the rights of a tenant, as the rights of a lessee merged with that of an agreement of sale, and hence it should be deemed that possession was delivered under the agreement of sale. The learned counsel further invited the attention of the court to explanation to Article 5 E and contended that, that if a power of attorney is executed in favor of an agreement holder, then the same is construed as delivering possession under the agreement, and stamp duty as payable under Article 5E1 is payable. He therefore submits that the same analogy has to be applied when possession is delivered under a lease deed executed prior to the agreement of sale. Next para. The Karnataka Stamp Act 1957 is a fiscal legislation, and this court cannot supplement the casus amisus to provide for an entry not provided in this Stamp Act. Full stop. A perusal of the agreement of sale shows that there was a prior lease agreement executed by the defendant in favor of the plaintiff in respect of the sued property, and possession of the sued property was delivered to the plaintiff under the said lease agreement, which was duly registered. It is thereafter that the sale agreement was executed by the defendant in favor of the plaintiff. There is no mention of the plaintiff as a defendant handing over possession of the sued property or treating that the property delivered under the lease agreement as the delivery of possession of the sued property under the agreement of sale. There is no merger of the rights of a lessee with that of an agreement holder, and hence, the claim of the defendant that the rights are merged is unacceptable. Rights of a lessee can merge only when there is a transfer of the property in the manner provided under Section 54 of the Transfer of Property Act. Full stop. It is apparent that the possession delivered to the plaintiff was not under the agreement of sale, but was under a prior lease, and hence the plaintiff was not required to pay the stamp duty as prescribed under Article 5E1 of the Stamp Act 1957. The trial court has rightly considered the same and has rightly held that the plaintiff is not liable to pay the stamp duty. It, however, held that the plaintiff is bound to pay some deficit stamp duty of ₹300 and imposed penalty of 10 times the duty, and directed the plaintiff to pay ₹3,300 as the deficit stamp duty and penalty. Full stop. Therefore, there is no error committed by the trial court in passing the impugned order warranting interference in this writ petition. Hence, writ petition is dismissed.
One more subject. Written statement ಇನ್ನೂ file ಮಾಡಿಲ್ಲ. I have said. Lords have dictated that written statement is filed and
Objected ಅಂತ.
object ಅಂತೆ.
ಅದು ಹಂಗಿದ್ರೆ don't mention that ಎಲ್ಲಿ the defendant contested the suit ಅಂತ ಇದೆಯಲ್ಲ ಅದು ತೆಗೆದುಬಿಡಿ.
Yes.
Abdul Muqtadir,
Respondent number 5's name has been entered in.
the same order ನೋಡಿ.
1 to 4, I will take
One
note.
AGA for 1 to 4, Mr. Naresh V. Kulkarni for R5. Since the petitioner has contended that the name of respondent number 5 is entered in column number 11 of the RTC without conducting any proceedings, the same is stayed. List on 11-2. RTC of survey number so-and-so village ಅಂತ ಹಾಕ್ಬಿಡಿ.
Petitioners
Kumar.
seeking writ of mandamus to consider, my lord, their representation at annexure C series and D series, whereunder through which they claimed to enter their names in the ROR pursuant to the
Yes.
grant made in the year 1978.
ಮಾಡ್ಬೋದಾ?
Hello, next week it may be taken, I will
Is
take
that-
instruction.
He is directed to accept notice for response 1 to 3, list on.
Next week, any. Yes,
Right.
ಅಲ್ಲ ಇದೆಲ್ಲ ಸುಮ್ನೆ I will not issue a mandamus.
ಎಲ್ಲ ಅದಕ್ಕೆ I will also,
Supervise the implementation of the mandamus. We can't simply
yes,
push these people to at the doors of the respondents.
no, that's why I also,
ಹೋಗಿ you people will expect other things. I will ensure that, the mandamus is implemented.
yes,
Yes.
My lord, here father of the petitioner participated in an auction of a site where he is found to be the highest bidder and deposited about 25% of the amount as per the conditions of the auction, my lord.
Hmm.
So unfortunately, in the year 2010, the father of the petitioner has died. After that, the petitioner herein came to know about the deposition of the amount and the about to be deposited balance amount, my lord. So immediately the remaining amount is deposited by the petitioner in the year 2011, my lord,
Hmm.
to respondent number 2. So after depositing the amount, entire amount, he requested orally to execute the sale deed. Despite of several oral requests, the sale deed has not been executed, my lord. So in the year 2024, he given a written representation to execute the sale deed.
Correct, madam. When was your father required to deposit the money?
My lord,
It was in 2004. When did you deposit the money balance?
2011, my lord.
After 7 years.
Yes, my lord.
ಅದೇಂಗ್ ಆಗುತ್ತೆ? This was an auction per sale, auction sale.
Yes, my lord.
How are you entitled, madam? In 2004 ಅಲ್ಲಿ ಮಾಡಿದ auction, if you are not paid the money,
But even after depositing in the 2011, my lord, after 13 years. they have
was there
given-
any letter asking you to deposit the money? Your father received a letter in
Notice,
2004.
Notice has been issued, ma'am, in
Correct,
the year,
what?
in the year 2009.
Your father died in 2010. ಮತ್ತೆ 2008 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೊಂದು ನೋಟಿಸ್ ನಿಮ್ ತಂದೆಗೆ. 2010 he died. In 2011 you deposit the money. Where is Badepur?
ring road, my lord.
Ring Road.
Ram
ಮತ್ತೆ?
Mandir ring.
What is the value today? ನೋಡಿ ಯಾರು ಕಲಬುರ್ಗಿ ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಯಾರು?
Krupa
AG
Sagar,
is directed,
Tengli.
AG is directed to accept notice for R1. Mr. Krupa, Tengli is government advocate, ಹಿಂಗೆ?
Yes,
Mr. Krupa Sagar Patil is directed to accept notice for respondent number 2.
yes.
Yes, same,
Yes.
same order. 37 is also same,
Please, my lord.
37 same. Ravi B. Patil,
Password, my lords.
ಏನ್ ಕೇಸ್ ಹೇಳಪ್ಪ?
No, my lord, I'm proxy counsel, I don't know.
Proxy counsel.
The consular petitioner held up in another court, my lord.
Take out notice issue with the AG is directed to accept notice for response 1 to 5, 1 to 6. Interim stay of the impugned order at annexure H. Annexure G and H till the next date of hearing. List on date. However, the petitioners are directed not to change the nature of the property or encumber it till the next date of hearing. Mantesh Patil.
Lords, survey number 31, 3 acre 5 guntas, Lords. There was an Tanda was situated, which is.
Pardon?
Lords, Tanda, the agriculture laborers were situated. They were residing, Lords. Subsequently, that the land itself belongs to the one Surya Nayaka. Thereafter, in the school record, government record, Lords, and the surrounding villagers in the taluk were recognized as Surya Nayaka Tanda only, because that land belongs to the Surya Nayaka. Then, my lords, by virtue of amended section 38A 2018, that was the proposal was sent. After conducting the entire proceedings, my lords, the 38A procedure was followed and published, my lords, in Form 2E as required under Rule 9B of the Land Reforms Act.
So you want your father's name to be perpetually.
Not only, my lords, these persons, the family members, the persons who are residing therein are all belongs to the same, my lords, Surya Nayaka and his relatives.
You
Now
don't want,
it
you
is,
don't
my
want
lords,
it to be named as Anjaneya Nagara.
Anjanaya Nagarant, first initially they have published it. Since all these my lords, persons who are residing, they made a objections that since it is already recognized as Surya Nayaka Tanda and the land is also situated and he has given the donated for the construction of this building. Therefore, based on that, my lords, the proceedings were conducted and finally annexure F page number 83 was published in the Gazette, my lords, as after completion of the entire proceedings under section 38A and rule line A to E, my lords.
Page number?
83, my lords, annexure F. Then this, after publication, my lords, now annexure G proceedings were conducted by the assistant commissioner. To change the name as Surya Nayak Nagara into the Sri Ram Nagarant. At page number 89, months, impugned proceedings. Last line. ಆದ್ದರಿಂದ ಚೀಟಿಯನ್ನು ಎತ್ತುವ ಮೂಲಕ ಆಯ್ಕೆಯಾಗಿರುವ ಶ್ರೀರಾಮ್ ನಗರ ಎಂಬ ಹೆಸರನ್ನು ಹೊಸ ಕಂದಾಯ ಗ್ರಾಮಕ್ಕೆ ನಾಮಕರಣ ಮಾಡಲು ಗ್ರಾಮ ಸಭೆಯಲ್ಲಿ ಅಂತಿಮವಾಗಿರುತ್ತದೆ. ನಂತರ ವಂದನಾರ್ಪಣೆಯನ್ನು ಗ್ರಾಮ ಸಭೆ ಮುಕ್ತಾಯವಾಗುತ್ತದೆ. He refers, my lords, that one the judgment of this honorable court wherein the mandamus was issued.
ಉಪಸ್ಥಿತ ಗ್ರಾಮಸ್ಥರು.
Yes, fine.
ಹೌದು.
Page 85.
ಅಲ್ಲಿ ಅವ್ರದ್ದು ಒಪಿನಿಯನ್ ಅಂತ ಏನಿಲ್ಲ. They not by lot they have selected the name. And my respectful submission is, my lords, after conducting the proceedings as required under 38A, after publication of in the Gazette.
But ಏನ್ ಮಾಡ್ತೀರ? This is the procedure adopted by all the villagers. Who are you?
But I am the resident of that area and I am one of the, my lords, idu, ಅವರು ಸೂರ್ಯನಾಯಕ ಇವರಿಂದ.
Correct, but if all the villagers say,
Not villagers, my lords. These proceedings were initiated under misconception is that at page number 80, my lords, 685 in first page, annexure G, my lords, may kindly be seen. That WP number 200-104/2024, they are referring. This writ petition is filed by one of the, my lords, legal heir. He is at page number 90, my lords. His prayer was to complete the proceedings to declare that Tanda as Samudra Tanda as a Surya Nayak Nagar Tanda and to issue the Khata as required under section 39 notes. Our prayer adittu. ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗೆ ಅದು ಡಿಕ್ಲೇರ್ ಆಗಿ ಹೋಗಿತ್ತು ಆಲ್ರೆಡಿ ಗೆಜೆಟ್ ಪಬ್ಲಿಕೇಶನ್ ಆಗಿತ್ತು ಬಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ದಿಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಪಾಸ್ಡ್ ಎನ್ ಆರ್ಡರ್ ನೌ ದೇ ಆರ್ ರಿಲೈಯಿಂಗ್ ಆನ್ ದಿಸ್ ಆರ್ಡರ್ ನೋಟ್ಸ್ ನೌ ದೇ ಬೇಸಸ್ ಒನ್ ಆಫ್ ದಿ ಬೇಸಸ್ ಫಾರ್ ಇನಿಷಿಯೇಟಿಂಗ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ದಿಸ್ ಆರ್ಡರ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಲೈಡ್ ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 91 ನಲ್ಲಿ ದೇ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಶುಡ್ ಫೈಂಡ್ ದಟ್ ದಿ ಪ್ರೇಯರ್.
ಊರ್ನವರೆಲ್ಲ ಕೇಳ್ತಾರೆ.
ಇಲ್ಲ ಊರವರಂದೆಲ್ಲ ಎಲ್ಲರೂ ಇದ್ದಾರೆ ಸರ್.
ಉಮೇಶ್ ಮತ್ತು ಕೇಮಣ್ಣ ಎಂಬುವರು ಮಾತನಾಡಿ ಸದರಿ ಕಂದಾಯ ಗ್ರಾಮಕ್ಕೆ ಈ ಮೊದಲು ಆಂಜನೇಯ ನಗರ ಎಂದು ನಾಮಕರಣವಾಗಿದ್ದನ್ನು ಮಧ್ಯಂತರ ಬದಲಾಯಿಸಿ ಸೂರ್ಯನಾಯಕ ನಗರ ಎಂದು ನಾಮಕರಣ ಮಾಡಿರುತ್ತಾರೆ ಮತ್ತು ನಮ್ಮ ಬಿ ಗಣೇಕಲ್ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಗೆ ಬರುವುದಿಲ್ಲ. ಆದರೆ ಸದರಿ ವಿಷಯದ ಕುರಿತು
ಈಗ ವಾಟ್ ಹಿ ಮಲಾಟ್ಸ್ ಮೇಡ್ ಎ ಕಂಪ್ಲೇಂಟ್ since he is one of the Lord's vice president, during his tenure only he has submitted that to declare it as Surya Nayak Nagara. Even that also I have produced it. Maybe there may be some reasons, Lord's, for extraneous reasons he has made a complaint and he stated in the. But earlier also he has signed the Lord's resolution.
Village is assess ಆಗಿದೆಯಾ?
ಹೌದಾ ಸರ್, ರೆವಿನ್ಯೂ ಅಸೆಸಬಲ್
ರೆವಿನ್ಯೂ ಅಸೆಸ್ಮೆಂಟ್ ಆಗಿದೆ. ಅಸೆಸ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ನ್ಯೂ ನೇಮ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಗಿವನ್.
ಹೌದು. ಈಗ ವಾಟ್ ಮೈ ರೆಸ್ಪೆಕ್ಟ್ಫುಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ 38A ಕೆಳಗೆ ಒಂದ್ಸಲ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪ್ರೊಸೀಜರ್ ಹ್ಯಾಸ್ ಬಿನ್ ಫಾಲೋಡ್ ಅಂಡ್ ಡಿಕ್ಲೇರ್ಡ್ ಅಂಡ್ ಗಜೆಟ್ ಇನ್ ದಿ ಗಜೆಟ್ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪಬ್ಲಿಷ್ಡ್.
38A ವಾಟ್?
ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಆಕ್ಟ್.
ಕೊಡಿ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್. 38A.
A grant of certification of ownership to an agriculture laborer, notwithstanding anything contained in this act or any other law for the time being in force, where in any village agriculture labor is ordinarily residing on dwelling house.
38A na?
House, Land Reforms Act. Ordinarily residing on dwelling house on a land not belonging to him in an unrecorded habitations like Lambani Tanda, Gollarhatti, Vaddarhatti, Kurbarhatti, Nayakarhatti, Majare Gram, Hadi Doddi, Palya, Camp Colony or any other such unrecorded habitations falling within the jurisdiction of that village on the date of commencement of the Karnataka Land Reforms Amended Act 2016, which is notified as such by the Deputy Commissioner, specifying the survey numbers and boundaries in the prescribed manner. Such dwelling house or houses along with the site thereof and land immediately apportioned thereto and necessary for its enjoyment shall on the date of such notification by the Deputy Commissioner vest absolutely in the state government, free from all encumbrances, and the agricultural laborer shall be entitled to be registered as owner thereof. For the purpose of this section, an agricultural laborer residing in a dwelling house, which is a portion of the house of the owner or which is a temporary residence on such land, shall not be regarded as ordinary residing therein. Every agricultural laborer entitled to be registered as a owner under subsection 1 may make an application to the Assistant Commissioner or any other officer authorized by the state government in the prescribed manner on or before completion of 1 year from the date of notification by the Deputy Commissioner under subsection 1, and the Assistant Commissioner or the officer authorized shall, after such inquiry as may be prescribed by order, determine the person entitled to be registered as owner and the dwelling house and the land in respect of which he is entitled to be so registered and such other matters as may be prescribed, and forward a copy of the order to the Tahsildar. The Tahsildar shall on receipt of the order passed under subsection 2 determine the manner specified subsection 1 and 2 of section 47. The amount of the landowner shall be entitled or for extinguishment of his rights in such land on payment of the amount determined. So the government by the agricultural laborer, the Tahsildar shall issue a notification to this effect and also issue certificate to such laborer specifying the extent and such other particulars as may be prescribed relating to such dwelling house and the land, and he shall registered as owner thereof. A copy of the certificate shall be forwarded.
ಎಲ್ಲಿದೆ ನೇಮಿಂಗ್ ಆಫ್ ವಿಲೇಜ್ ಬಗ್ಗೆ?
Naming of village notes, it is not referred.
Then
Only it says it has to be declared.
ಏನಂತ?
The unrecorded habitat anta.
Huh.
And it has to be vested in the government.
TAT
But
is
what
only-
the authorities have not completed,
Hmm.
your lordships kindly see that. At
Hmm.
2E olaga then only they have given the name.
Form 2E ಅದು
Form number 2E, which refers to Mallard's rule 9B. 9B is an amended rule by virtue of section 38A.
ನೈನ್ ಬಿ ಏನು ಓದಿ ಏನಾಗುತ್ತೆ?
Procedure for issuance of the notification by the Tahsildar declaring unrecorded habitations. The criteria for declaring an unrecorded habitation shall be as follows, namely, there shall be not less than a cluster of 10 houses in an unrecorded habitation. The dwelling house along with the site thereof and the land immediately apportioned thereto kept for agriculture and allied purpose use such as cattle shed, backyard, mixen to keep agricultural implements shall form part of the unrecorded habitation, and all the lands being used by the community people in the said unrecorded habitation for the purpose of road, lane, path, street, school, temple, health, clinic, borewell, open well, threshing field, mixen, or land necessary for enjoyment along with the open spaces in between thereof shall also form part of the unrecorded habitation. The concerned Tahsildar and the Assistant Director of Land Records shall conduct joint spot inspection and formulate proposals for declaring unrecorded habitations and submit the same to the Deputy Commissioner through the concerned Assistant Commissioner. The Deputy Commissioner, after due verification of the proposal submitted by the Tahsildar under Sub-Rule 2, and after satisfying himself that the unrecorded habitation meets the criteria for declaring as such, shall issue notification in Form 2E, specifying the survey number and boundaries thereto. Upon issue-
ವಿಲೇಜ್ ನಂಬರ್ ವಿಲೇಜ್ ಹೆಸರು ಇಲ್ಲ ಅಲ್ಲಿ.
ಇಲ್ಲ ವಿಲೇಜಸ್ ಅಂತ ಎಲ್ಲಿ ಈ ಪ್ರಾವಿಷನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ರೆಫರ್ ಇಲ್ಲ, ಬಟ್ ಎವ್ರಿ ಟೈಮ್ ದೇ ಇಶ್ಯೂ ಮಲಾಟ್ಸ್ 2E
ಇಟ್ಸ್ ಓನ್ಲಿ ಫಾರ್ ದ ಪರ್ಪಸ್ ಆಫ್ ಐಡೆಂಟಿಫಿಕೇಶನ್.
identification, but 2E ಒಳಗನೆ ಸೂರ್ಯನಾಯಕ ನಗರ ಅಂತ they have referred it and
Yes.
published it, Mallards. And all that apart, Mallards, now the proceedings which they have initiated and names were chosen by lot.
My lord,
ಏನಪ್ಪ ಅಂದ್ರೆ ಗ್ರಾಮ
Kindly
ಸಭೆ
see.
ನಡವಳಿ ನಡೆದಿದೆ ಏನು?
page 87. They are referred as circular, my.
Huh?
Page 87,
ಹ್ಮ್
government circular, my lord, para 2, my lord.
ಹ್ಮ್
ದಿನಾಂಕ 9/12/24 ಬೆಳಗ್ಗೆ 11 ಗಂಟೆಗೆ ಸದರಿ ಗ್ರಾಮಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ಹೊಸ ಕಂದಾಯ ಗ್ರಾಮದ ಹೆಸರಿನಲ್ಲಿ ತಕರಾರು ಕುರಿತು ಮೇಲೆ ವಿವರಿಸಿದ ಅಂಶಗಳನ್ನು ಆಧರಿಸಿ ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಬೆಂಗಳೂರು ದಿನಾಂಕ 1/3/2016 ಅನುಬಂಧದಲ್ಲಿ ಪರಿಕಲ್ಪನೆ ಅಂಶ 6 ಪರಿಶೀಲಿಸಲಾಗಿ ಸರ್ಕಾರ ಆದೇಶದಲ್ಲಿ ನಿಗದಿಪಡಿಸಿದ ಮಾನದಂಡಗಳಂತೆ ಅರ್ಹತೆ ಪಡೆಯುವ ತಾಂಡ, ಹಟ್ಟಿ, ಆಡಿ ಇತ್ಯಾದಿ ಜನವಸತಿ ಪ್ರದೇಶಗಳನ್ನು ಕಂದಾಯ ಗ್ರಾಮವಾಗಿ ಪರಿವರ್ತಿಸಲು ಅಥವಾ ಹಾಲಿ ಇರುವ ಗ್ರಾಮದ ಭಾಗವಾಗಿ ಪರಿಗಣಿಸಲು ತಾಲೂಕು ಮಟ್ಟದಲ್ಲಿ ಕೆಲಸ ಮಾಡುವ ಹಿರಿಯ ಕಂದಾಯ ಅಧಿಕಾರಿಗಳೇ ಖುದ್ದಾಗಿ ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಿದ್ಧಪಡಿಸಬೇಕು. ಸದರಿ ದಾಖಲೆ ರಹಿತ ಜನವಸತಿಯನ್ನು ಕಂದಾಯ ಗ್ರಾಮವಾಗಿ ಘೋಷಿಸಲು ಅಥವಾ ಕಂದಾಯ ಗ್ರಾಮದ ಭಾಗವಾಗಿ ಪರಿಗಣಿಸಲು ಪರಿವರ್ತನೆ ಆಗುವ ಆ ಗ್ರಾಮಗಳಿಗೆ ಯಾವ ಹೆಸರಿಡಬೇಕೆನ್ನುವುದರ ಬಗ್ಗೆ ಸ್ಥಳೀಯರ ಅಭಿಪ್ರಾಯ ಅಗತ್ಯ. ಈ ರೀತಿಯ ಅಭಿಪ್ರಾಯವನ್ನು ಪಡೆಯುವಾಗ ಆದ್ಯತೆಯ ಮೇಲೆ ಕನಿಷ್ಠ 3 ಹೆಸರುಗಳನ್ನು ಗ್ರಾಮಸ್ಥರಿಂದ ಕೇಳಿ ಪಡೆಯಬೇಕು. ಇಂತಹ ಹೆಸರುಗಳ ಪೈಕಿ ಒಂದನ್ನು ಸ್ಥಳೀಯರು ಹೇಳಿದ ಆದ್ಯತೆಯನ್ನು ಗಮನದಲ್ಲಿರಿಸಿಕೊಂಡು ಆ ಹೆಸರು ತಾಲೂಕಿನಲ್ಲಿ ಪುನರಾವರ್ತನೆ ಆಗದ ರೀತಿಯಲ್ಲಿ ಆಯ್ಕೆ ಮಾಡಬೇಕು. ಒಂದು ವೇಳೆ ತಾಂಡ, ಹಾಡಿ, ಹಟ್ಟಿ ಇತ್ಯಾದಿ ದಾಖಲೆ ರಹಿತ ಜನವಸತಿ ಪ್ರದೇಶಗಳ ನಿವಾಸಿಗಳು ಒಂದೇ ಹೆಸರು ನೀಡಲು ಸೂಚಿಸಿದಲ್ಲಿ ಅದನ್ನು ಚುನಾವಣೆಯಲ್ಲಿ ಅನುಸರಿಸುವಂತೆ ಲಾಟ್ರಿ ಎತ್ತುವ ಮೂಲಕ ಯಾವ ಜನವಸತಿ ಪ್ರದೇಶಕ್ಕೆ ಇಡಬೇಕು ನಿರ್ಧರಿಸಬಹುದು. ಹಾಗೆಯೇ ಆ ಹೆಸರನ್ನು ಹೊಸದಾಗಿ ರಚಿತವಾಗ ಕಂದಾಯ ಗ್ರಾಮದ ಹೆಸರು ಎಂದು ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಪ್ರಸ್ತಾವಿಸಬೇಕು ಎಂದು ನಿರ್ದೇಶನ ಇರುತ್ತದೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಅನುಗುಣವಾಗಿ ಶಿವಣ್ಣ ತಂದೆ ಸೂರ್ಯನಾಯಕ್ ಅವರು ದಿನಾಂಕ 25/1/23 ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಸದರಿ ಗ್ರಾಮದ ಹೆಸರಿಗೆ ಕೆಲವರು ಗ್ರಾಮಸ್ಥರಿಂದ ತಕರಾರು ಇರುವುದರಿಂದ ಸೂರ್ಯನಾಯಕ್ ತಾಂಡ ಮತ್ತು ಆಂಜನೇಯ ನಗರ ಹೊಸ ಗ್ರಾಮ ಹೆಸರುಗಳಿಗೆ ವಿವಾದಗಳು ಉಂಟಾಗಿರುವುದರಿಂದ ಸಾರ್ವಜನಿಕರ ಹಿತದೃಷ್ಟಿಯಿಂದ ಲಾಟರಿ ಚೀಟಿ ಎತ್ತುವ ಮುಖಾಂತರ ಗ್ರಾಮದ ಹೆಸರನ್ನು ತೀರ್ಮಾನಿಸಲು ನಿರ್ಧರಿಸಲಾಯಿತು. Based on 8 names they have given.
ಅಷ್ಟೇನಾ?
Even my lords, they have the video which was recorded.
ಆಯ್ತು, ಇವತ್ತೇ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು ಬೇಡ.
My respectful one submission is the proceedings in which they have conducted. my lords. Even not even.
What is in a name, Mahesh?
My lords, I am not about.
What is in a name?
ಇಲ್ಲ ಅಲ್ಲಿ ನೇಮ್ ಅಂತ the issue is not about name, my lords. The problem is your lordships kindly see the public records.
It doesn't matter. What is in a name after all? It's an unregistered, unassessed village. Now they have assessed it. They want to give it a new name. You want your ancestors' name to be used for the naming the village. The villagers do not want the village to be named after your ancestors.
That is what my one submission is. Even they have shown on video also on that day. What they are in the proceedings, which clearly only for 10 minutes it was able to record it. ಅದಾದ್ಮೇಲೆ ಏನು ರೆಕಾರ್ಡ್ ಮಾಡಕ್ ಕೊಟ್ಟಿಲ್ಲ. ಅವರು ಏನು ಅಲ್ಲಿ ಹೇಳಕ್ಕೆ ಬಿಟ್ಟಿಲ್ಲ.
ಆಯ್ತು, how many people were there at the meeting?
ಅಲ್ಲಿ ಆರ್ಡ್ಲಿ ಮಲಾಡ್ಸ್ ಒಂದು 70 ಜನ ಇದ್ರು.
ಎಷ್ಟು ಜನ ಇದ್ರು ನಿಮ್ಮೂರಲ್ಲಿ?
300 ಮೇಲೆ ಇದ್ದಾರಂತ.
ಪಂಚಾಯತ್
ಇದೆಲ್ಲದಕ್ಕಿಂತಲೂ ಪಂಚಾಯತ್ ಗ್ರಾಮ ಸಭೆಯವರೇ ಈ ನೇಮ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಗ್ರಾಮ ಸಭೆ ಮಾಡಿ ಕಳಿಸಿರೋದು. ಈಗ ಅವರೇ ಬಂದು ಅಪೋಸ್ ಮಾಡ್ತಿದ್ದಾರೆ.
ಏನ್ ಮಾಡಕ್ಕ? If all the villagers do not want your father's
if all the villagers, let them conduct fresh proceedings. I am not saying that ಆ proceedings order video ನೋಡಿದ್ರೆ they have not done.
ಆಯ್ತು, ಒಂದು
and it may be record, video record maybe.
No, for your satisfaction, we can get one more meeting done. AG is directed to accept notice for response 1 to 4. The respondent number 4 shall depute the concerned revenue inspector to conduct a meeting of the villagers to decide the name of the village. Full stop. Such meeting shall be held on
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
held on 25th February 2025. It is open for the petitioners and all villagers to participate and decide at the said meeting. The decision of the meeting shall be intimated to the court.
Proceedings may be recorded. Proceedings
ಏನ್ ಬೇಕು?
ಇಲ್ಲ, ಅಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಅದೇ ಆಗ್ತಾ ಇದೆ. ಅಲ್ಲಿ what is
27th ಏನೆಲ್ಲ MLA ಮೀಟಿಂಗು ರೆಕಾರ್ಡಿಂಗು, ಮೇಯರ್ ಮೀಟಿಂಗು ರೆಕಾರ್ಡಿಂಗ್, ಎಲ್ಲಾ ರೆಕಾರ್ಡಿಂಗ್ ಬೇಕು.
ಅಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಇದು what now authorities will act.
The kings have gone, monarchs have gone.
That is
Their
their
father is not even a ruler.
present
Not even a
situation.
chieftain. Forget chieftain ಅಲ್ಲ ನಿಮ್ಮ.
ಹೌದು.
ಮತ್ತೆ ಎಂತೆಂತೋ ರಾಜ ಮಹಾರಾಜರುಗಳೆಲ್ಲ ಬಂದು ಹೋದ್ರು. ನಿಮ್ಮ ಹೆಸರು ಎಂತದ್ದು ಶಾಶ್ವತವಾಗಿರ್ಬೇಕು ಅಂತ.
ಹೆಸರಿಂದ ಏನ್ ಇದರಲ್ಲಿ they are not that it has to be kept in their name. Only what they are already notified, finalized. ಮತ್ತೆ ಇದು unnecessary some 2 persons have started.
If all the villagers do not want your father's name to be kept to the Thanda, to the village.
ಅಲ್ಲ ನಿಜವಾಗ್ಲೂ ಹಂಗಿತ್ತಂದ್ರೆ ಹೆಸರು ತೆಗೆದು ಬೇರೆದು ಇಟ್ಬಿಡ್ಲಿ. ಯಾಕಂದ್ರೆ ಅವ್ರು ಲ್ಯಾಂಡ್ ಗಿನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, they will receive the compensation.
I have to do whatever you want. Yes, this on 27th. Anna Raya.
The writ petition nature of mandamus directing the respondent number 4 to consider the representation made by the petitioner.
But consider the end for what? Representation for what?
To
my
make
lord, to make
necessary
necessary entries, appropriate column number of ROR as per order of Deputy Commissioner Respondent number 2, page number 79 and 18, void annexure B1, my lord.
Yeah, what entry you want to be made? Annexure?
Annexure B1, page number 17, my lord. Last para, ರಾಯಚೂರು ಜಿಲ್ಲೆ ಮಾನ್ವಿ ತಾಲೂಕು ಮಾನ್ವಿ ಹೋಬಳಿ ಮಾನ್ವಿ ಗ್ರಾಮದ 95 ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಒಟ್ಟು ಎಕರೆ 12 ಎಕರೆ 36 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಭೂ ಪರಿವರ್ತಿತ ಜಮೀನ ಜಕ್ಕುಬಂದಿ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ತಹಸೀಲ್ದಾರ್ ಮಾನ್ವಿರವರಿಗೆ ಮೂಲ ಕಡಿತ ಈ ಆದೇಶದ ಪ್ರಕಾರ ಸಂಬಂಧಪಟ್ಟ ಸರ್ವೆ ನಂಬರ್ ಭೂ ಪರಿವರ್ತನೆ ಆಗಿದೆ ಎಂದು ಸಂಬಂಧಪಟ್ಟ RTCಯಲ್ಲಿ ನಮೂದಿಸತಕ್ಕದ್ದು. ಮತ್ತು
Who has passed this order? DC, no? Yes, government, why don't you make entry
Yes,
once the land is converted?
yes.
I will not issue a mandamus. You ask a Tahsildar to implement this and come and report to the
Yes.
court. Barkod AG has directed to accept notice for respondents 1 to 4. In view of the order passed by the respondent number 2, converting the land for non-agricultural use and directing the respondent number 4 to make appropriate entries in the revenue records, the learned AG is directed to secure information from the respondent number 2 as to why he has not given effect to the order passed by the respondent number. Learned AG is directed to secure information of the respondent number 4 as to why he has not given effect to the order passed by the respondent number 2. Yes, list on yavat.
2 weeks.
2 weeks ಏನಕ್ಕೆ?
ಇಲ್ಲ, ನಾ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟು ಎಂಟ್ರಿ ಮಾಡಿ.
ರಾತ್ರಿ ಮಾಡ್ಕೊಂಬರ್ಲಿ ಕೋರ್ಟಿಗೆ. Don't expect these people to come and stand at your doorstep. Yes. Manvendra Reddy.
Yes, my lord.
My lord.
But sir, learned counsel Sri Chimmalgi, he
Huh?
has entered caveat or name ತೋರಿಸಿಲ್ಲ.
ಯಾರಿಗೆ?
Chimmalgi for respondent.
ಬರ್ಕೊಳ್ಳಿ. The office is directed to show the name of Mr.
I.S. Chimmalgi.
RS.
I.
I.S. Chimmalgi as the counsel for the respondent number 5 since he has entered caveat.
You have served the
Caveat
copy-
ಯಾಕ್ರಿ put up ಆಗಿಲ್ಲ? Why caveat is
you have
not put
served
up?
the copy on the council, the junior council.
Chimmalgi ಮಾಡಿದೀರಾ?
ಮಾಡಿ.
ಲಿಸ್ಟ್ ಆನ್ ಯಾವತ್ತು ಬೇಕು?
Tuesday.
Tuesday ಅಲ್ಲ. They are forming a road in the middle of the land, my lord.
ನಾಳೆ.
Just,
ನಾಳೆ.
This tomorrow.
I will not, I am going to Prague.
Huh?
I am going to Prague.
ಇಲ್ವಾ?
ಇಬ್ರು ನಡೀರಿ.
ಇಬ್ರು ಹೋಗ್ತಿದ್ದೀರಾ? ಆಯ್ತು, when do you want it?
My lord.
ಆಯ್ತು, when do you want it? When are you coming back from Prayag?
Till status quo may be maintained. Otherwise they will form a road, my lord. My
ಅದೇನು ಇಸ್ಕೊಳ್ರಿ ಅದೇನು?
Civil suit is pending.
ಚಿಮ್ಮಲ್ಗಿ ಕರ್ಕೊಂಬಂದ್ಬಿಡಿ. It is not fair on my part.
civil suit is also paid. They
Civil
want to
suit.
pay- lay a road in the middle of the land, which is, I am growing a horse gram and you see. And by the side, eastern side, there is a road. From ancestral, they are using the road.
No, who is forming the road?
Deputy Commissioner, they have moved an application under 103 of the application, respondent number 4 and 5, my lord.
ಅಲ್ಲಿ ಚಿಮ್ಮಲ್ಗಿ ಕರ್ಕೊಂಬನ್ನಿ, ಪಾಸ್ ಓವರ್.
All right.
ಮಹಾಂತೇಶ್ ಪಾಟೀಲ್.
But these petitioners are owners of agricultural land lots. He stated that the particular survey numbers and measurement at para 3 of my writ petition, page number 6. Now, at annexure B, page number 26, without acquisition or any notice, now they are forming the road. Survey number 70 in the start.
Hmm.
70 in the start time, there is a cart road.
So is this not a village road? Not
Village road.
shown in the village map?
ಅದು ಕಾರ್ಟ್ ರೋಡ್ ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇಲ್ಲ ಅವ್ರು.
ಇಲ್ಲ. Is whether whatever road that they are forming is shown in the village map or not?
It is shown as cart road, my lords, but they are not even forming that road or improving that road.
Take out notice.
Annexure B. not there.
Annexure?
B, page number 26. ಅಲ್ಲಿ 70 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಸರ್. ದಟ್ ಓಲ್ಡ್ ರೋಡ್ ಸ್ಟಾರ್ಟ್ಸ್ ಫ್ರಮ್ 119.
70 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಕೆಳಗೆ ಲಾಸ್ಟ್ ಬಾಟಮ್ ಅಲ್ಲಿ ಮ್ಯಾಪ್ ಬಾಟಮ್.
64, 63, 65.
69 ಪಕ್ಕದಲ್ಲಿ.
66.
68, 69, 70.
70, 70.
70 ಇಂದ ಅವರು they are forming the road from 70 and then they are connecting it, my lords. Thereafter they are forming 71, 72 ಹಿಂಗ. But there is a road, cart road, if it shows 54 ಅಲ್ಲಿ. ಅದು cart road ಅಂತ even if it is considered.
ಬಟ್ ಇವರಿಗೆ 70 ದಾರಿನೇ ಇಲ್ವಾ?
ದಾರಿನೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅದು ನನ್ನದ್ರಲ್ಲಿ ಏನು ವೇನೇ ಇಲ್ಲ, ಯಾವ್ದು ಪಬ್ಲಿಕ್ ಕಾರ್ಟ್ ವೇನು ಇಲ್ಲ, ಎಂತದೂ ಇಲ್ಲ. ಬಿಕಾಸ್ ದಿಸ್ ರೋಡ್ ಸ್ಟಾರ್ಟ್ಸ್ ಫ್ರಮ್ ಇಲ್ಲಿಂದ ಸ್ವಾಮಿ 119 ಅಲ್ಲಿಂದ. ಇಲ್ಲಿ ಒಂದು ಹೊರಗಿಂದ ಕನೆಕ್ಟಿವಿಟಿ ರೋಡ್ ಇದೆ. ಆ ರೋಡಿಗೆ ಅವರು ಈಸಿ ಆಗುತ್ತೆ ಫಾರ್ಮ್ ಮಾಡೋದಕ್ಕೆ ಅಂತ ನಾವು ದೇ ಆರ್ ಡೂಯಿಂಗ್ ಇಟ್. ಇಟ್ ವಿಲ್ ಬಿ ದಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಫ್ ರೋಡ್, ದಿ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ವಿಲ್ ಬಿ ರೆಡ್ಯೂಸ್ಡ್.
You are the
ಈ 34 feet road
you
ಮಾಡ್ತಾರೆ.
are the owners of 119.
119, my 70, 69, 75.
ಅಲ್ಲ ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಮಾಡ್ತಿದ್ದಾರೆ? ಫ್ರಮ್ ದ ಹಳ್ಳ ಟು?
ಇಲ್ಲಿ ಹಳ್ಳದಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಈಗ ಅವ್ರು ನಾವು ದೇ ಆರ್ ಫಾರ್ಮಿಂಗ್ ಸರ್ವೆ ನಂಬರ್ 70 ಅಲ್ಲಿ. We are the owners of survey number 70, 69, 71, 72. 72 ದಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಬಾರ್ಡರ್ ಇದೆ ಲ್ಯಾಂಡ್.
Please take out notice.
Any date they will, if 34.
We'll fix a short date. We do not know what they have done. PWD ಬೇರೆ ಅಂತ ಹೇಳ್ತೀರಾ?
ಹೌದು.
Executive engineer PWD ಅಂದ್ರೆ it should be a major road.
Not so. Let them form. What is now the situation?
If it was a panchayat, I could understand. Here the executive engineer of PWD is undertaking this development.
Not my instructions are that earlier it was under the.
So it's a major road ಅಂತ ನಿಮ್ಗೆ ಹೇಳ್ತಿರೋದು. It's a major road that they have taken up.
ಹೌದು.
So without following the due process of law.
If they able to produce it, my lords, it was acquired somewhere or the road is situated already.
1 to 4. Is directed to secure instructions whether the proposed road in the land of the petitioners is formed in accordance with list on yavat bekri yavattu
1 week time.
1 week. 15 days. List
1
on.
week.
1 week.
If the road is formed, not nothing survives for consideration.
No, but we do not know. ನಾನು ಹೇಳಿದ್ನಲ್ಲ, if it was a panchayat development, panchayat ಆಗಿದ್ದಿದ್ರೆ I would have granted an interim order. Executive engineer of the public works department is involved.
ಇದು ಒಂದೇ ಅಲ್ಲ sir. What is now the situation is even in another 2-3 cases also. The problem is, my lords, when the fund they receive, they have to, my lords, within their time frame, they have to do it, the execute the work.
Therefore, let us see.
ಅವಾಗ ಏನಾಗುತ್ತೆ?
Date, one date ಹೇಳಿ ಯಾವ? 11th. Yes.
Not preliminary hearing, I request. Otherwise.
Yes, preliminary hearing. Arun Kumar, Mr. Raja Venkatappa Naik. HCGP to secure the tribunal records. ಬಂದಿದ್ಯಾ? AGA. Tribunal records.
ಮಲ್ಲಿಕಾರ್ಜುನ ಸಾವ್ಕಾರ್.
ನೀವು ರೆಡಿ ಇದ್ದೀರಾ?
After 2:30.
2:30.
2:30.
2:30. 42. Mantesh Patil. Sanjay M. Joshi.
One day accommodation. ಸ್ವಲ್ಪ ಓದಕ್ಕಾಗಿ.
I thought he will ask for adjournment. ನೀವೇ ಕೇಳ್ಬಿಟ್ರು.
ನಾಳೆ ಇಡ್ರಿ. ಇಲ್ಲ ಪಾಸ್ ಓವರ್. Just I will go through and make some.
Pass over.
ಆಯ್ತು ಹಾಕಿ.
tomorrow. sir, ಯಾಕಂದ್ರೆ
Hey, ನೀವು ಒಂದಾದ್ರೂ
ಇಲ್ಲ
ಮಾಡ್ರಿ.
ಸರ್ 33 ಐ ಆಮ್ ರೆಡಿ ಸರ್ that's it.
At least one,
ಅಲ್ಲ,
one
yes.
matter you please
ಇಲ್ಲ,
argue.
ಇಲ್ಲ ವ್ಯಾಸ್ ನಾ ರೆಡಿ
ಅಲ್ಲ, when you come with a mindset to take an
ಇಲ್ಲ
adjournment.
ಸರ್ ಇವತ್ತು ಈಗ ಮಾಡ್ತೀವಿ ಸರ್ ಹಂಗೇನಿಲ್ಲ ಸರ್ 33
ಮಾಡ್ರಿ,
suit.
pass over. ನೀವು ಬಂದ್ರೆ ನೀವು adjournment ಅಂತ.
Suit ಇದೆ ಸರ್ ನಾನು ಮೊನ್ನೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಡಿಸ್ಕೌಂಟ್ ಮಾಡಿದ್ರಿ ಸರ್ ತಾವೇ ಇದೆ 33 suit ಇದೆ.
No, I seen you. Whenever you come for an adjournment.
ಹೇಳಿ sir.
You don't come to argue the matter.
ಹಾಗಲ್ಲ ಸರ್.
Bhimaraya. Arun Kumar.
My lord, Bhimrai record, it may be taken day after tomorrow day.
ಏನ್ ಹೇಳಿ?
ಭೀಮರಾಯನ್ ರೆಕಾರ್ಡು ಕಳಿಸ್ತಾ ಇದಾರೆ ಇವತ್ತು.
ಅವತ್ತಿಂದ ಕಳಿಸ್ತಾನೆ ಇದ್ದಾರೆ.
ಇಲ್ಲ, ಇದು 41 ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ದಾವ ಮೇಲೆ. 43 ರೆಕಾರ್ಡ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇಟ್ ವಿಲ್ ಬರ್ತ.
What is 41 ಯಾವುದು?
ಅದು ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಪಾಸ್
ಓವರ್ ಆಗಿದೆ 230.
Yes, ma'am.
What about Bhimaraya?
Bhimrai day after tomorrow it may be.
Day after tomorrow. Learned counsel for the learned AGS again seeks time. As the last chance list on ಯಾವತ್ತು? 11th.
ಒಂದ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ
ಹಾ.
ಇವರು ವಿತೌಟ್ ನೋಟಿಸ್ ಇಲ್ಲಾರ್ದೆ ಇದು ಮಾಡ್ಯಾರ ಮೈಲಾಡ. ಇವರು ಏನು ನಮ್ಮ ಫಾದರ್ನು ಕಬ್ಜದಲ್ಲಿ ಇಲ್ಲ ಅಂತೇಳಿ ಒಂದು ಲೆಟರ್ ಬರೆದು ಕೊಟ್ಟಿದ್ದಾರೆ ಮೈಲಾಡ. ಆ ಲೆಟರೇ ಇಲ್ಲ ಮೈಲಾಡ.
ಇಲ್ಲಿ
ತಹಶೀಲ್ ಅಲ್ಲಿ
ಫೈಲೇ ಬಂದಿಲ್ವಲ್ಲ ಇನ್ನ?
ಇಲ್ಲ ಮೈಲಾಡ, ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಮೈಲಾಡ. ಅಲ್ಲಿ
ಯಾರು ಹೇಳ್ತಿದ್ದಾರೆ?
ಅಲ್ಲಿ ನಮ್ಮ ಪಾರ್ಟಿ ಹೋಗಿ ಇದು ಮಾಡಿದ್ರೆ
ರೆಕಾರ್ಡ್ ಬರ್ಲಿ ನೋಡೋಣ. List on 11th. Yes. DP Ambekar.
In this
Yes,
case,
madam.
records are directed to secure
What
government.
records?
My
Last
lord,
date of it.
entire records, honorable court directed me to secure. my lord.
Directed to secure the entire file relating proceedings. ಯಾಕೆ?
ಇಲ್ಲ, I have sent a letter, it may be taken next week. I will, otherwise,
No, if you can't get the records, why do you get the matter listed?
same day I am writing letter.
Warrant issue ಮಾಡಲ್ಲ?
ಇಲ್ಲ, ಇದು ಒಂದ್ ಸರಿ ಟೈಮ್ ಕೊಡ್ರಿ, ಒನ್ ಟೈಮ್ email.
Learned AG again seeks time.
Entry model.
Seeks time to comply the order dated 21/1/25. List on so and so interim order granted is extended to the next date.
One second.
For the
Hmm.
petition in this case, my lord. My lord, this is a simple mandamus, my lord.
Mandamus.
Yes.
For what?
I'm the owner of the land bearing survey number 4669, measuring to the extent of 4 acres 16 gunta, my lord. And my land has been submerged in one Mallaredi lake, my lord. And the respondents have initiated the land acquisition proceedings, and 4-1 was issued in the year 1998, my lord. And subsequently, my lord, the 6-1 has issued in the year 24/10/1998. And thereafter, my lord, award has been passed in the year 2000. Till now, my lord, they are not given any compensation to that effect, my lord.
Yes.
Take the instruction.
No, whoever is responsible, mister, what is this? AG is directed.
Covered under same notification, my lord, it has been allowed, my lord.
Yes, when will you get when will you pay the compensation?
1 week.
Learned AG seeks time to secure instructions as to when compensation would be paid to the petitioners. As per the award,
As per the award.
As per the award passed on 14/1/2000.
14/1/2000.
Yes, list on. ನೀವು ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿದ್ಮೇಲೆ ಅಪ್ರೂವ್ ಆಗಿದೆಯಲ್ಲ ಅವಾರ್ಡ್? 2000 ಸರ್, 25 years have gone by. 25 ವರ್ಷ ಆದ್ರೂ ಅವ್ರು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ತಿದ್ರೆ.
Verify ಮಾಡಿ.
25 years you not paid the compensation. And what is the purpose of compensation? I don't understand.
Passed under same 4-1 notification, my lord, it came to the allowed, my lord.
ಕೊಡಿ ಅದು. Anyway, see, I don't want to again send you back to that mandamus and ತಿರ್ಗಾ ಹೋಗಿ ತಿರ್ಗಾ ಅವ್ರ ಮನೆ ಹತ್ರ ನಿಂತ್ಕೊಳ್ಳು. I want to ensure that they get the compensation. ಸುಮ್ನೆ ಹೋಗಿ ತಿರ್ಗಾ ಕನ್ಸಿಡರ್ ಅಂತ ಮಾಡಿ. Yes. Otherwise, I'll take serious action against the concerned person.
Nice.
This is a violation of a constitutional mandate. Shivakumar Kallu.
Last occasion, my lord, was ordered for,
I have secured records.
Yeah, ready na?
I looked into the records, my lord.
The learned AGA submits that he has secured the records. Learned counsel for the petition seeks time to look into the records. List on. Take whatever date you want,
Yes.
but be ready on that day. Dheeraj Kumar. Santosh Kumar Mardi.
Santosh Kumar Mardi last occasion said it doesn't come under national highway. The state highway has been upgraded and the state is responsible for this and state has already filed objections. And it is squarely covered by an ownership judgment in writ petition number.
Which is that?
It has been found without acquisition, without notification. On the last occasion, my lordship has asked whether appeal has been filed. The petitioners in WP number 200963, they agreed by para number 23, that is non-granting of compensation in respect of 10 meters, they have preferred appeal minutes. There is no appeal by the government or the PWD authorities minutes. And there is no such ambiguity here in the present case also. Like already there was 10 feet or 10 meters and that was not acquired earlier to 1947.
Yes. Hey, what are your objections, government?
This is, it is upgraded and I have already.
Where are the
filed,
objections to the petition?
Page number 2, man.
15.
Ilri objections ilri.
29.
State government objections illi. What is then? Is what are your objections?
National highway comes under the national highway, madam.
National highway.
R1, and you see the objection. Page number 9, madam. Gazette notification.
Right of way that this judgment, I already taken a view that if you want to upgrade the land and
Upgrade.
huh?
Upgrade the land.
Well, upgrade adri judgment nodi. This is in respect of a state highway. Even in respect of state highway, I said if you, even the building line, if you want to widen the building line or the ROW, you are bound to pay compensation for that. Anta, that is a judgment that I have rendered already. Now, what do you want to go through that judgment?
Yes.
Both ಹೇಳ್ತೀರಾ? Learned counsel for the petitioner submits that the issue that arises for consideration, this writ petition is already decided by this court in WP number 200963 of 2018 and connected petition. So learned AGA seeks time to go through the said judgment. List on ಯಾವತ್ತು ಬೇಕು?
Great.
Yes.
Lords, the father of the petitioner, one Kallappa son of Channappa, my lords, has purchased the land from the earlier owner, my lords, one Hanumappa, through the registered sale deed dated 4/2/1966, my lords.
4/2/1966.
It's annexure B, my lords, page number 24. Then his name
Father of
was
the petitioner has purchased.
father of the petitioner. Then his name was also my lords, mutated at annexure C, page number 26, my lords. It is certified on 24/2/1968. Thereafter, his name was continued to show in the revenue records from the 1968. Till, my lords, thereafter, during the proceedings of the mutation, that has been wrongly, my lords, shown as 1 acre 20 guntas.
What is the total extent?
4 acre 20 guntas he has purchased. The total extent of the land is, my lords,
So how much is purchased by him?
4 acre 20 gunta.
ಎಲ್ಲಿದೆ ಮ್ಯೂಟೇಶನ್?
Mutation sale deed, annexure B.
ಇಲ್ಲ ಮ್ಯೂಟೇಶನ್ ಆಯ್ತು ಅಂದ್ರಲ್ಲ ಇಲ್ಲಿ.
Mutation, my lords, at annexure C, my lords, page number 25.
23.
Then his name.
23 ಇಲ್ವಲ್ರಿ ಇಲ್ಲಿ?
Huh?
Page number 23 is some
23 and 26 and ನನ್ನ typed copy mutation.
annexure C na?
Annexure C, 25 and
25.
then his name, my lords, as shown
ಎಲ್ಲಿದೆ 4 acre 20 ಗುಂಟಸ್ ಅಂತ ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿ ಕಾಲಮ್ ಅಲ್ಲಿ ಎಕರೆ ಗುಂಟೆ ಅಂತ ರಕಂ.
ಅಲ್ಲ ಮ್ಯೂಟೇಶನ್ ಇಲ್ವಾ?
ಮುಟೇಶನ್ ಇಲ್ಲ ಮೇಲೆ
ಮ್ಯೂಟೇಶನ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇಲ್ವಾ?
ಇಲ್ಲ ಮೇಲೆ
ಇಲ್ಲ, ಇದು ಮುಟೇಶನ್ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್, my lords. Annexure C.
ಎಲ್ಲಿದೆ ಎಕ್ಸ್ಟೆಂಟ್?
ಇಲ್ಲಿ ಹನುಮಪ್ಪ annexure C ದಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 25, my lords. ಎಕರೆ ಗುಂಟೆ ಅಂತಿದೆ. But however, my lords, even irrespective of that, the name was entered 4 acre 20 guntas in the revenue record of the 1968-69 ಅಲ್ಲಿ. That annexure D series, 12A1 ಅಂತಂದು.
ಎಷ್ಟಿದೆ? 4 acre 20 ಗುಂಟೆ. ಕಲ್ಲಪ್ಪ.
It is even that extent is referred in the sale deed also.
ಇವಾಗ ಯಾವಾಗ ಚೇಂಜ್ ಆಗಿದೆ?
ಅವರು subsequently in the middle, my lords, annexure E page number 43.
Annexure E.
ಇದು 4 acre 20 guntas ಅಂತ ಇವ್ರ ಹೆಸರಲ್ಲೇ the son, my lords, has got entered his name.
This is inheritance,
ಹೌದು, after the death.
ಆಮೇಲೆ
my lords, annexure G page number 57, my lords.
ನೀವು ಟೈಪಿಂಗ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದಿರೋ?
ಎಲ್ಲಿ?
annexure E ಟೈಪ್ ಕಾಪಿ ನೋಡಿ. 1 acre 20 ಗುಂಟೆ ಅಂತ ತೋರಿಸಿದಿರೋ?
ಇಲ್ಲ, ಅಲ್ಲಿ ಒಂದು ಮಿಸ್ಟೇಕ್ ಏನಾಗಿದೆ annexure E, my lords. Kindly see ಹಕ್ಕನ್ನು ಪಡೆದ ರೀತಿ ಅಂತಿದೆ. ಒರಿಜಿನಲ್ annexure E ದಲ್ಲಿ.
ಓದಿ.
ಐಟಮ್ ನಂಬರ್ 2, ಶರಣಪ್ಪ ತಂದೆ ಕಲ್ಲಪ್ಪ 4 ಎಕರೆ 20 ಗುಂಟೆ ಅಂತ ಬರೆದ್ರು. ಇಲ್ಲಿ ಅದೇ ಸರ್ವೆ ನಂಬರ್ ಇನ್ ಕಾಲಮ್ ನಂಬರ್ 3 ದಲ್ಲಿ ರೆಫರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ 1 ಎಕರೆ 20 ಗುಂಟೆ ಅಂತ ಬರೆದ್ರು.
1 acre 20 ಗುಂಟೆನಾ? 4 acre 20 ಗುಂಟೆನಾ ಅದು?
ಇದು ಅದು ಆಕ್ಚುಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ ಅಂತಾನೆ ಬರೆದ್ರು. Then, my lords, ಅದೇ ಟೈಪ್ಡ್ ಕಾಪಿನೂ ಅದೇ ರೀತಿ 1 ಎಕರೆ 20 ಗುಂಟೆ ಅಂತಾನೆ ಬರೆದ್ರು. ಆಮೇಲೆ ಇಲ್ಲಿ RTC ಅಲ್ಲಿ ಕೂಡ there was a correction, my lords. ಅದು ರಿಡ್ಯೂಸ್ ಮಾಡಿದ್ದು ಕರೆಕ್ಷನ್ ಎಲ್ಲ ಮಾಡಿದ್ರು. ದೆನ್ at annexure G, my lords, page number 57. ಅಲ್ಲಿ 1 ಎಕರೆ 24 ಗುಂಟೆ ಖರಾಬ್ ಎ ಅಂತ ತೆಗೆದು ಶರಣಪ್ಪ ಕಲ್ಲಪ್ಪ ಹೊಸ ನಂಬರಿನ ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 36 ಗುಂಟೆ ಅಂತ ಮಾಡಿದ್ರು. ಹೊಸ ಸರ್ವೆ ನಂಬರಿನ ಸ್ವಾಧೀನದಾರರು ಅವರ ವಿಸ್ತೀರ್ಣ ಅಂತ.
2 ಎಕರೆ 36 ಗುಂಟೆ.
ಹೌದು. Then, my lords, annexure H, he made a request to conduct the survey. The survey was thereafter conducted. Page number 63, my lords, annexure H2 is the copy of the ಸರ್ವೆ ರಿಪೋರ್ಟ್. ಇಲ್ಲಿ ಬ್ಲಾಕ್ ನಂಬರ್ 2 ಶರಣಪ್ಪ ತಂದೆ ಕಲ್ಲಪ್ಪ ಅಂತ ಬಂದ್ರು. ಬ್ಲಾಕ್ ನಂಬರ್ 3ದಲ್ಲಿ 4 ಎಕರೆ 20 ಗುಂಟೆ ಶರಣಪ್ಪ ತಂದೆ ಕಲ್ಲಪ್ಪ ಇವರ ಅನುಭವದಲ್ಲಿರುತ್ತದೆ. Thereafter, it is continued. The annexure K, annexure J, which is the 12 survey number 12 totally measures 18 acre 24 guntas. In that 18 acre 24 guntas, 8 acre 12 gunta was utilized for the forming the canal. Then annexure K proceedings came to be initiated. In that, my lords, your lordships would find at item number 3, serial number 3. 4 ಎಕರೆ 20 ಗುಂಟೆ 2 ಗುಂಟೆ ಕರಾವ್ ಅಂತ ಬರ್ದು ನೋಡ್ಸ್ 4 ಎಕರೆ 18 ಗುಂಟಾಸ್ ವಾಸ್ ಶೋನ್. ಕಾಲಮ್ ನಂಬರ್ 9 ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 36 ಗುಂಟೆ ಅಂತ ಮಾಡಿದ್ರು. ತಹಸೀಲ್ದಾರರು ಸಿಂಧನೂರು ಇವರು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಗಣಿಸಿ ಪಹಣಿ ತಿದ್ದುಪಡಿ ಮಾಡಿದರೆ ಆಕಾರ ಬಂದ್ ವಿಸ್ತೀರ್ಣಕ್ಕೂ ಹಾಗೂ ಪಹಣಿ ವಿಸ್ತೀರ್ಣಕ್ಕೂ ತಾಳೆಯಾಗುತ್ತಿದ್ದರಿಂದ ಈ ಕೆಳಗಿನಂತ ಆದೇಶ. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಿಂಧನೂರು ತಾಲೂಕಿನ ಗುಡ್ದೂರ್ ಹೋಬಳಿ ಪಾರಾಪುರ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 12ರಲ್ಲಿ ಈ ಕೆಳಗಿನ ಕೋಷ್ಟಕದಲ್ಲಿ ತೋರಿಸಿರುವಂತೆ ಪಹಣಿ ತಿದ್ದುಪಡಿ ಮಾಡಲು ಆದೇಶಿಸಿದೆ.
ಟೋಟಲ್ ಇರೋದೇ 18 ಎಕರೆ 20 ಗುಂಟೆ.
18 ಎಕರೆ 24 ಗುಂಟೆ ಇದೆ ಲ್ಯಾಂಡ್.
ಟೋಟಲ್ ಇರೋದು 18 ಎಕರೆ 20
ಹೌದು ಹೌದು
24 ಗುಂಟೆ.
ಹೌದು
ಅದೇ 4 ಗುಂಟೆ ಖರಾಬು
ಹೌದು
ಅಲ್ವಾ? ಸೊ ಹೌ ಕ್ಯಾನ್ ದಿ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಬಿಕಮ್ 19 acres?
19 ಎಕರ್ ಅಂತ ಇಲ್ಲಿ ಕೆಳಗಡೆ ಬರುತ್ತೆ. ಅದು they conducted the proceedings and the land which he holds is 4 acre 20 guntas in possession. Now he is in possession. Even if it is not considered all the purchasers and land extent utilized for the canal and everything, and there will be no reduction in the land. 8 acre 8 12 guntas correct ಆಗಿ ಉಳಿತಾ ಇದೆ. 18 ಎಕರೆಯಲ್ಲಿ
8 acres 32 guntas is TBP ಕಾಲುವೆ.
ಹೌದು. That is in particularly survey number 12/1. There are two.
So how can the total extent go beyond 18 acres 20 guntas? Not ಕೇಳ್ತಿರೋದು. Survey number 12 measures 18 acres.
They did not refer. What they say is only ಆಕಾರ ಬಂದ್ ಪ್ರಕಾರ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಇದು ಅವರೇ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಂಡಕ್ಟ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಹಾಕಿರೋದು.
Correct. Land cannot, ಅದೇನ್ ರಬ್ಬರ್ ಬ್ಯಾಂಡ್ ತರ
18 acre
land is not elastic.
ಅದೇ 18 acre 24 guntas ಒರಿಜಿನಲ್ RTC ಇವನ್ ಫ್ರಮ್ ದಿ ಕಾಸರಪಾಣಿ 1954.
ಇನ್ನು 16 ಗುಂಟೆ ಎಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ? 16 ಅಲ್ಲ 20 ಗುಂಟೆ ಎಲ್ಲಿ? ಇನ್ನು 20 ಗುಂಟೆ ಎಲ್ಲೋಯ್ತು? ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಡನ್ ಇಸ್ ಪ್ರಪೋರ್ಷನ್ ಕಡಿಮೆ ಮಾಡಿದ್ರು ಎಲ್ಲಾರ್ದು, so that it comes within the final tally of 19 acres.
Next page,
Next
18
page ಅಲ್ಲಿ
acre
ಮಾಡಿರೋದು
24 gunta.
ಮಾಡಿರೋದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ
19 acres ಕರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ 18 acre 20 guntas ಅಂತ ಕರೆಕ್ಟ್ ಆಗಿ ಟ್ಯಾಲಿ ಮಾಡಿದ್ರು. ಅದರಲ್ಲಿ 2 ಎಕರೆ 16 ಗುಂಟೆ ನಂದು ತೋರಿಸಿದ್ರು. 1 ಎಕರೆ ಉಳಿದು ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಏನಿತ್ತು ಅದು that has been not shown.
Ultimately it has to be brought within that total 18 acres.
ಅಲ್ಲ even the revenue records which your lordships your 2023 ಅಷ್ಟು ಸರ್ವೆ ನಂಬರ್ ಹಿಡಿದ್ರೆ
ಈಗ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ we do not know whether you purchased first. ನಿಮ್ಮ ವೆಂಡರ್ ಹತ್ರ I don't know what is the total extent of land that your vendor possessed. For example, if you are the first purchaser, then the next purchaser will have to go. First purchaser ಮಾಡಿದ್ರೆ then if your vendor has got 10 acres, if you have purchased 8 acres, then the vendor cannot sell another 8 acres.
ಹೌದು.
So the next purchaser can only claim 2 acres.
I understood. My submission is even if it is taken the lands which are now holding at present, if it is tallied with the sale deeds, it will come to not 18 acre 24 guntas 4 gunta corrupts
ನೀವೇ ತೋರಿಸಿ ಹೌ ಅಂತ.
ಈಗ RTC ಇಲ್ಲೇ ಇದ್ದಾವೆ.
ಕೊಡಿ. This is a which year? RTC is a which year?
ಪ್ರೆಸೆಂಟ್ ಇಯರ್
24, 25.
ಹೌದು.
ಲೆಕ್ಕ ಮಾಡಿ ಹೇಳಿ.
ಈಗ 12/1 ಅಂತ ಇದೆ ಫಸ್ಟ್ ಪ್ರಾಪರ್ಟಿ.
Page number 2/2, 1/2.
12/1 ಅಂತ ಈಗ 12 ಸರ್ವೆ ನಂಬರ್.
Please wait. 1/1, 2/2.
12/1 ಅಲ್ಲಿ
ಬಂದೆ. Yes.
ಈ 12/1 ಅಲ್ಲಿ ಮಲಾಡ್ಸ್ 8 ಎಕರೆ 12 ಗುಂಟಾಸ್ ಕೆನಾಲ್, 4 ಎಕರೆ 20 ಗುಂಟಾ ಶರಣಪ್ಪ ಪಿಟಿಷನರ್, 1 ಎಕರ್ 6 ಗುಂಟಾ ಮಹಬೂಬ್ ಸಾಬ್, ಟೋಟಲ್ 13 ಎಕರ್ 38 ಗುಂಟಾಸ್. 12/2 ದಲ್ಲಿ 2 ಎಕರ್ 13 ಗುಂಟಾಸ್ ನರಸಪ್ಪ, 12/3 ದಲ್ಲಿ 2 ಎಕರ್ 13 ಗುಂಟಾಸ್ ಸಿದ್ದಪ್ಪ. ಟೋಟಲ್ ಕಮ್ಸ್ ಟು 4 ಎಕರ್ 24 ಗುಂಟಾಸ್. 13 ಎಕರ್ 38 ಪ್ಲಸ್ 4 ಎಕರ್ 24 ಇದ್ರೆ 18 ಎಕರ್ 22 ಗುಂಟಾಸ್.
ಇಲ್ಲಿ ಇನ್ಯಾರಿದ್ದಾರೆ ಇಲ್ಲಿ?
ಮತ್ತೆ ಯಾರು ಇಲ್ಲ, ಈಗಿರೋದಿಷ್ಟೇ ಪಾಣಿ.
ಅಲ್ಲ, TBP ಕಾಲುವೆ 2 ಇದೆ ನೋಡಿ, 8 acre 32 ಗುಂಟಾಸ್ ಅಂಡ್ 1 acre 22 ಗುಂಟಾಸ್.
ಅಲ್ಲ, ಅದು 1 ಎಕರ್ 22 ಗುಂಟಾಸ್ ಅಂತ ಇವನ್ ಮಲಾಟ್ಸ್ ಕ್ಯಾಲ್ಕುಲೇಟೆಡ್.
10 acre 14 gunta total. TBP.
2 ಇದೆ, 2 item ಇದೆ.
Yes, mal. Both includes 10 acre 14 gunta. TBP canal.
ಅದೆರಡು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ ಯಾರ್ದು ಕಡಿಮೆ ಮಾಡ್ಬೇಕು?
ಲೆಟ್ ದೆಮ್ ಮಲಾಟ್ಸ್ ಕಂಡಕ್ಟ್ ಸರ್ವೆ.
ಲಾಸ್ಟ್ ಕಮ್ ಫಸ್ಟ್ ಗೋ ಹೋಗ್ತಾರೆ.
ನಮ್ದು ಸೇಲ್ ಡೀಡ್ ಫಸ್ಟ್ ಅಂತ ಬರುತ್ತೆ, 1968 ಸೇಲ್ ಡೀಡ್ ನಂದು. And my name is standing 4 acre 20.
Yes, Mr. Have you seen this? ಇದು
Yes, mal.
ನೀವು ಇಂಡೀಕರಣ ಮಾಡ್ತಿರಲ್ಲ, ಇಂಡೀಕರಣ ಮಾಡುವಾಗ ಹೂ ಇಸ್ ದ ಫಸ್ಟ್ ಪರ್ಚೇಸರ್? ಅವ್ರಿಗೆ ಅಷ್ಟು ಲಗತ್ತು ಮಾಡಿ ಮಿಕ್ಕಿದ್ದನ್ನ ನೀವು ಕಳೀತಾ ಹೋಗ್ಬೇಕು. ಯು ಕೆನಾಟ್ ಪ್ರೊಪೋರ್ಷನಲಿ ರೆಡ್ಯೂಸ್. ಪ್ರೊಪೋರ್ಷನಲಿ ನೀವ್ ಹೆಂಗ್ ರೆಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ? First the person who's purchased first will be saved. The person who's purchased next will have to make way. Alva?
Yes, mal.
When will you get instructions?
Next week it may be taken. I will call officer.
And you have not made all these persons as parties. Mahbub Saab, Siddhappa.
ಅಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದ what they have not done.
Correct, but then
Now they will suffer, my lord.
Not what my instructions are that. ಈಗ ಯಾರು ಬೇರೆ ಯಾರ್ದು ಲ್ಯಾಂಡ್ ನೋಟ್ಸ್ ವಿ ಆರ್ ನಾಟ್ ಟೇಕಿಂಗ್ ಎನಿಬಡೀಸ್ ಲ್ಯಾಂಡ್. ಪೊಸೆಷನ್ ಅಲ್ಲಿ ಯಾರ್ದು ಅವ್ರಿಗಿದ್ದಾರೆ ಏನು ಡಿಸ್ಟರ್ಬ್ ಆಗಿಲ್ಲ. ಆ ಕೆನಾಲ್ ಹೋದ್ಮ ಬೈಫರ್ಕೇಟ್ ಆದ್ಮಾಗ 12/2 ಅಂತ ಒಂದಾಯ್ತು, 12/1 ಅಂತ ಆಯ್ತು. ಯಾರ ಪೊಸೆಷನ್ ಅಲ್ಲೂ ಯಾರಿಗೂ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇಲ್ಲ. ಈಗ ಇವ್ರದ್ದು ಅವ್ರು ತಗೊಂಡ್ರು, ಅವ್ರದ್ದು ಇವ್ರು ತಗೊಂಡ್ರು ಅಂತ. ಓನ್ಲಿ ದಿಸ್ ರೆಕಾರ್ಡ್ ಈಸ್ ನಾಟ್ ನೌ ಮೇಕಿಂಗ್ ಲಾಟ್ ಆಫ್ ಡಿಫಿಕಲ್ಟ್ ಫಾರ್ ದೆಮ್ ಟು.
maybe there's some extra land in this survey number, we do not know.
ಅದನ್ನು ಇರ್ಬೋದು. ಅದಕ್ಕೆ ಅವ್ರು ಏನಂತಾರ, ಈ ಸರ್ವೆ ಮಾಡಿ ಯಾರ್ದವ್ರಿಗೆ ಎಷ್ಟೆಷ್ಟು ಬರ್ತತೆ ಅಷ್ಟು ಸರ ಕೊಟ್ರು, ದೆನ್ ಸರ್ವೆ ಕಂಡಕ್ಟ್ ಮಾಡಿ ಅಟ್ಲೀಸ್ಟ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು ಸಾಕು.
Direction may be given to my lord, resurvey entire land.
After hearing the learned counsel for the petitioner and the learned AGA, this court is of the opinion that in order to put an end to the dispute, the concerned ADLR should conduct a survey and identify the extent of land owned by the persons found in Annexure A, which is the order passed by the Assistant Commissioner Link Sugut, dated 23/7/2018, 18. Stop.
ಇಲ್ಲ, ಆಸ್ ಪರ್ 2024 RTC
ಎಲ್ಲಿದೆ?
ನಾನು ಕೊಟ್ಟಿದ್ದೇನೆ. ಮತ್ತೆ ಇದು ಅಂದ್ರೆ ದೇ ವಿಲ್ ಗೋ ಬೈ ದಿಸ್ ನೋಟ್ಸ್ ಬಿಕಾಸ್ ಆಲ್ರೆಡಿ ದೇರ್ ಇಸ್ ಎನ್ ಮಿಸ್ಟೇಕ್ ಡನ್ ಬೈ ದಮ್. ಆ 12 bar 1,
ಅಲ್ಲಲ್ಲ.
12 bar 2 ದಲ್ಲಿ ಯಾರ್ಯಾರು
ಒಂದೇ
ಇದ್ದಾರೆ?
ಒಂದ್ ನಿಮಿಷ ಏನಾಯ್ತು? Identify the extent of land owned by respective owners in survey number 12 bar
12 bar 1, 12 bar 2.
and 12 bar 1 and 12 bar 2 of Parapura village.
ಇಲ್ಲ ಗುಡ್
Huh?
ಗುಡ್ದೂರು ಪರಾಪುರ್
Parapur village, Gudadur
ಹೋಬಳಿ.
Gudadur taluks, Sindhanur taluk. And submitted report to this court. List on
2 weeks.
on date.
Yes.
Shankar Mama. We'll take it up at 2:30.
ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್
ಯಾಕೆ?
ಸ್ವಲ್ಪ ಓದ್ಕೋಬೇಕಾಗಿತ್ತು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್ ಇನ್ನೂ ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಟೈಮ್ ತೊಗೊಂಡಿರಲ್ಲ ಅಷ್ಟೇ. ನಾನು ಸ್ವಲ್ಪ ಓದ್ಕೋಬೇಕು. ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಆಗ ಫಾರ್ 4 days ಟುಡೇ.
On counsel for the petitioner seeks time. List on
11.
Shivanand Patil,
18.
Cinema 50. Deepak Bharat. Ready ಇದೀರಾ? Ready? Both of you ready?
Yes.
ಏನ್ ಹೇಳ್ರಿ? ಫೈಲ್ ಇಲ್ವಾ?
Order 20, I am the plaintiff, my lord. There was a dispute that I had purchased 3 acres of some land from him. He started a dispute telling that I have encroached 4 acres, 4 guntas out of that. Because that land had gone for widening of the road up, which in fact in his land, remaining portion of the land it had gone. After the completion of evidence, I made an application under order 26.
What
for
is the suit
appointment
for?
of a-
Suit is for
local
what?
inspection.
Suit is for what?
Suit is for declaration and injunction. So declaration and injunction. Just to identify that 4 acres which was been taken up by for road widening, whether it falls in his portion of the land or in my portion of the land. Last to select a commissioner appoint ಮಾಡಿ, because that will settle, that will set a trust apart.
But the suit is para 5 million. May I take to para 5 of plaint, page 12,
Para 5.
page 12. Lord, the
Ah.
fact of the case that during the month of middle of week of the August 2016 stated that plaintiff has encroached the part of the land to an extent of 4 guntas towards west of the land. Lord, written statement, my lord, para 18, page 18, page para 6, my lord. The contents of the para 5 of the plaint are false and they are therefore specifically denied by defendant. It is false to aware the defendant made any allegation against the plaintiff that he encroached the extent of 4 guntas in the land. The averments made by plaintiff specifically in para are vague and proved to false. One breath, the plaintiff asserts that the encroachment is towards east and land, and another breath, the encroachment towards west. Lord, we have not stated that, Lord, we have only defense taken by the defendant before the trial court is that, Lord, I am not the sole owner. The trial court comes to the conclusion that, my lord, if at all they have the sale deed, the declaration suit is there. If they prove their title, their suit will be decreed. There is no question of encroachment identification. We have not stated anywhere in the written statement asserting 4 guntas. Only defense taken by the defendant is that, my lord, I am not a absolute owner, and other brothers and sisters are also there. My undivided shares have been got sale executed by the plaintiff. That is the only defense I have taken in written statement. There is no question of, and trial court comes to the conclusion, my lord, if the declaration suit is proved by the documents, there is no question of appointing the commissioner.
Yes. Plaintiff and defendant are brothers.
No,
No, they are.
No, purchaser,
They-
owner and the purchaser.
Then issue number 3 ಏನಿದು, whether the defendant proves the suit property, self-acquired property of Tipanna, and there was no partition.
Although defense naga, after having sold it without seeking for any counter relief, They just take a statement, they make a statement that we are, in fact, I was not the only owner of the said land.
Chief, evidence have you traced this particular, the evidence, have you suggested that the defendant is claiming?
Yeah, ಹೌದು
ಇಲ್ಲಿ
ಅದು
ಹೇಳಿದ್ದೀರಾ?
ತಂದಿದ್ದೀನಿ, ಈಗ just xerox ಮಾಡಿಸಿದ್ದೀನಿ.
Sure.
ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಹ್ಮ್.
4 ಗುಂಟ ಜಮೀನು ಅಗಲೀಕರಣದಲ್ಲಿ ಹೋಗುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿದಾರನು ಸರ್ಕಾರವನ್ನು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡ ಜಮೀನು ಬಿಟ್ಟು ನಂತರ ನನ್ನ ತಂದೆ 3 ಎಕರೆ 2 ಗುಂಟ ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 3 ಎಕರೆ 2 ಗುಂಟ ಜಮೀನಲ್ಲಿ ವಾದ್ಯವ ಕಬ್ಜದಲ್ಲಿ ಇದ್ದಾನೆ ಎಂದರೆ ಸಾಕ್ಷಿ ಅವನು ಜಮೀನು ಎಷ್ಟು ಇದೆ ಅದರಲ್ಲೇ ಅವನು ಇದ್ದಾನೆ, ನನ್ನ ಜಮೀನು ಎಷ್ಟಿದೆ ನಾವು ಇದ್ದೇವೆ ಎಂದು ನುಡಿತಾರೆ. ಮಾರಾಟ ಮಾಡಿದ ಪೂರ್ವದಲ್ಲಿ ದಾವಾ ಜಮೀನು ಒಟ್ಟು 9 ಎಕರೆ ಗುಂಟ. And he has tried to thereafter elicit by taking the NC. Fact is that the dispute is actually with regards to 4 acre which was acquired by the state, which was taken over by the state. ಯಾವ portion ದಲ್ಲಿ ಬರುತ್ತೆ ಅದು ಅಷ್ಟೇ. So to decide how to where, who is in which extent as possession.
ಬಟ್ ಇಲ್ಲಿ ಹೇಳಿದ್ರಲ್ಲ,
ಹ?
ಅವತ್ತಿನಿಂದ ಇಲ್ಲಿಯವರೆಗೂ ವಾದಿಯು ಸದರಿ ಜಮೀನ್ದಲ್ಲಿ ಕಬ್ಜಾದಲ್ಲಿ ಇದ್ದಾನೆ ಎಂದರೆ ಸರಿ.
ಸರಿ.
ಅಂದ್ರೆ 2 ಎಕರೆ 3 ಎಕರೆ 2 ಗುಂಟೆ.
2 ಗುಂಟೆ ಅಂತ ನಮ್ದು ಸಜೆಷನ್. ನಾವ್ ಏನ್ ಹೇಳ್ತೀವಿ, he is alleging that I have encroached 4 guntas and he is creating disturbance. So for that purpose, I asked for a commissioner. I am in position up to this point. Whether does it amount to encroachment or
Is in respect of what is the area in respect of the suit is?
pardon?
3 acres.
What is the area?
3 acres 2 guntas.
Then he also admits that.
Yes. Alla, he admits here ಜಮೀನಲ್ಲಿ ಕಬ್ಜಾ ಇದ್ದಾನೆ. He is not very specific. ಅವನು ಎಷ್ಟು ಕಬ್ಜದಲ್ಲಿ ಇದ್ದಾನೆ, ಅವ ಎಷ್ಟು ಮಾರಾಟ ಮಾಡಿದ
ಹೇಳ್ತಾರೆ ನೋಡ್ರಿ, 2000ನೇ ಇಸ್ವಿಯಲ್ಲಿ ನನ್ನ ತಂದೆ ವಾದಿಗೆ 3 ಎಕರೆ 2 ಗುಂಟೆ ಜಮೀನು ಮಾರಾಟ ಮಾಡಿದ್ದಾನೆ. ಅವತ್ತಿನಿಂದ ಇಲ್ಲಿಯವರೆಗೂ ವಾದಿಯು ಸದರಿ ಜಮೀನ್ದಲ್ಲಿ ಕಬ್ಜಾದಲ್ಲಿ ಇದ್ದಾನೆ ಎಂದರೆ ಸರಿ.
So on this basis, my lord, injunction will have to be issued.
Correct.
ಹೌದಾ? That then now where is the question of interference ಅಂತ ಬರ್ತದೆ?
ಯಾವುದು?
Because my allegation is that he is trying to interfere in that 4 guntas that I hold it in 3 acres 2 guntas.
He says 3 acre 2 guntas you are in possession.
ಅಷ್ಟು ಬರೋದು ಮತ್ತೆ that can be written down specifically that he admits that 3 acre 2 guntas ಇದಾರಪ್ಪ ಅಂತಂದ್ರೆ
ನಾವು ವಾದಿಗೆ 4 ಗುಂಟೆ ಜಮೀನನ್ನು ಒತ್ತುವರಿ ಮಾಡಿರುತ್ತೀರಿ ಎಂದು ತಕರಾರು ಮಾಡುತ್ತಿದ್ದೇವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಈಗ ವಾದಿ ಎಷ್ಟು ಜಮೀನಲ್ಲಿ ಇದ್ದಾರೋ ಅಷ್ಟು ಜಮೀನಿಗೆ ಘೋಷಣೆ ಮಾಡಿದರೆ ನಮ್ಮದು ಯಾವುದೇ ತಕರಾರು ಇಲ್ಲ. ಎಂದ್ರೆ ಸಾಕ್ಷಿ ಅವನು ಜಮೀನು ಎಷ್ಟು ಇದೆ ಅಷ್ಟರಲ್ಲಿ ಅವನು ಕಬ್ಜಾ ಇದ್ದರೆ ನಮಗೇನು ತೊಂದರೆ.
I have read that part of this thing that makes out a full case, full-fledged case for in favor of plaintiff. Then again he is interfering ಅಂತ
Not be necessary ಅಂತ.
that is recorded upon.
ಮಸ್ಕಿ ಅಂತ ತಾಲೂಕು, now it is ಮಸ್ಕಿ.
ಯಾವುದು?
ಸಿಂಧನೂರು ಬೈಫರ್ಕೇಟ್ ಈ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರಿ.
ಸಿಂಧನೂರು ಅಂತ ಇರೋದು ಮಸ್ಕಿ ಅಂತ.
Lord's kindly,
Yeah.
one matter is settled out of the court, my lord. I am withdrawing the writ petition tomorrow, my lord.
Good.
Obliged.
Rakesh Kini.
My lord, I have given NOC in this matter, my lord. Mr. Sridhar had argued this matter. His name has not been shown in the cause list, my lord. But I have informed his junior. He said he will be present today.
My lord, this is a matter
But
where
why
my
is-
lord has,
No, but why is it coming before having deposited? They're not for,
my lord, may I
This
submit,
matter
my
has
lord?
been confirmed by the Supreme Court, my lord.
This
My lord,
order
there
is
was a-
confirmed in Supreme Court.
Yes, it's confirmed in Supreme Court.
No, the order passed by this court is confirmed.
This court is confirmed by Supreme Court. That's what I am.
My lord, may I submit, my lord? I am appearing for the contesting respondent, my lord.
Hmm.
My lord, there was the election proceedings were stayed by lord in the above writ petition by filing a writ petition, my lord, by the election officer and the, my lord, State Government Employees Association. Wherein, my lord was pleased to dismiss the writ petition by imposing cost and further directed that, my lord, election shall be conducted before 26/12/2024, my lord. Lordships get at, my lord.
Yes.
Yes, my lord. Then, my lord, the petitioners here in the writ petition have approached the Honorable Supreme Court, my lord, by filing SLP 31,074 of 24.
31,000?
31,074 of 2024, my lord. My lord, on the basis of filing of the SLP, my lord, they have not conducted the election before 26/12/2024. My lord, as directed by my lord. And now the cost was deposited. Then, my lord, before the Honorable Supreme Court, my lord, on 2/1/25, 2/1/25, my lord, they have submitted that they will not press the matter, but cost may be waived, my lord, is their submission. Then, my lord, one para in the order of the Supreme Court, my lord, may read. We
Yes.
have perused the impugned judgment and also considered the basis for imposing the cost while upholding the order passed by the trial court ordering fresh election. No interference is found to be justified. The special leave petition is accordingly dismissed. Since the High Court had fixed 27/12/24 for holding the election and the said date has already gone by, Mr. Goswami submits that the petitioner will immediately hold the fresh election, but another date may have to be fixed. To obtain fresh date for holding election, petitioner is granted liberty to move the High Court for this limited extent only. My lord, with these my lord, observations, Honorable Supreme Court was dismissed the SLP, my lord. Ultimately, my lord, since the elections were not conducted before 27/11/12/2024, my lord, they were given liberty to move, my lord, for fixing a fresh date of elections.
Yes.
My lord, neither they have paid the cost, my lord, nor they have moved, my lord, for holding the fresh date, my lord, for conducting election. The specific, my lord, reason for directing, my lord, to hold the election before 27/12/2024 was that, my lord, election to the state unit was scheduled on 27/12/2024, my lord.
No, correct, but the mandate of this election officer, if it's already over,
My lord,
the fresh election officer has to be appointed.
my lord, that is not over, my lord. My lord, he
No,
continues.
correct. Now the election officer, who's the petition number 2,
Please, my lord.
he cannot be directed to hold elections because his mandate is over.
No, my lord. My lord, he in fact issues a fresh calendar of events also, my lord, ignoring the direction of this honorable court.
ಯಾವತ್ತಿಗೆ?
Our on 7/1/25, my lord, after dismissal of SLP,
Ah,
without obtaining the leave of this honorable court for fixing a fresh date, my lord, they issues a calendar of events, my lord, fixing the date of election as 10/1/25
ah.
by, my lord, issuing a fresh calendar of events. My lord, that is impermissible, my lord. Because, my lord, they should have conducted the election where it has stopped, my lord, on the earlier occasion.
Yes.
But conveniently, they issues a fresh calendar of events. And, my
Now,
lord,
who is this Mr. K. Sridhar? Our appear ಆಗ್ತಿಲ್ಲ.
He is not here today, my lord. His name was not shown in the
Office is
cause list.
directed to show the name of Mr. K. Sridhar as the advocate for the petitioner, instead of Mr. Rakesh Kini, who has given no objection. List on, when do you want it? Tomorrow? List tomorrow. Please tell Sridhar that I'm going to issue a bailable warrant if the cost is not paid.
I'll inform, my lord, but I'm told that he's in United States, my lord. His junior told me that.
And, my lord, our difficulty is, my lord, still, my lord, elections were not conducted, my lord.
Yes, list tomorrow. Yes, next. Kailash Gopi.
My lord, in this matter, I appeal for the respondent. My
Ah.
lord, we filed this application for modification of the order, my lord. The practical, actually it is in the interest of the petitioner only. The difficulty is that, my lord, clause 4 of the operative portion of the order, my lord. I have produced the order along with the application at page number 12. My lord, as per the direction issued by this honorable court, you have completed the inquiry within 1 month instead of 3 months, my lord. But after the investigation, if the respondents are of the opinion that the petitioner has not shared confidential information of the department with others for financial gain, the respondents shall take immediate action to restore the orders of voluntary retirement that was accepted on 23/3/2024 with effect from 31/7/2024. My lord, his application for voluntary retirement was accepted by us on 23/3/2024, but subsequently it was withdrawn as there was a complaint and enquiry was pending. This honorable court directed us to complete the enquiry within 3 months, and we completed it, and he held not guilty, my lord. And the retirement, my lord, with effect from 31/7/2024, he worked till today, still he is working, my lord. We are awaiting the modification of this order to release him, my lord, to settle the pensionary benefits.
But what is the finding of the investigation?
Investigation finding, I have produced at document number 2, my lord. It is found that he is not guilty. At page number 15, it is there, my lord.
No, what have you paid salary to him?
Yes. Salary is paid from 3/7/24 also.
No,
31/7.
From 23/3/2024.
Yes.
Till 31/7/24, have you paid him the salary?
Yes, sir. Salary is paid. And in fact, one increment is also issued to him.
So therefore, please tell us what will be the effective date when his voluntary retirement could be
Still
accepted?
he is on duty. We may be directed to release him within
On
2 months.
28th February.
My lord, they told me that they require 2 months to settle the pension
Right,
papers.
madam, the VR will be accepted with effect from 28th February,
My lord, 31st March, my lord.
31st March.
Yes, my lord.
Who
Because they
appears for
need
the other
to-
side?
I
Kailash.
informed the other side also, actually.
Kailash Gopi.
Yes, I informed him that it is listed today.
Barcode, the learned counsel for the respondent submits that pursuant to the order passed by this court, an investigation was conducted and it was found that the petitioner was not guilty of sharing confidential information of the department with others for financial gain. She therefore submits that there is no impediment to accept the voluntary retirement of the petitioner. However, she contends that the petitioner has worked from 23/3/2024 till date
Yes.
and has drawn salary. And therefore, this court may reconsider the date of the voluntary retirement coming into effect.
Yes, please.
Full stop. The learned counsel for the petitioner is absent. And so list tomorrow.
Tomorrow I
Yes,
have
madam.
an important matter meeting.
You're not coming to Kalaburagi, madam. It's on VC.
No, I need to attend the court in Bangalore.
Right? Bunny VC iltane. You can sit wherever you want and you can attend.
Please.
Not in the car, but don't sit in the car and attend. Yes.
Not at all.
Hmm. Sundar
Lord.
Raman.
Yes.
Bill number 3, I appear, my lord.
Ah,
This, your lordships will recollect, this case was the matter, my lord, where Mr. Dhananjay had appeared. Your lordships had heard this matter quite extensively. Now, in the application of production of documents was rejected by the trial court. Your lordships may not have held at para 17 that the
17.
2 episodes of 2012, page 46,
Just a moment. Page 46.
in the case of non-plaintiffs were categorically mentioned in the plaint, statements made by defendants in 2 episodes, 712 and 2412, which purportedly defame the plaintiff and their project. It is for defendants to establish information published or telecast was based on documents. Then, this is important. The perusal of 2 episodes shows that the defendants have substantially relied upon the Karnataka Legislative House Committee report, the framework agreement proceedings before the court, and the statements of agreed landowners. It therefore goes without saying that the defendants piece various circumstances. Now, my lord, the Karnataka Legislative House Committee report came into existence in the year 2016. There's no reference, my lord, of the House Committee report at all
Yes.
in the episode.
So this is the objectionable thing. Which is the other one?
This is the first issue, my lord, and your lordship then say that these documents can thereafter be produced later on. At para 23, my lord then holds that this document they wanted to place, but this document was not in existence at the time, my lord, when the defamatory statements were made in the episodes in 2012.
Para 23, is it?
Para 23.
Yes.
Therefore, my lord, one does not flow from the other because you can only rely on documents which were in existence prior to the episode being published, not
Yes,
documents which came into existence after.
In para 23, what is mentioned?
Para 23, not allowed in part, impugn order passed by someone is not disturbed. However, liberty is reserved to defendants to renew the request or call for documents from the plaintiffs after they enter the witness box and produce the documents. Now, this document, Lord, we had entirely pointed out to your lordships and to the trial court, was not in existence at that point in time. Therefore, they cannot
Correct.
now try to prove it. No, but the point, Lord, is your lordship.
Whatever documents that they intend to relay or call for from you,
Yes.
let them enter the witness box and thereafter let the court decide whether those documents have to be summoned or
But then
not.
this finding comes in the way because your lordships now hold that though this was in existence prior to that date.
Suppose if you remove this words Karnataka Legislative Committee report in page
Then
number
their
20.
application had to be dismissed because their application was the production of that document.
Oh, no. Is who appears for the other side?
No, my lord, notice has to be issued.
Issue notice to the respondent. Mr. What's his name? Dhananjaya.
Dhananjay, KV Dhananjay.
Mr. KV Dhananjay is directed to accept notice for the respondent. List on date.
Great.
Yes. ಮಾಡಿದಾರಾ? Needful is off, the learned counsel for the petitioner submits that needful is done. Office is there to check and verify. Proceed to issue notice to respondent number 6 to 11. It is made clear that if the process paid is not in order, the petition shall stand dismissed against the respondent number 6 to 11, and consequently, the petition shall stand dismissed in its entirety. Yes.
Interim order may kindly extend, my lord.
Interim order granted is extended to the next date. ಮಾಡಿದಾರಾ?
Counsel for the petitioner is out of.
You appeared, somebody else appeared in the morning.
But he has informed
No.
within 2 days, sir. Please,
Somebody else appeared in the morning ಅಲ್ಲ ಯಾರು?
file ಬಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. Appear ಆಗಿರ್ ಗೊತ್ತಿಲ್ಲ.
1 week time is granted to do the needful.
Please.
Annaraya.
Last kind permission.
ಕೊಡಿ.
The affidavit.
First,
Order
Serve the
sheet.
copy on the other side. Already
Order sheet.
for the government.
Yes, Annaraya.
Senior counsel is attending.
first, 9:30.
ಯಾರು?
Mahaleshwar.
ಎಲ್ಲಿದ್ದಾರೆ? Where is it?
Yes, yes.
What was the order of the last street? Learned additional government advocate as the learned counsel for respond for directed to place on record the original file
Yes, my lord.
taking the no confidence motion against Adhyaksha and Upadhyaksha, so on. So, Padashetty, learned counsel for interdependence. Learned counsel is directed to file an affidavit of the PDO indicating the manner of service of notice to the petitioners. Shall give description attempts made by him to serve the petitioners. Yes. The affidavit now filed.
PDO Rampur, my lord. That is
Copy
connected.
ಕೊಟ್ಟಿದ್ದೀರಾ?
9 yes,
Copy.
sir, the copy, morning itself. Yes.
ಈಗ ಅವ್ರು ಕೊಡಕತ್ತಾರ. ಯಾವಾಗ? ಅದನ್ನ ಇದು ಓದಾಕತ್ತಾರ, ನಮ್ಮ ಅಂಕರು. ಅದಕ್ಕೆ ಅಷ್ಟ ಆಗೋಲ್ಲ.
Oh. ಭಾರಿ ಸಾಹಸ ಮಾಡಿದ್ದೀರಾ.
ಇದು ಕೇಸ್ ಮಾಡಿ. ಫಸ್ಟ್
ಸಾರಿ. Yes.
ಇದೇ ಎಕ್ಸ್ರೇ ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ?
It's not by mistake, it is a screenshot ನಲ್ಲಿ ಬಂದು.
ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಎಲ್ಲೂ ಕಾಣ್ತಾ ಇಲ್ವಲ್ಲ?
ಫೋಟೋದಲ್ಲಿ that's but it's not. But they have taken the
ಅಲ್ಲ, where is the complaint lodged before the police?
complaint, my lords, that is a request letter in page 15. 19/12/2024.
Yes,
ಇಲ್ಲ, kindly pass over.
Yes.
Yes.
ಯಾರು ಚಿಮ್ಮಲ್ ಕಟ್ಟಿನ?
Mamdapur is taking instruction. Yes, we have served copy and he has taken instruction from that law.
ಎಲ್ಲ ಬರ್ತಾರೆ ಅಂದ್ರಲ್ಲ?
ಹೇಳಿದ್ರು ಬೆಳಿಗ್ಗೆ.
So.
With your lordship's leave, this is a tenant's writ petition. Your lordship, the
ಮುಂದೆ
The-
ಹೇಳ್ರಿ.
petitioner's father by name Bhimashappa has been granted occupancy rights in respect of land survey number 109,
129.
measuring 4 acres,
109.
19 guntas.
109,
Measuring?
4 acre 19 guntas.
In village Bevanur of Indi Taluka. Your lordship, annexure A. Page number 46A, that is application for grant of occupancy rights for number 7 was submitted by the forefather Bhimsha Avashpa in the year 28/6/1976. Thereafter, your lordship, annexure B, in 40 page 46, English 46A, tenancy rights granted in favor of Bhimshappa Avashappa dated 29/8/77.
Annexure B.
Thereafter, grant of certificate of registration under section 55 of the Land Reforms Act was granted in favor of Bhimashappa, annexure C, page 51 to 57. And thereafter, your lordship, annexure D, page 65, Kannada, there your lordship, the mutation was granted
by Tahsildar dated 4/1/88. Then your lordship, annexure E, that is page number 72-101, contained a record of rights in the name of Bhimshappa Avashappa from the year 1989 up to 1997-98. And after 98, your lordship, the mutation was effected in the name of the petitioners who are the sons of late Bhimashappa, and it continued. All of a sudden, your lordship, it is surprise to note that in 2013, your lordship,
Karnataka Sarkar.
in the record of rights, it is deleted the name of the petitioners and inserted as name of the government of Karnataka without any affording opportunity to the petitioners.
Where is this MR H57 bar 2013-14?
13-14.
In column number 10 of the
Column number
RTC
10.
for the year 2013-14, there is an entry called MR H57 bar 2013-14. ಏನದು? Page number 104 ಬನ್ನಿ.
104 page.
Yes, your lordship. And page number 104, and further I have brought typed English as well as issued
Ala.
endorsement.
Column number
issued-
10 ಗೆ ಬನ್ನಿ, 104,
Still
column number 10.
$104,
Column number 10 ಅಲ್ಲಿ
25/2/2014.
ಅಲ್ಲ ಸರ್, ಕಾಲಮ್ ನಂಬರ್ 10 ಅಲ್ಲಿ MR
Yes, your lordship.
H57 bar 2013-14. What is that MR entry? ಅವ್ರಿಗೆ ಹೇಳ್ರಿ ದೇಶ್ಮುಖ್ ಅವ್ರೆ.
Yes.
Yes.
ನೋಡ್ತಾ ಇರ್ತೀನಿ.
Your lordship, page number 105, column number 2.
10 ಇರುತ್ತೆ ಸರ್, 10.
Huh.
10.
Page number 104C, then 105. Column number 2.
ಮುಟೇಶನ್ ಎಂಟ್ರಿ
Mutation entry ಅಂತ.
MR ಎಂಟ್ರಿ ಅಂದ್ರ ಮುಟೇಶನ್ ಎಂಟ್ರಿ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ವಾಟ್ ಯು ಸೇ ಅಬೌಟ್ ದ್ಯಾಟ್ ಅಂತ ಹೇಳ್ತಾರ.
ಕಾಲಮ್ ನಂಬರ್ 10 ಅಲ್ಲಿ
104 page.
104. One moment.
Column number 10. sir.
Acha. Yes, your lordship.
ಇಲ್ಲಿದೆ.
ಕಾಲಮ್ ನಂಬರ್ 10 ಅಲ್ಲಿ MR H57.
ಮುಟೇಶನ್ ಎಂಟ್ರಿ.
Yes, your lordship.
What is that?
Page number 103, mutation. Other rights liability, a condition is implemented as do not possess till 15 years. There is a difference in construction.
ಏನು ಬರ್ದಿದಾರ? ಎಲ್ಲಿದೆ ಇದು?
MR
MR
57 oblique 2013. Sale of
ಮಾತ್ರ 103
5/2014.
ಐತ್ ಪೇಜ್ ನಂಬರ್ 103. ಕಾಲಮ್ ನಂಬರ್ 10. MR H57 bar 2013-12. ಸೇಲ್ 5/3/24 ಅಂತ.
ಅದು ಏನದು ಅಂತ ಕೇಳ್ತಿರೋದು. What is that MR?
Type of possession. MR ಅಂದ್ರೆ mutation.
How was this government's name entered in column number 9?
My lord, because land tribunal order has been passed, it has not intimated to Assistant Commissioner by the petitioner, my lord. Land tribunal order has passed and allotted 4 acre 19 guntas to the petitioner fathers, my lord. It has not intimated to the Assistant Commissioner by the petitioner. That's
ಫಾರಂ ನಂಬರ್ 10 ಇಶ್ಯೂ ಆಗಿದೆ, ಖಾತೆ ಆಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ. How did you change their name? How did you delete their name and enter the name of state government?
Annexure G is there.
I have filed additional document with issue of endorsement by the Tahsildar Indi, page 121, annexure G. Additional document.
Page 121.
Yes,
121, Annexure G, additional document, Your Honor.
Yes.
Annexure G, page 121. The endorsement issued by the Tahsildar, it also does not disclose anything, Your Lordship.
Yes, Mr. How was this government name entered in column number 9?
My lord,
Ah,
kindly go through our statement of objections.
well, ಇದನ್ನು annexure H ಓದಿ ಇದು ಏನು? What is this
Then
annexure?
page 122 English translation I have produced, Your Lordship. Page 122.
Please read this 123.
Then
You don't proceed.
Annexure H, Your Lordship, the notification duly typed, page number 123,
ಓದಿ.
page 123.
ಓದಿ.
Yes. Regarding to mention the rights in column number 9, page 125, English translation.
ಕನ್ನಡ.
Yes. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಇಂಡಿ ಭೂ ನ್ಯಾಯಮಂಡಳಿಯಲ್ಲಿ ಉಲ್ಲೇಖ ಆದೇಶದಲ್ಲಿ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 1961 ಮತ್ತು ತಿದ್ದುಪಡಿ ಕಾಯ್ದೆ 1974 ಕಲಂ 63 ಪ್ರಕಾರ ಮೇಲಿನ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಒಟ್ಟು ಕ್ಷೇತ್ರ 174 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನನ್ನು ಭೂ ರೈತರಿಗೆ ಹಂಚುವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಸರ್ಕಾರಕ್ಕೆ ಕಬ್ಜಾ ಮಾಡಿಕೊಳ್ಳಲು ತೀರ್ಮಾನಿಸಿ ಆದೇಶಿಸಲಾಗಿತ್ತು. ಸದರಿ ಆದೇಶಕ್ಕೆ ಬಾಧ್ಯತೆಯಾದ ಶ್ರೀ ವಿಠ್ಠಲ ಶಿವಪ್ಪ ರಾಠೋಡ್, ಶ್ರೀ ಮಾಧು ಜಯರಾಮ್ ರಾಠೋಡ್, ಶಾಕಿನ್ ಇಂಡಿ ರವರು ಭೂ ಸುಧಾರಣಾ ಮೇಲ್ಕಾಣೆ ಪ್ರಾಧಿಕಾರ ಬಿಜಾಪುರ ಇವರದಲ್ಲಿ ಕ್ರಮವಾಗಿ ಸರ್ವೆ ನಂಬರು ದಾವಾ ದಾಖಲಿಸಿ ಸದರಿ ಪ್ರಾಧಿಕಾರ ಮೇಲ್ಕೆನದಾರ ಮನವಿಯನ್ನು ತಳ್ಳಿ ಹಾಕಿ 22/2/88 ವಜಾಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿತ್ತು. ಸದರಿ ಆದೇಶಕ್ಕೆ ಬಾಧಿತವಾದ ಅರ್ಜಿದಾರರು ಪುನಃ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರು ಇವರಲ್ಲಿ ಪೆಟಿಷನ್ ನಂಬರ್ ಈ ರೀತಿಯಾಗಿ ಹಾಕಿ ರೆಡ್ಡಿ ಸಲ್ಲಿಸಿದ ವಿಚಾರಣೆ ಅರ್ಜಿಯನ್ನು ಅಂಗೀಕರಿಸಿ ಮರು ವಿಚಾರಣೆಗೆ ಭೂ ನ್ಯಾಯಮಂಡಳಿಗೆ ನಿರ್ದೇಶಿಸಿದ ಪ್ರಯುಕ್ತ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಇಂಡಿಯಾ ದಿನಾಂಕ 13/7/77 ಮಾಡಿರುವ ಆದೇಶ ಕ್ರಮಬದ್ಧವಾಗಿ ಎಂದು 4/1/2002 ಪುನಃ ಕ್ಷೇತ್ರ 174 ಎಕರೆ 14 ಗುಂಟೆ ನೇತನ್ನು ಸರ್ಕಾರಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲು ತೀರ್ಮಾನಿಸಿ ಆದೇಶಿಸಲಾಯಿತು. ಸದರಿ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಆದೇಶಕ್ಕೆ ಬಾಧಿತರಾದ ಮತ್ತೆ ಅರ್ಜಿದಾರರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಬೆಂಗಳೂರು ಇವರಲ್ಲಿ ರಿಟ್ ಅರ್ಜಿಯನ್ನು ದಾವಾ ದಾಖಲಿಸಿದಲ್ಲಿ ಸದರಿ ಅರ್ಜಿದಾರ ರಿಟ್ ಪಿಟಿಷನ್ ಅರ್ಜಿಯಲ್ಲಿ ಯಾವುದೇ ಸರಿಯಾದ ಸಕಾರಣಗಳನ್ನು ಕಾನೂನುಬದ್ಧ ಹೇಳಿಕೆಗಳು ಇರೋದಿಲ್ಲದರಿಂದ ರಿಟ್ ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳಿಸಿ ಆದೇಶಿಸಿದೆ. ಆದಾಗ ಕೂಡ ಅರ್ಜಿದಾರರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಸಂಚಾರಿ ಪೀಠ ಗುಲ್ಬರ್ಗ ಇದರಲ್ಲಿ ಮರು ವಿಚಾರಣೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸುವುದು ವಜಾಗೊಳಿಸಿ ತಂದು ಸ್ವೀಕರಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಆದರೆ ಸದರಿ ಅರ್ಜಿದಾರರು ಎಲ್ಲ ಆದೇಶಗಳು ಕುರಿತು ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಭಾರತ ಸರ್ಕಾರ ನವದೆಹಲಿ ಇವರಲ್ಲಿ SLP ನಂಬರು 19,555/50C of 2009 ಮೇಲ್ಬರೆಯನ್ನು ಸಲ್ಲಿಸುವುದನ್ನು ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರು ಮತ್ತು ಗುಲ್ಬರ್ಗ ಇವರ ಆದೇಶಗಳನ್ನು ಎತ್ತಿ ಹಿಡಿದು ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಅರ್ಜಿದಾರ ಅರ್ಜಿಯನ್ನು ದಿನಾಂಕ 1ರಂದು ವಜಾಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಸದರಿ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಭಾರತ ಸರ್ಕಾರ ನವದೆಹಲಿ ಇವರಲ್ಲಿ ಮಾಡಿರುವ ಆದೇಶದಂತೆ ಸೂಕ್ತ ಕ್ರಮಕ್ಕೆ ಗೊಳ್ಳಲು ಮಾನ್ಯ ಸರ್ಕಾರದ ಕಾರ್ಯದರ್ಶಿಗಳು ಕಾನೂನು ಕೋಶ ರೆಸಿಡೆಂಟ್ ಕಮಿಷನರ್ ನವದೆಹಲಿ ಇವರು ಉಲ್ಲೇಖಿಸಿ ನಿರ್ದೇಶನ ನೀಡುತ್ತದೆ. ಮುಂದುವರೆದು ಸದರಿ ಇಂಡಿ ಬ್ಲಾಕ್ ಸರ್ವೆ ನಂಬರ್ 743ರಲ್ಲಿ 49 ಎಕರೆ 23 ಎಕರೆ ಜಮೀನನ್ನು ಚಂದು ಲಮಾಣಿ ಹಾಗೂ ನಾತು ಚಂದು ಲಮಾಣಿ ಇವರ ನಮೂನೆ ನಂಬರ್ 7ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ಪ್ರಯುಕ್ತ ಸದರಿಯವರಿಗೆ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಇಂಡಿ ಇವರ ಅನೇಕ TLC ನಂಬರ್ ದಿನಾಂಕ 5/3/76 ಪ್ರಕಾರ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 61 ತಿದ್ದುಪಡಿ 74ನೇ ಗಣಿ ಹಕ್ಕು ನೀಡಿ ಆದೇಶಿಸಿದ ಪ್ರಯುಕ್ತ ವಿಶೇಷ ತಹಸೀಲ್ದಾರ್ ಇಂದಿರೆ ಅವರು ದಿನಾಂಕ 28/8/80 ಫಾರ್ಮ್ ನಂಬರ್ 10 ನೀಡಿರುತ್ತಾರೆ. ಕಾರಣ ಸದರಿ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಭಾರತ ಸರ್ಕಾರ ನವದೆಹಲಿ ಇವರಲ್ಲಿ ಮಾಡಿರುವ ಆದೇಶದಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಬೆಂಗಳೂರು ಹಾಗೂ ಗುಲ್ಬರ್ಗ ಇವರ ಆದೇಶ ಮತ್ತು ನೆದರನ್ನು ಸದರಿ ಜಮೀನುಗಳನ್ನು ಉಲ್ಲೇಖಿ 3 ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಆದೇಶದಂತೆ ಸರ್ಕಾರದ ಕಬ್ಜೆ ಪಡೆದುಕೊಳ್ಳುವ ಸಲುವಾಗಿ ಈ ಕೆಳಗಿನಂತೆ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. ಭೂ ನ್ಯಾಯಮಂಡಳಿ ND7 ಆದೇಶದಂತೆ ಇಂಡಿ ಬ್ಲಾಕ್ 743ರಲ್ಲಿ 49 ಎಕರೆ 23 ಗುಂಟೆ ನೆಲವನ್ನು ಹೊರತುಪಡಿಸಿ ಕ್ಷೇತ್ರ 174 ಎಕರೆ 14 ಗುಂಟೆ ಸರ್ಕಾರ ಹಕ್ಕು ದಾಖಲಿಸಲು ತಹಸೀಲ್ದಾರ್ ಇವರಿಗೆ ಸೂಚಿಸಲಾಗಿದೆ. ಎರಡನೇದು ಸೆಕೆಂಡ್ ಕಾಲಮ್ ಪರ್ಟೇನ್ಸ್ ಟು ಅಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಇಂಡಿ ಗ್ರಾಮದ ಬ್ಲಾಕ್ ನಂಬರು 884, 691, ಸಾತ್ಪುರ್ ಬ್ಲಾಕ್ನಲ್ಲಿ 320, ವಸಂತನಗರ್ ಇಂಡಿ ಬ್ಲಾಕ್ 743, ಇಂಗಳಗಿ ಬ್ಲಾಕ್ 235 ಮತ್ತು ಚಿಕ್ಕಬೇವನೂರು ಬ್ಲಾಕ್ ಸರ್ವೆ ನಂಬರ್ 109ಗಳನ್ನು ಒಟ್ಟು ಕ್ಷೇತ್ರ 174 ಎಕರೆ 14 ಕ್ಷೇತ್ರದ ಪಹಣಿ ಕಾಲಂ 9ರಲ್ಲಿ ಸರ್ಕಾರ ಎಂದು ಹಕ್ಕು ದಾಖಲಿಸಲು ಸೂಚಿಸಿದೆ. My humble submission is this, your lordship, that whereas the case of this petitioner's father is concerned, under weaker section, special policy of the government of Karnataka which prevailed, those persons who are landless and weaker section people should be granted the landed property by way of grant of occupancy rights. So therefore, this petitioner's father was granted occupancy rights under that particular scheme. Besides, he was also cultivating the said landed property. So therefore, in view of any provisions coming into operation,
Yes.
my humble submission is this, your lordship.
Kindly see para 2 of my statement of objection, my lord.
For objection, direct to objection or.
ಇಲ್ರಿ ಇಲ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿರ್ಗ ಅದನ್ನ ನೋಡಿ. ಇಲ್ಲಿಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲೆಲ್ಲ ಇದನ್ನ ನೋಡಿ ನೋಡಿ. ಎಲ್ಲ ಮತ್ತೆ
I think they have. My lord, my contention that land tribunal has granted occupancy right this petitioner fathers, my lord. At the time of proceeding, they have not intimated to the assistant commissioner.
now we have been intimated.
Yes, my lord. In our contentions also.
Will
said-
restore the names?
Yes, my-
Direct the restoration. Barcode.
Your lordship, may I cite one decision?
I am allowing your petition.
Hello.
Barcode. The petitioner contents, petitioner's content. Sorry, petitioners have called in question what is annexure F?
Annex ref.
Annexure A, your lordship,
F.
page number 41. Filing of form number 7 dated 28/6/76.
ಏನೋ ಕೇಳಿದ್ರೆ ಅವ್ರೇನೋ ಹೇಳ್ತಾರೆ.
ಏನ್ರಿ sir?
The petitioners
yeah.
have called in question
Page
order
number
dated
104C.
25/2/2014, passed with respondent number 3, directing the entry of the name of the state government in column number 9 and 12, the RTC, hearing survey number 109 of which village?
Chickbevanur village.
Chikkabevlur.
No, it's of so village. Chikkabevnur. ಇಂಡಿ ಇದು ಯಾವ ಊರು?
Indi ತಾಲೂಕು.
ಇಂಡಿ ತಾಲೂಕು. ಗುಲ್ಬರ್ಗ ಡಿಸ್ಟ್ರಿಕ್ಟಾ?
ಇಲ್ಲ ವಿಜಯಪುರ.
Vijaypur district. Next para. The petitioners contend that their father had filed form number 7 claiming occupancy rights in respect of 4 acres,
19 guntas.
19 guntas in survey number 109 of Chikkabevnur village. Full stop. They contend that the land tribunal had granted occupancy rights on
13/4/70.
on 29/8/1977. Consequent to which form number 10 was issued under section 55 of the Land Reforms Act. Full stop. They contend that after the death of their father, their names were entered in the revenue records. Sorry, they contend that their father's name was entered in the revenue records in the year 1988-89. And till ಯಾವತ್ತು change ಆಗಿದೆ ನಿಮ್ಮ ಹೆಸರು?
Change.
Till the year 2013-14, when the name of the petitioners were entered
ಹೆಸರು ಏನು ಚೇಂಜ್ ಆಗಿದೆ? ಹೆಸರು ಏನು ಚೇಂಜ್
as they had inherited the said property
ಚೇಂಜ್ ಆಗಿದೆ?
after the death of their father.
2013, your lordship.
Full stop. They contend that for the first time in the year 2013-14, the name of the respondent number 1 was entered in column number 9 and 12 of the RTC bearing survey number 109 of Chikkabevnur village measuring 4 acre 19 guntas. Full stop. They contend that when they sought information under the Right to Information Act as to how the name of the state government was entered, the respondent number 2 furnished a copy of the order dated 25/2/2014, where the respondent number 2 had directed the entry of the name of the state government in respect of 174 acres, 14 guntas in survey number 109 of Chikkabevnur village. In view of various proceedings that emanated out of an order passed under section 63 of the Karnataka Land Reforms Act, which culminated in an order passed by the Honorable Supreme Court in SLP 1955-19556/2009. Being agreed with the said order, the petitioners are before this court. Next, the learned counsel for the petitioners contend
that the respondents have contend that the land tribunal was headed by the then respondent number three. And occupancy rights were granted, consequent to which the respondent number 4 issued form number 10 and recognized the right of the father of the petitioners in respect of 4 acre 19 guntas in survey number 109 of Chikka Bevanur. Stop. He contends that the respondent number 3 had thereafter entered the name of the father of the petitioners in the year 1988, and the same continued till the year 2013. When the name of the petitioners was entered in the revenue records. He therefore contends that the respondents were fully aware of the fact that 4 acre 19 guntas in survey number 109 was granted to the father of the petitioners, but yet they deliberately included the name of the state government in the inserted the name of the state government in column number 9 and 12 after deleting the name of the petitioners. He therefore contends that the order passed by the respondent number 3 is liable to be set at naught insofar as the land of the petitioners is concerned. Full stop. The learned AG, on the other hand, submitted that the order of the land tribunal was not communicated to the respondent number 3 and 4. And therefore, the respondents 3 and 4 were under the bona fide impression that the entire extent of 174 acres, 14 guntas in survey number 109 was excess land, and hence steps were taken to enter the name of the state government in the revenue records. Next, I have considered submissions of the learned counsel for the petitioners and the learned counsel for the respondents, and the learned AGA for the respondents. Next para. The documents produced along with the writ petition categorically establish that the father of the petitioners was granted occupancy rights to an extent of 4 acres 19 guntas in survey number 109 of Chikka Bevanur village, the year 1977. This was followed by a certificate issued by the respondent number 4 in forum number 10, confirming the extent of land which was in cultivation of the father of the petitioners. The revenue records were also transferred to the name of the father of the petitioners and stood from the year 1988-89 till the year 2013-14. Full stop. The basis for entering the name of the state government in column number 9 and 12 after deleting the name of the petitioners is an order passed by the respondent number 3 dated 25/2/2014. Next para. A perusal of the impugned order shows that proceedings were initiated under section 63 of the Karnataka Land Reforms Act in respect of land bearing survey number
109.
109. Land bearing survey number of land bearing block number 884, 691 of 691 of Indi village, block number 320 of Satpura block, of Satpura, block number 752 of Vasant Nagara, Indi, bracketed, 752 and 743 of Vasant Nagara, block number 235 of Ingalagi, and block number
230. 109.
block survey number 109 of Chikka Bevanur village. Full stop. The order of declaring the aforesaid said land as excess land was challenged by Shri Vittal Shivappa Rathod and Shri Madhu Jairam Rathod before the Land Reforms Appellate Authority. LR number 240/86, 262/86, which were dismissed on 22/2/1988. Thereafter, they challenged the order in WP number 5562/1988, 5911/1988, and 7227/1982. This court, in terms of this court allowed the writ petition and directed the tribunal to conduct a fresh inquiry. Full stop. Consequent thereto, the tribunal passed an order dated 4/1/2002 and directed an extent of 174 acres, 14 guntas to be registered in the name of the state government. The aforesaid persons then challenged the order in WP number 21867/2002, which was dismissed, and a writ appeal 2123/2006 was also dismissed. They again challenged it before the Honorable Supreme Court in SLP 1955-19556/2009, which was also dismissed on 6/9/2013. Full stop. It also disclosed that in respect of block survey number 743 of Indi, two persons named Jangu Chandu Lamani and Nathu Chandu Lamani had filed form number 7, and that the tribunal had granted occupancy rights in an area measuring 49 acres, 23 guntas, and had issued corresponding form number 10. Full stop. Therefore, the respondent number 2 directed the name of the state government to be entered in the revenue records in respect of the aforesaid survey numbers, except 49 acres, 23 guntas in survey number 743. Full stop. It is thus evident that the respondent number 3 and 4 have not taken into consideration the fact that 4 acre 19 guntas was granted to the father of the petitioner in survey number 109 of Chikka Bevanur village, and hence that also had to be excluded while passing the order directing the name of the central government to be entered in the revenue records. In that way of the matter, this writ petition is allowed. The impugned order passed by the respondent number 3 is set aside insofar as the land bearing survey number 109 of Chikka Bevanur village, measuring 4 acre 19 guntas. Full stop. The respondent number 3 and 4 are directed to forthwith take immediate measures to restore the name of the petitioners in the revenue records in both column number 9 and 12 of the land bearing survey number 109 of Chikka Bevanur village, so Taluk, measuring 4 acre 19 guntas. This shall be done within a period of 3 months from the date of receipt of a copy of this order. Yes.
Petitions are in possession, Your Lordship.
Right. Yes.
42.
Short accommodation taken next week and.
Why, mister? Yeah, dismissal.
ಅಲ್ಲ
ಏನ್
33
ground?
seat is 33 seat ಇದೆ.
Huh?
33 seat labor court.
33 C2.
Yes, sir.
He was dismissed on the ground of misconduct
Hmm.
and unauthorized absent. My lord. That same was challenged before this honorable court. My lord. In writ petition it was dismissed, and we have filed also writ appeal also that was dismissed. My lord. Thereafter, my lord, he has filed the seeking arrears of the
Hmm. Calculation, it's only a matter of calculation.
calculation. ಸ್ವಲ್ಪ
Calculation ಮಾಡಕ್ ಬರಲ್ಲ.
The calculation already filed before the tribunal. my lord. Our respond number 2 before the filed. Same is.
Whatever they have submitted is granted.
No, my lord. 3 lakh, 3 high assessment. 3,52,000.
ಅಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರಾ?
Court, yes.
ಅವ್ರು ಎಷ್ಟು ಕೇಳಿದ್ರೆ ಅಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, sir.
What more, mister?
my lord,
Page number 36 there is.
Page number?
36. $3,15,572.
No, where does the respondent, where does the petitioner say that he is entitled to only this much?
4 lakhs, it's sir. 4 lakhs some amount.
4 lakh? 33 C2 petition ಎಲ್ರಿ ಇದೆ?
4,54,741 ಇದಕ್ಕೆ.
annexure E order, my lord.
Annexure?
Annexure E, my lord.
Annexure E na?
Please, my lord.
Where is the petition filed by you? 33 C2.
Petition is not there.
Annexure A, sir.
Annexure E.
ಹಾ?
Annexure
Annexure
A,
A.
my lord.
ಏನಂತ ಕೇಳಿದಿರಾ?
That has been filed by the respondent. Respondent and
Detailed calculation wages dues clearly enumerated. Annexure will reflect the wages payable. Applicant entitled to receive some more. 4,64,741.
741, yes, my lord.
ಹೆಂಗೆ? Where is that annexure 1 and 2 that you had filed?
2 is annexure B is to objection of the respondent before the tribunal. After he,
Mister, where is the annexure 1 and 2? Page number 13 ಗೆ ಬನ್ರಿ, para 10.
please.
Para 10 last but 5 lines ಓದ್ರಿ.
Please, madam. The detailed calculation was, the calculation of wages is due clearly enumerated in the annexures. The annexure 1 and 2 reflects the wages and payable and paid the applicant. Applicant is entitled to receive an amount of rupees 4,64,741.
Where is that annexures 1 and 2?
1 and 2. It is not there.
You want,
Please.
what kind of petitions you file? You don't even know what is your case. ನಿಮ್ ಕೇಸ್ ಏನು ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. And your petition is so incomplete.
I will produce the document.
Appa, in less than a second, I could find out that this is not produced. You've not been able to look at it even the last 4 years. ಮುಖ್ಯವಾಗಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕಾಗಿರೋ ಡಾಕ್ಯುಮೆಂಟೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲ್ಲ ನೀವು. ಮಹಾಂತೇಶ್ ಪಾಟೀಲ್ ಹಿಂಗ್ ಮಾಡಲ್ವಲ್ಲ, ಯಾಕೆ? ವೈ ಡಸ್ ಇಟ್ ಡೂ ದಿಸ್? On counsel for the petitioner. List on.
Submission, Mamdapur.
Yeah, Mamdapur ಬನ್ನಿ, ಅದೇನು?
39. 39. Petitioner is owner of survey number 475 measuring 320 Untamal. So also respondent number 4 and 5 are owners of survey number 476 and 477. Page annexure, page number 21, I have prepared a sketch map, my lord, where the respondent and all other the persons whose lands are nearby are passing through by this road, my lord. Page number 21, my lord. Since long back, there was a pathway in the map shown in the land. They have filed an application under 103, the land revenue act, to
Land Reforms Act,
land revenue act,
Land Revenue Act,
and claiming a cart road in the middle of the land, wherein it is now a irrigated land. I am growing what you call wheat and horse-cram. And I have also filed a civil suit. My suit is dismissed on technical. That is at page number, the reasoning given by the learned civil judge at there are the photos, my lord, from every time. All the persons are using the road.
So what is this road then?
But then all the people, it is either the eastern side of my land, my lord. The way is used for all persons, cart, everything, my lord. Now they want to have a road in between my land wherein I have grown wheat. The civil suit is filed, dismissed, and I have filed a regular appeal, my lord. It is pending for consideration. Even clause 3 also says about, shall I read, madam? 103.
Yes, I truly would. Yes.
Civil suit final and nothing authorized to done under the provisions of this act shall affect the right to the parties interested as the same may be established in any suit between the parties in the court of competent jurisdiction. So my regular appeal is pending.
The 103.3 na.
Subclass.
103.3 says the order of the Deputy Commissioner under subsection 2 shall be subject to the decision of civil suit.
Yes, my lord. My civil suit is pending, my lord. And my appeal is pending, my lord.
So whatever order that is passed, by the Deputy Commissioner will be subject to the outcome of the civil suit.
So now, now they are laying a road in my middle of the land, my lord.
Yes.
Entire crops are being damaged.
Whether what is the inquiry conducted by the Deputy Commissioner?
May I? Page number 66, last paragraph.
Page 66.
Not that I want a road, it is not that I want a road in the land of the petitioner. There existed already a road existed therein. He has encroached upon it. Last 4 lines from page number 66. ಕಾರಣ ಸದರಿ ರಸ್ತೆಯ ಬಗ್ಗೆ ತಕರಾರು ಮಾಡದಂತೆ ಮನವೊಲಿಸಲಾಗಿದೆ ಅಂತ ಜವಾಬು ಪಂಚನಾಮೆ ಮತ್ತು ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳು ಕಂದಾಯ ನಿರೀಕ್ಷಕ ವರದಿಯನ್ನು ಲಗತ್ತಿಟ್ಟು ತಹಶೀಲ್ದಾರ್ ಬಸವನ ಬಾಗೇವಾಡಿಯವರು ದಿನಾಂಕ 20/7/2017 ರಂದು ವರದಿ ಸಲ್ಲಿಸಿದ್ದನ್ನು ಅವಲೋಕಿಸಿ ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಅರ್ಜಿದಾರರಿಗೆ ಈ ಮೊದಲಿನಂತೆ ಪರಸ್ಪರ ಒಪ್ಪಿಕೊಂಡು ಜವಾಬು ನೀಡಿದಂತೆ ಎದುರುದಾರರು ಜಮೀನದ ಸರ್ಕಾರಿ ರಸ್ತೆಯಲ್ಲಿ ಹಾದು ಹೋಗಲು ತಕರಾರು ಮಾಡದಂತೆ ಎದುರುದಾರರಿಗೆ ಸೂಕ್ತ ತಿಳುವಳಿಕೆ ನೀಡಲು ತಹಶೀಲ್ದಾರ್ ಬಸವನ ಬಾಗೇಡಿಯವರಿಗೆ ಆದೇಶಿಸಿದ್ದು ಕಂಡುಬರುತ್ತದೆ. ತದನಂತರ ರಸ್ತೆಯನ್ನು ತೆರವುಗೊಳಿಸಲು ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಬಸವನ ಬಾಗೇಡಿಯವರು ಹೋದಾಗ ರೀಸನ್ ನಂಬರ್ 477 and 470 ನೇದ್ದರ ಜಮೀನ್ ಮಾಲೀಕರಾದ ಸಂಗಪ್ಪ, ದಟ್ ಈಸ್ ಪಿಟಿಷನರ್, ಮಲ್ಲಪ್ಪ ಬೈಚ್ವಾಳ್ ಹಾಗೂ ಆತನ ಹೆಂಡತಿ ಶಾಂತಾಬಾಯಿ ಸಂಗಪ್ಪ ಬೈಚ್ವಾಳ್ ಇವರು ಅಡ್ಡಪಡಿಸಿದ್ದರಿಂದ PSI ಮನಗುಳಿ ಇವರಿಗೆ ಫಿರ್ಯಾದಿ ನೀಡಿದ್ದು ಆ ಪ್ರಕಾರ ಪ್ರಥಮ ವರ್ತಮಾನ ವರದಿ ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬಂದಿದ್ದರಿಂದ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ so and so. Let's kindly peruse the last operative portion of the impugned order ಆದೇಶ. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಕಾಣಿಸಿದ ಅಂಶಗಳನ್ನು ಅವಲೋಕಿಸಿ ಪುನರ್ ಪರಿಶೀಲನಾ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಸರ್ಕಾರಿ ರಸ್ತೆಯಲ್ಲಿ ಇರುವ ಒತ್ತುವರಿ ತೆರವುಗೊಳಿಸಲು ತಹಶೀಲ್ದಾರ್ ಬಸವನ ಬಾಗೇಡಿಯವರಿಗೆ ಆದೇಶಿಸಿದೆ. ಖಾಸಗಿ ಜಮೀನಿನಲ್ಲಿ ರಸ್ತೆ ಇದ್ದಲ್ಲಿ ಅದರ ಕುರಿತು ಮಾನ್ಯ ಸೇವಾ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳಲು ತಿಳಿಸಿದೆ. ಅಲ್ಲಿಯವರೆಗೆ ರಿವಿಷನ್ ಎದುರುದಾರರಿಗೆ ಈ ಮೊದಲಿನಂತೆ ಪರಸ್ಪರ ಒಪ್ಪಿಕೊಂಡು ಜವಾಬು ನೀಡಿದಂತೆ ಹಾದು ಹೋಗಲು ತಕರಾರು ಮಾಡದಂತೆ ಆಗಿದೆ. He has also already, milords, there was a previous this thing wherein he had agreed for the existence of the road, and he also agreed that he will not, milords, disturb in the using of.
This is regarding some government road.
Yes, he has encroached upon that government road, milords.
Yes.
There is
Now,
no road,
milords,
my lord.
every now,
There is a-
even other.
There is a path road, my lord. Earlier in between a land, my lord. Thereafter, from ancestral property, they
If you want,
understand.
we'll get a commissioner appointed if you want. ನೀವ್ ಹೇಳಿ ಯಾರು ಬೇಕು ಅಂತ ಹೇಳಿ. We'll get a
ಇದರಲ್ಲಿ
commissioner appointed.
beyond his land exists my land. He has blocked the bund. He has.
That road is, I have.
Commissioner
Yes, my lord.
ಯಾರು ಮಾಡ್ಬೇಕು ಹೇಳಿ. ಹಾ. The one sitting there. ಏನಪ್ಪ?
ರೋಡ್ ತರ
Towards eastern side, my lord, bund. Thereafter, there is a road they are going. they are using, my lord.
ಇರೋದು ಎಲ್ಲಿ? Where is this property?
It is in Masibinal village, Taluka Baswan Bagewadi, district Vijaypur.
Can you go? ಹೋಗ್ತೀಯಾ? ಹೋಗಿ ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀಯಾ ಕರೆಕ್ಟ್ ಆಗಿ ಸ್ಕೆಚ್ ಕೊಡ್ಬೇಕು. ಹಾ?
Yes, my lord.
ಹಾ.
With the assistance of some officer, milords, of the department. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ರೋಡ್ ಅವ್ರು ಮುಚ್ಚಾಕಿ ಗೋಧಿ ಅದು
ಆಗುತ್ತಲ್ಲ.
Yes.
If he goes tomorrow, you can find out ಮುಚ್ಚಾಕಿದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಗಿಡ ಬೆಳ್ಸಕ್ಕಾಗತ್ತ?
ಇಲ್ಲ ನಾವು I have also secured photos.
It's all right. Let him go and give a report. ಹಾ. ಎಷ್ಟು ಹೇಳಿ ಕಮಿಷನರ್ ಫೀ?
5,000, 10,000. 10,000 will give.
No.
10,000. Any fees, my lord, court deems fit will be paid.
ಎಷ್ಟು ಹೇಳಿ? 25.
25 will pay.
Yes. ಬರ್ಕೊಳ್ಳಿ. The petitioner contends that the respondent number 2 has passed the impugned order and has tried to form a road in the land belonging to the petitioner bearing survey number 475,
Yes, madam.
77 and 76.
No, I land is 75.
475. However, the learned counsel for the respondent number 4 and 5 submit that they are the owners of the adjacent survey number 476 and 477, and that the petitioner has encroached into a road which is identified in the village map
Yes.
and is treated as a government road. He contends that the respondent number 2 has passed the impugned order directing the petitioner
Oh.
to remove the encroachment on the said government road. Therefore, there is a dispute as to whether the road that the respondents 4 and 5 are claiming, respondent number 2 is claiming, belongs to the state government and whether the same is used by the general public. Full stop. While the petitioner claims that it is not used by anybody, the respondents 4 and 5 claim that it is used by the general public and the petitioner has closed it
Yes.
or encroached,
Closed it.
has
From
closed
past-
it.
And there is a eastern side, there is a road, my lord, they're all,
Thus, in order to find out
that one observation.
the factual,
Eastern side of the land survey, land, there is a road.
let him go and identify.
Ah,
To get a factual report of the property of the petitioner and the road that is ordered to be restored by the respondent number 2. This court felt it appropriate to appoint a commissioner, full stop, Mr. Huh? Bhimshat Angalgi. Takkalki, who was present in the court, was requested to visit the property and submit a report.
He agreed and accepted the request of the court. Full stop. Therefore, is appointed as a court commissioner to visit the property of the petitioner, draw up a sketch of the property of the road, which is ordered to be restored by the respondent number 2, and also identify any other road available on the eastern side of the property of the petitioner. Full stop. The respondent number 3 shall provide the assistance of a revenue inspector of the revenue inspector of the zone, you know,
Hubli.
the Hobli, revenue inspector of the Hobli, to help him execute the commissioner warrant. Full stop. Office is directed to issue appropriate commission warrant to the commissioner. Full stop. It is open for the commissioner to seek the assistance of the local police in case he is obstructed from executing the commission warrant. The commissioner's fee is tentatively fixed at a sum of rupees 25,000 payable by the petitioner to the commissioner at the spot. The commissioner shall submit a report on yavat
2 days.
No?
2 days time.
The commissioner shall inspect the spot on Shanwara, Saturday.
One petition copy to
On
let him
on 8th February 2025 at 11 AM. 11 ಗಂಟೆಗೆ ಆಮೇಲೆ 11:15 ಹೋಗ್ಬೇಡ. 11 ಗಂಟೆನೆ. ಓಕೆ?
ಇಲ್ಲ ಇಲ್ಲಿಂದ ಬೆಳಿಗ್ಗೆ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಂತ ದೂರ ಆಗತ್ತೆ.
ಒಂದಿನ ಮುಂಚೆ 25,000 ಕೊಡ್ತಿಲ್ವಾ? ರೂಮ್ ತಗೊಳ್ಳಿ ಎಲ್ಲೋಗಿ. Let him take a room, Mr. Let him.
ಮುಂಜಾನೆ ಹೋದ್ರೆ ಬಿಸಿಲಾಗ್ತದ, ಮುಂಜಾನೆ ಸರಿಯಾಗಿರುತ್ತೆ.
Let him go enjoy. Let him spend 5,000 rupees for this.
Yes, my lord.
ಮತ್ತೆ? 11 ಗಂಟೆಗೆ 11 AM. It is open for the petitioner and the respondents 4 and 5 to be present at the spot. The commissioner shall submit a report by 11th, Mangalore, 11th February 2025.
Copy of the petition may be served to the.
ನೀವೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
Till then,
ನನ್ನ ಕಡೆ ಇಲ್ಲ.
ನಿಮ್ಮದು ಕಾಪಿ ಕೊಡಿ.
till 12th ಕಿಟ್ರು.
ಹಾ?
12th.
ಎಂತದು?
Taken up on 12th.
12. ಏನ್ 12?
Date.
ಅಲ್ಲ ಇದು ಟ್ಯೂಸ್ಡೇ ಬರೋದು. KLR matters will come up on Tuesday. Yes, 11th.
Till then status.
ಅಲ್ಲ, I will not take any. ಅವ್ರಿಗೂ overall there will be understanding. ಯಾಕಂದ್ರೆ ಮತ್ತೆ
The next state of hearing, the parties are directed to maintain status quo.
Yes.
Yes. Next, correct. Ashok Molge.
My lords, the matter pertains to no confidence motion.
Pardon?
The matter pertains to no confidence motion
Ah,
initiated against the petitioner. My lords, since on the date of service of notice, the petitioner was not present in the house. Considering the same, the PDO of the Panchayat has affixed the same to the house of the petitioner on 22/1/2025 at 4:35 PM. And he has taken a photo and forwarded the same to the petitioner mobile mallards. I have produced the copy. Annexure B is the notice dated 21/1/2025. And the PDO has served, affixed the same to the house of the petitioner on 22/1/2025 at 4:30 PM. And forwarded the photo to the fixing the date of election on 6/2/2025 minutes. There is a clear violation of not having clear 15 days time between the service and the date of meeting.
On the 15th day, then we should fix the meeting.
Yes,
On the 15th day.
on the 15th day, we fixed the meet.
My lord, the notice of the Gram Panchayat moved by the no complaints before
Huh?
the notice of the Gram Panchayat members moved by before the Assistant Commissioner not produced by the petitioners.
So what?
So whether it has signed by the members or not,
Oh, but 20
whether it has completed 30 days or not, whether how many members has been signed, one third.
how is it
third.
material?
But ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಬಟ್ ಹೆಂಗ್
ಅದೇನಕ್ಕೆ ಬೇಕು?
ಕನ್ಕ್ಲೂಸ್ ಮಾಡ್ಬೇಕು ನಾವು?
ಅಲ್ಲ ಅದೇನಕ್ಕೆ ಬೇಕು ಅಂತ 21/1/2025 ನೋಟಿಸ್ ಇರೋದು.
ಓಕೆ
6/2/2025 ಮೀಟಿಂಗ್ ಇರೋದು. ಎಷ್ಟು ದಿನ ಆಯ್ತು ಅಲ್ಲಿಗೆ? 21 is 10 days. ಜನವರಿಲಿ 31 ದಿನ
30.
ಪ್ಲಸ್ 6ನೇ ತಾರೀಕು 16 ದಿನ ಆಯ್ತು. ಸೊ when was the notice served?
22.
But as per overall instruction of Gram Panchayati members, it has been served on the same day, my lord. But that has not produced by the petitioner. Kindly direct to the PDO, secure the records.
Not
It has
only,
served to the petitioner by hand.
ಮತ್ ಬೈ ಹ್ಯಾಂಡ್ ಆಗಿರೋ ಮನೆಗೆ ಅಂಟಿಸ್ಬೇಕಾಗಿತ್ತು.
ಆದ್ರೂ ಅವರು ಹೋಗಿ ಅಂಟಿಸಿದ್ದಾರೆ, ಅದನ್ನ ಇವರು ಆ 15 days ಅಡ್ವಾಂಟೇಜ್ ತಗೊಳ್ಸಲ್ಲ ಇದನ್ನ ಇದು ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಅದನ್ನ ಕೊಟ್ಟಿಲ್ಲ. PDO ಕರ್ಸ್ಬಿಟ್ಟು ಅದನ್ನ ಇಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ಸೆಕ್ಯೂರ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತೇ ಆಗುತ್ತಲ್ಲ ಅಂತ.
not only to the petitioner, my lords, all the persons, all the members, including them also served on 22nd.
ನಿಮ್ಗೆ ಯಾವ ಬಂತು?
So all the, another person was also served on 22nd.
As
Photos.
per annexure B.
ನಿಮ್ಗೆ ಯಾವ ಬಂತು?
It is 20 same day, my lord.
You received on 21st.
21st.
ಹಾ
ಬಟ್ ಅವರಿಗೂ ಅದೇ ದಿನ ಕೊಟ್ಟಿರ್ಬೇಕು, ಅದನ್ನ PDO ಹತ್ರ ಇದೆ, ಅದನ್ನ ಸೆಕ್ಯೂರ್ ಮಾಡಿ ಹೇಳಿದ್ರೆ ಅದು
ಕರೆಕ್ಟ್
ಗೊತ್ತಾಗುತ್ತೆ.
ಅಪ್ಪ. 21st ಸರ್ವ್ ಆಗಿದ್ರೆ 21st ಯಾಕೆ ಮನೆಗೆ ಅಂಟಿಸ್ಬೇಕಾಗಿತ್ತು?
ಇದು ಎಲ್ಲ 15 days ಅಡ್ವಾಂಟೇಜ್ ತಗೊಳಕ್ಕೆ ಆಲ್ಮೋಸ್ಟ್ ಎಲ್ಲಾ ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳಲ್ಲಿ ನಡ್ತಕ್ಕಂತ ವಿಷಯನೇ ಇದೆ.
ನೀವು ಆ ಕಡೆ ಇದ್ರೆ ನೀವು ಅದೇ ತಗೊಳ್ತಿದ್ರಿ. You also would have taken the same advantage.
ಅದಕ್ಕೆ PDOಗೆ ರೆಕಾರ್ಡ್ ಸೆಕ್ಯೂರ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಅಂತ.
It is
ಇಂಡಿ ಯಾರು ಬರ್ತಾರೆ? ಅಸ್ಟೆಂಟ್ ರತ್ನಾಶಿವಾಗಿ ಮಠ
Vijapur.
Produce the photo of the PDO itself.
ಬರ್ಕೊಳ್ಳಿ, ಆಯ್ತು ನೋಡು.
Annexure C.
AG has directed accept notice for response 1, 2 and 3. Mr. Annaraya
M. Patil.
M. Patil has entered caveat for the private respondents. Srimati Ratna Shivayogi Mutt is directed to accept notice for respondent number 4. The learned counsel for respondent number 4 is directed to secure information as to when the meeting notice was served on all the members of the Panchayat, and particularly the petitioner. And in particular, the petitioner. List tomorrow.
Yes, madam.
Please intimate,
Please,
madam.
please.
Hema Kulkarni.
Appear for petitioner, my lord. Respondent bank is filed criminal miscellaneous against the petitioner for recovery of suit loan.
Yes, madam. What is your case?
97 lakh amount, madam. 97 lakhs. Due amount is 1 crore 82.
This is a section 14 order.
Yes, ma'am.
Order is passed on section 14.
Yes, ma'am.
What is section 14?
Notice to petitioner to paper
So
publication.
what is section 14, madam? What is section 14?
Position of the property, ma'am.
Possession of the property. What do you mean by that?
Please.
ಏನ್ ಹಂಗಂದ್ರೆ?
ಲೋನ್ ಅಮೌಂಟಿಗೆ ಮಾರ್ಟಿಗೇಜ್ ಆಗಿ ಕೊಟ್ಟಿರೋ ಪ್ರಾಪರ್ಟಿನ ಪೊಸಿಷನ್ ತಗೊಳಕ್ಕೆ ವಾರಂಟ್ ಇಶ್ಯೂ.
ಎಷ್ಟು? 50%?
25%.
50%.
4 weeks time
Madam,
ಕೊಟ್ಟಿರೋ.
this petition is not maintainable. I'm granting you time only so that you can pay the money, that is all. Otherwise, if you compel me, I'll have to decide the case and say that you have to go before the surface DRT.
That one request is that, my lord, the respondents are insisting for 21 lakhs to make it
Okay, so regularize the account, my lords. So he is ready to regularize the account. If 1 month time is given, my lord, he will pay the 21 lakhs and get the account.
Where have you
regularized.
said that the bank is willing to regularize it?
It is, they have not given anything on writing. Therefore, we waited until.
Have you said
the
it
last-
anywhere in the petition?
No,
Then-
because unless they say we can't write it.
No,
If
but
the date will be fixed, my lords, it may be,
Yes.
order may be passed, interim order, subject to result of payment of 25.
Madam, 97 lakhs is the due.
Please.
97 lakhs is the due. Where's the question of 21 lakhs?
Only for the default of few installments, my lords, they have
And
made
this
a
was-
non-performing asset.
This was in 2019. We do not know what is the amount due now.
The
1
same.
crore 82.
1 crore 82 lakh.
2,438.
Then,
Therefore, it is almost impossible to pay the 50% of the amount. So may I request, my lords, if a date be fixed, my lords, if the bank gets ready for the payment of 21 lakhs, so that I can get the account recovered.
then take out notice aste. No interim order.
They'll
No interim order.
let the interim order be passed, my lords, and subject to payment of.
Take out notice if you want, but no interim order.
50%.
50% work code. Though this writ petition is not maintainable in view of the judgment of the apex court in Satyavati, London, since the learned counsel for the petitioner submitted that the petitioner is interested to settle the dispute and pay off the outstanding, comma, the impugned order at annexure
B.
B state subject to the petitioner depositing 50% of the amount due with the respondent number 1 within 4 weeks from today.
Yeah, request for 8 weeks, my lords, the amount being very
Deposit
heavy.
ಮಾಡಿ ನೋಡೋಣ.
Please.
Within 4 weeks from today. It's made clear if the petitioner does not deposit the amount, the respondent number 1 will be at liberty to take any steps in furtherance to the impugned order. Yes.
Dispensation to the respondent.
Respondent
Uh,
number 2.
issue a notice to the respondents. ಯಾರಿಲ್ಲೋ advocate ಇಲ್ಲ
Respondent
standing
number
counsel.
Respondent number 2 is maybe dispensed. Ma'am.
Issue notice to respond number 1, notice to respond number 2 is dispensed at the request and risk of the petitioner. Yes.
There's no panic on it.
The plaintiff invoice number 569 of 2017 on the file of so-and-so has filed this writ petition challenging the correctness of an order dated so-and-so by which an application filed by him under Order 26 Rule 9 of CPC was rejected. Next para. The suit invoice number 569 of 2017 was filed for declaration of title of the plaintiff to the suit property and for perpetual injunction to restrain the defendant from interfering with his possession in the suit shall property. Full stop. The plaintiff claimed that he is the owner of the land bearing survey number 62/1/2, measuring 3 acre 2 guntas and situated in Tajpur, Tajpur, bracket H village, Vijaypur Taluk and district. He contended that he had invested huge sums of money for raising a pardon? Grapes.
Grapes.
For raising a winery, VINERY. He claimed that the defendants during August 2016 alleged that the plaintiff had encroached into 4 guntas of their land on the western side
and had filed an application for survey of the land. But the survey officials colluded with the defendants and contended that the plaintiff had to give up his area on the eastern side of his land, adjacent to the defendant's land. Full stop. Plaintiff alleged that his attempts to convince the defendant proved futile. And that he was bent upon to use force to encroach into the land owned by him. Stop. The defendant contested the suit and claimed inter-alia that the defendant contested the suit and claimed inter alia that the allegation made by the plaintiff that the defendant had alleged that the plaintiff had encroached into 4 guntas of land was false. He contended that at one breath, the plaintiff asserted that the encroachment was on the east of his land, and in another breath, he claimed that it was on the western side of the defendant's land. Therefore, he contended that the allegation that the defendants had alleged that the plaintiff had encroached into 4 guntas of land was all false. Full stop. With these contentions, based on these contentions, the trial court framed issues and set down the case for evidence. After the parties adduced their evidence, an application was filed by the plaintiff under Order 26 Rule 9 of CPC to appoint the Assistant Director of Land Records or any Taluka surveyor as a court commissioner to submit a report on the memo of instructions after holding a spot inspection of the land bearing RS number 62/1/2 measuring 3.02 acres. Full stop. In the affidavit accompanying the application, he stated that the defendants are objecting my claim. Full stop. They are disputing the area in my possession and started alleging that I have encroached their part of the land towards west of my land to an extent of 4 guntas. Accordingly, I am constrained to file the present suit. Now it is necessary to appoint court commissioner to measure the suit agricultural land owned by me, inverted comma close. This application was contested by the defendant who denied the assertions made in the affidavit accompanying the application. They also contended that the plaintiff cannot seek the appointment of a commissioner to collect evidence and prove the case of the plaintiff. The trial court, in terms of the impugned order, rejected the application on the ground that the defendant on the ground that the plaintiff is bound to establish by producing documents, by establish his title by producing acceptable evidence, and that there is no need for appointment of a commissioner. Being agreed by the said order, the plaintiff is before this court. Next paragraph. The learned counsel for the plaintiff contends that the dispute between the plaintiff and the defendant is that the defendant has been persistently claiming that the plaintiff has encroached into a part of his land on the western side.
He contends that a survey was also conducted. The sheet was drawn up, identifying the property of the plaintiff and the defendant. Full stop. He therefore contends that it is necessary to identify the property of the plaintiff and also whether he had encroached into any land belonging to the defendant. Full stop. Per contra, the learned counsel for the defendant submits that the defendant had denied the claim of the plaintiff that he had made any allegation that he had encroached into 0.4 guntas of land. He therefore contends that he further contends that no issue is framed as to whether the plaintiff has encroached into any portion belonging to the defendant, any portion of land belonging to the defendant. He therefore contends that there is no need for appointment of a commissioner, and the application filed by the plaintiff is only to protract the proceedings. Next, I consider submissions of the learned counsel for the plaintiff and the learned counsel for the defendant. Next para. A perusal of the plaint shows that the plaintiff had claimed that the defendant sold 3.02 acres out of 9.04 acres in RS number 62/1 in terms of a sale deed dated 11/5/2000. Full stop. The plaintiff claimed that he and the defendant had understood that the area sold to the plaintiff was the area after deducting the area already acquired by the government for expansion of the state highway. Full stop. He contended that the defendant had handed over possession of 3.02 acres of vacant land out of 9.04 acres. And the revenue entries are brought about reflecting the same. Full stop. The plaintiff alleged that the defendants were claiming that the plaintiff had encroached into 0.4 guntas on the western side of their land. And an application was filed for survey and fixing the boundaries of the land as per the sale deed. He alleged that the survey officials colluded with the defendants and that they claimed defendants who directed the plaintiff to give up a portion of his land. Full stop. However, in the course of cross-examination of the defendant, the following suggestions were made. Underline first. Therefore, the defendant is consensus ad idem over the fact that the plaintiff is in possession of 3 acre 2 guntas of land. Full stop. He also stated that he had never claimed that the plaintiff had encroached into 4 guntas of land belonging to him. Full stop. Under the circumstances, there was no need for appointment of a commissioner as the defendant did not dispute the title of the plaintiff to 3 acre 2 guntas of land. Consequently, the trial court was justified in not entertaining the application filed by the plaintiff. Hence, the writ petition lacks merit and is dismissed. Ravi V. Patil.
Here.
Yeah, who is the other side? Who appears for the other side? State government.
State government.
Yes.
My lord. Last date hearing, I have filed, my lord. Today file has been misplaced.
File is misplaced. Lord AJ seeks time, list on.
Next week, my lord.
Take whatever you date you want, but don't, at least by that time you get back the file.
Yes,
DP Ambekar. What about this file?
yes, my lord.
Petitioners are challenging the order of the land tribunal, holding that they are having excess 30 acres of land.
Pardon?
Petitioners are challenging the order passed on their farm number 11, holding that they have got 30 acres excess land, 30 acres, 23 quintals. The facts of the case is, my lords.
Objections ಬೇಕಾಗುತ್ತಲ್ವಾ?
Yes.
Learned AGA seeks time to file statement of objections. List on.
2 weeks.
The interim order is there, my lords.
Interim order is extended till the next date.
Yes.
Yes.
Harshavardhan.
This is an issue regarding, my lord, the rehabilitation benefits that are payable under the new act, my lord. One of the benefits, my lord, under Schedule 2 is that, my lord, if the project, my lord, generates employment, the land losers, my lord, are entitled for, my lord, a vocation or, my lord, a job on the same project. Lord, here, my lord, the next, they have rejected that on the count that, my lord,
But this has to be done by whom? Respondent 4, huh?
yes, respondent 3, my lord, is supposed to pass, my lord, or recommend that prepare the draft and, my lord, send it. And, my lord, respondent 4 is
Sir,
supposed
who
to
is the
pass.
answering respondent? R1 to R5 AG ಅಂತ ಹೆಂಗ್ ಬಂತು?
1, 2, 3, my lord, government.
What about 4 and 5?
4 and 5 are, my lord, the beneficiary of that, my lord, acquisition.
Is government.
Lord, there is one small interpretation which is required in this case. Lord, they deny me that benefit on the count that, Lord, they hold that I am not primarily dependent or on this, Lord, project. Since my land acquired is lesser than, Lord, 50% of my land holding. Lord, the classification is based, my lord, in section 3 definition, my lord, if your lordship sees. There are two, my lord,
But then can this petition be disposed of without their objections?
they have filed their objections.
ಮಾಡಿದಿರಿ?
Lord, I'm served, my lord, 1912, my lord, I'm.
ಕೊಡಿ. ಹೊಸ ಆಕ್ಟ್ ಕೊಡ್ರಿ, 2013 ಆಕ್ಟ್. Section?
Section 3, my lord, the definition. 3C would be relevant, my lord.
Yes.
Benefits are for the affected families. Now the definition of, my lord, the affected family requires to be, my lord, considered. 3C1 says, my lord, I'll read, my lord, 3C. The affected family includes 1, a family whose land or other immovable property has been acquired. This is one category. 3C2 says, my lord, a family which does not own any land, but a member or members of such family may be agricultural laborers, tenants, including any form of tenancy or holding of usufruct rights, sharecroppers or artisans, or who may be working in affected area for 3 years prior to the acquisition of the land, whose primary source of livelihood stands affected by the acquisition. This is the second class. Lord, Schedule 2, if your lordship sees, my lord. Schedule 2 provides for, my lord, the rehabilitation benefits.
Yes.
Starts with the heading that, my lord, elements of rehabilitation and resettlement entitlements for all affected families, both landowners and, my lord, families whose livelihood is primarily dependent on the land acquired in addition to those provided in the first schedule.
Yes.
So both, my lord, owners, land losers, and also, my lord, persons affected by the, who are primarily dependent on the acquired lands. I am entitled for benefit under, my lord, item number 4, choice of annuity and entitlement. What? May I read this? I'll read this and, my lord, then, my lord, 4, my lord, choice of annuity or employment. The appropriate government shall ensure that the affected families are provided with the following options. A, where jobs are created through the project after providing suitable training and skill development in the required field, make provision for employment at a rate not lower than the minimum wages provided for in any other law for the time being in force to at least one member per affected family in the project, or arrange for a job in such other project as may be required, or one-time payment of rupees 5 lakhs per affected family, or annuity policy that shall pay not less than 2,000 rupees per month per family for 20 years with appropriate indexation, so and so, so and so. Now, my lord, the rejection is on the count that I do not fall under the category where I am primarily dependent on the land. Lord, my argument is that, my lord, I am a class different from that. 3C1, not 3C2. If it is 3C2, my lord, then if I'm not a land loser, but
Where is the impugned order?
yes,
Ready, na? You ready?
annexure D, my lord, is the award.
Annexure D.
D
Ah,
starts from 23, operative portion at so and so.
yes. Amaresh. Amaresh.
I'll read, my lord, the previous paragraph. It starts, my lord, 4.11 on page 27, where this is considered. ಪ್ರಕಟಿತ ಜಮೀನಲ್ಲಿ ಶ್ರೀ ಸೊ ಅಂಡ್ ಸೋ ಇವರಿಗೆ ಸೇರಿದ ಜಮೀನು ಖುಷ್ಕಿ ಜಮೀನಾಗಿದ್ದು ಸದರಿ ಜಮೀನು ಸೊ ಅಂಡ್ ಸೋ ಮತ್ತು ಜೆಎಂಸಿಯಲ್ಲಿ ಸೊ ಅಂಡ್ ಸೋ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಟ್ಟಿದ್ದು ಅದನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಳ್ಳಲಾಗಿದೆ. ಮಾನ್ಯ ರಾಜ್ಯ ಆಯುಕ್ತರು ಸೊ ಅಂಡ್ ಸೋ ಹಾಗೂ ಪದನಿಮಿತ್ತ ಕಾರ್ಯದರ್ಶಿ ಕಂದಾಯ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಇವರ ಉಲ್ಲೇಖ ಸೊ ಅಂಡ್ ಸೋ ಅಡಿಯಲ್ಲಿ ಪುನರ್ವಸತಿ ಮತ್ತು ಪುನರ್ವ್ಯ ವ್ಯವಸ್ಥೆ ಕರಡು ಯಾದಿಯನ್ನು ಅನುಮೋದಿಸಿ ಆದೇಶ ಮಾಡಿದ್ದಾರೆ. ಸದರಿ ಕರಡು ಯಾದಿಯ ಪ್ರಕಾರ ಸರ್ವೆ ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೋ ಭೂ ಮಾಲೀಕರು ಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಟ್ಟಿದ್ದು ಕಲಂ ಸೊ ಅಂಡ್ ಸೋರ ಅಧಿಸೂಚನೆ ಆಗಿದ್ದು ಶ್ರೀಮತಿ ಕಮಲಾಬಾಯಿ ಗಂಡ ಸೊ ಅಂಡ್ ಸೋ ಇವರಿಗೆ ಮತ್ತು ಶ್ರೀ ಅಮರೇಶ್ ತಂದೆ ಸೊ ಅಂಡ್ ಸೋ ಇವರಿಗೆ ಸೇರಿದ ಜಮೀನು ಭೂಸ್ವಾಧೀನತೆಗೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. ಈ ಕುಟುಂಬಗಳು ತನ್ನ ಎಲ್ಲಾ ಮೂಲಗಳಿಂದ ಬರುವ ಆದಾಯದ ಶೇಕಡ 50ಕ್ಕಿಂತ ಕಡಿಮೆ ಜಮೀನುಗಳನ್ನು ಕಳೆದುಕೊಂಡಿರುವುದರಿಂದ ಸದರಿ ಕುಟುಂಬಗಳ ಜೀವನೋಪಾಯದ ಮುಖ್ಯ ಆಧಾರ ಪ್ರೈಮರಿ ಸೋರ್ಸ್ ಆಫ್ ಲೈವ್ಲಿಹುಡ್ಗೆ ಯಾವುದೇ ಧಕ್ಕೆ ಉಂಟಾಗಿರುವುದಿಲ್ಲವೆಂದು ತೀರ್ಮಾನಿಸಿದ್ದಾರೆ. ಆದ್ದರಿಂದ ಸೊ ಅಂಡ್ ಸೋ ತೀರ್ಮಾನಿಸಲಾಗಿದೆ.
What is 31 2A?
Yes, 31 is, my lord, the provision to, my lord, pass an award for rehabilitation.
2A.
Rehabilitation and resettlement award. It shall include, my lord, rehabilitation and resettlement amount.
He's a land loser ultimately. He's a land loser.
Already less than 50%, my lord.
Huh?
His land is loser less than 50%.
No, where does the act make a distinction? That he must have lost more than 50% of the ellide.
File the objection on page number 2, my lord.
Odi, section 3 Odi. It does not mean a displaced family. Displaced family is different, affected family is different. A family whose land or other immovable property has been acquired. So therefore, everybody comes within that definition. How can you say that he has not lost more than 50% of land
Just para 6, my lord.
of
Page number. Objection filed.
para 6? Please read.
It is submitted that the petitioner was having total extent of 8 acre 15 guntas in Gandhi Nagar, Raur, in survey number 57 to an extent 1 acre 12 guntas. In survey number 58, 1 acre 17 guntas. Survey number 59 to an extent 1 acre 22 guntas. And survey number 60 to an extent 4 acre 4 guntas. Totally 8 acre 15 guntas. Out of the petitioner holding 8 acre 15 guntas only extend to 1 acre 18 guntas.
So how much have you acquired? 1 acre 12 guntas, 1 acre 18 guntas and 6 guntas.
Yes, madam.
ಎಷ್ಟಾಯ್ತು ಅಲ್ಲಿಗೆ? 2 acre 36 guntas.
That's- Therefore, the acquired portion is less than 50%. The total holding, my lord. Hence the and the bloody amount, award amount also paid, madam.
Please read section 31.
Yes. May I read, ma'am?
For each affected family,
May I read, ma'am? Rehabilitation resettlement award for the affected families by collector. The collector shall pass settlement award for each affected family in terms of entitlement provided in second schedule. The rehabilitation resettlement award shall include all the following, namely rehabilitation and resettlement amount payable to the family, bank account number of the so and so to be to which the rehabilitation and resettlement award name is to be transferred, particulars of the house site and house to be allotted in case of displaced family, particulars of land allotted to the displaced family, particulars of one-time subsistence allowance and transportation allowance in case of displaced family, particulars of payment of cattle shed and petty shops, particulars of one-time amount to artisans and small traders, particulars of mandatory employment to be provided to the member of the affected family, particulars of any fishery rights that may be involved, particulars of any annuity or and other emoluments, entitlements to be provided, particulars of special provisions for SC and ST to be provided that no, my lord, they got confused between that, my lord, the primary source of livelihood being affected or otherwise. That's a category by itself. That's a category where you don't lose the land, but you still are affected. Your primary source of livelihood is affected. In that situation, my lord, the entitlement is there.
where does it say primary source of?
That's, my lord, in the definition of, my lord, section 3C2. A person who has not lost his land, but still his primary source of livelihood is affected, then also, my lord, he is entitled for the benefits. If he has lost land, he falls under 3C1.
For example, an agricultural laborer, ಅದೇ ಊರಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿರ್ತಾನೆ, ಆ ಊರಿಲ್ಲೇ ಅಕ್ವೈರ್ ಆಗ್ಬಿಡುತ್ತೆ. The entire village is acquired. So for that agricultural labor, there should be some package. Therefore, they say, whose primary source of livelihood stand affected by the acquisition of the land. Antavರಿಗೆ. Who does not own any land, but a members of such families owns. ಅಷ್ಟೇ ಅಲ್ವಾ? ಬರ್ಕೊಳ್ಳಿ.
Even though award passed in new act, my lord.
new act
Compensation
ಅಲ್ಲ.
amount also.
The petitioner is aggrieved by the refusal to pass a Rehabilitation and Resettlement Award by the respondent number 3 on the ground that this primary source of livelihood of the petitioner is not affected by the acquisition. Next para. The petitioner was the owner of 8 acres, sister,
15 guntas.
8 acres, 30,
15 guntas.
8 acres, 15 guntas of land, of agricultural land in survey numbers.
My lord, the petitioner is concerned with only 57 and 58, where he has lost, my lord, 1 acre, 15 guntas and 6
We're only
guntas.
concerned with 57, 58.
Yes, my lord.
The petitioner was the owner of land in survey number 57 and 58 of Gandhi Nagar, Raur, measuring
Total extent, my lord, is not forthcoming. It's out of which, my lord, 1 acre, 15 guntas and 6 guntas is acquired.
out of which 1 acre,
15 guntas and, my lord, 6 guntas in another survey number is acquired. 57, my lord, 1 acre, 15 guntas is acquired. 58, 6 guntas is acquired.
but what is the total extent?
Total extent, my lord, I'll just point it out.
The owner of land bearing survey number 57, 58 of so and so, measuring dash and dash, of which 1 acre 15 guntas in survey number 57, huh?
Yes, my lord.
1 acre 12 guntas ಅಂತಾರೆ ಇಲ್ಲಿ.
12 gunta ಇದೆ.
57/1.
So you have a look at the award.
1 acre 15 gunta. Page number 31.
Amaresh, 57. Kamala Bai, Amaresh.
Lordship will get it at, my lord, page 38. The
57
apportionment
bar.
state
1 acre 15 guntas in survey number 57 bar 1.
1. And, my lord, 6 guntas in 50.
And 1 acre and 06 and 6 guntas in survey number 58 was acquired for the purpose of the respondent number 4, huh?
Yes,
4 and 5,
yes. For establishment of, my lord, ITI training
for
institute.
establishment of an ITA industrial training institute
Yes,
by the state government.
yes.
Full stop. An award was passed determining the compensation payable to the petitioner and others. However, while considering the eligibility of the petitioner for rehabilitation and resettlement as prescribed under section 31 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, Resettlement Act 2013, bracket henceforth referred to as Act of 2013. The respondent number 3 held that the family of the petitioner did not possess 8 acres. 8 acres.
8 acres, 15 guntas.
8 acres, 15 guntas. And what was acquired was less than 50% of the land. And therefore, the primary source of livelihood of the petitioner was not affected. And hence, he is not entitled to any rehabilitation as prescribed under Schedule 2 to the Act of 2013. Being agreed with the same, the petitioner is before this court. Next part. The learned counsel for the petitioner submits that Under section 31 of the Act 2013, the respondent number 3 is bound to pass a rehabilitation resettlement award for each affected family in terms of the entitlement provided in second schedule. He referred to the definition of the word affected family in section 3 subclause C bracket small Roman I and contended that it includes a family whose land or other immovable property has been acquired. He submits that the question whether a person has lost primary source of livelihood by virtue of the acquisition is applicable only to a family which does not own any land but is an agricultural laborer or a tenant and who is affected by the acquisition. Full stop. He therefore contends that the reasoning of the respondent number 3 in refusing to work out a rehabilitation resettlement award is wholly lopsided and deserves to be interfered with. Full stop. Per contra, the learned AGA has filed a statement of objections contending that the family of the petitioner owns 8 acre 15 guntas of land, of which 2 acre 36 guntas was acquired, and therefore the family possessed, therefore less than 50% of the total holding was acquired, and the family was not deprived of the source of livelihood. Hence, it was contended that the respondent number 3 has rightly held that the primary source of livelihood is not affected, and hence the petitioner is not entitled to the rehabilitation and resettlement award as prescribed under section 31 of the Act 2013. I consider submission of the learned counsel for the petitioner and the learned AGA for the respondents. Next para.
In Schedule 2 also, my lord, the words used are, my lord, both landowners and families whose livelihood are affected. So both, in both the situations, they make that distinction.
The preamble to the Act of 2013 provide however, specify that the Act of 2013 is to provide inter-alia relief to the affected families, relief to the owners of the land and other affected families, and provide just and fair compensation to the affected families whose land has been acquired or proposed to be acquired or are affected by such acquisition, and make adequate provisions for such affected persons for their rehabilitation and resettlement, and for ensuring that the cumulative income of compulsory acquisition should be that affected persons become partners in development, leading to an improvement in their post-acquisition social and economic status, and for matters connected therewith. Full stop. It is in the above background that the Act consciously defines an affected family as follows, copy moved. It also has defined a displaced family as follows, 2K. It is not in dispute that the family of the petitioner as a whole owned 8 acres, 15 guntas, huh?
Yes.
8 acres, 15 guntas of land in various survey numbers, of which an extent measuring 2 acre 36 guntas was acquired for the purpose of establishment of an industrial training institute by the state government. Therefore, the family of the petitioner was an affected family as defined under section 2C1 of the Act 2013. Once they were once they were part of an affected family, the respondent number 3 was bound to work out a rehabilitation and resettlement award for each affected family in terms of the entitlement provided in this second schedule, which is as follows. Copy mode, second schedule. Full stop. The reasoning of the respondent number 3 that the primary source of livelihood was not affected, primary source of livelihood of the family of the petitioner was not affected, was not a criteria to deny the relief to which the plaintiff petitioner was entitled to, as the family of the petitioner family of the petitioner did not comprise agricultural laborers and were not tenants in the land that was acquired. Therefore, the rejection of the claim of the petitioner for the rehabilitation resettlement award was thoroughly unjust and arbitrary. Full stop. The respondent number 3 was bound to work out a rehabilitation package as prescribed under Schedule 2 of the Act 2013. Since the petitioner is entitled to succeed in this writ petition. Consequently, the following order is passed. The writ petition is allowed. The impugned award, insofar as it denies the benefit of a rehabilitation resettlement package to the petitioner as provided under second schedule to the Act 2013, is set aside. Full stop. Number 3, the respondent number 3 is directed to forthwith work out a rehabilitation resettlement package to the family of the petitioner on the lines specified in Schedule 2 to the Act of 2013 within a period of 3 months from the date of receipt of a copy of this order. It is made clear that the respondent number 3 shall not further procrastinate
the issue and deny the relief to the petitioner on any other ground. Yes.
Lord, Annexure F is the approval of that, Lord. Annexure F is
Ah.
the approval of that award by the Deputy Commissioner. That may also have to be set aside, Lord, and
Consequently, the approval of the award by the respondent number 2
two, Lord.
is set aside to the above extent.
Yes. Annexure F.
Yes, the annexure F is.
Great.
Mr. G.G. Chakshetty.
I'm appearing for the petition. Senior counsel will argue this matter.
I appear for the.
Yes, please.
Lord, the petitioner uh, had filed form number 7 and was accordingly granted occupancy rate as at page 34.
Yes.
Then, however, the entries were not changed to his name, her name, and therefore a writ petition came to be filed, which is at page 37.
Yes.
Saying that the name should be entered in the revenue records. That petition came to be allowed. Then in the meanwhile, one Thirumal Rao, who claiming to be the owner of the property, filed a writ appeal against this order at page 40.
Yes.
Now this writ appeal came to be disposed of at page 42, paragraph 3. Learned counsel for the appellant submits that till this date, the concerned revenue authority has not passed any order in pursuance of the order of this court dated 24/2011. With that be so, it is open to the appellant to make an application seeking intervention before the concerned revenue authority for opposing the prayer made by respondent number 4 in his representation, and also a mutation application submitted by him. If any such application is made, concerned revenue authority shall allow the said application, and after granting opportunity of being heard to the appellant and respondent number 4, shall decide the representation in pursuance of the order dated 24/2011. If the representation of the respondent number 4 has already been decided, it is open to the appellant to challenge the order passed in appropriate proceeding. The Thirumal Rao contended that there is no such order at all and it is a forged document. At page 44, after hearing both sides, the Tahsildar passed an order saying that the according to the order passed by the land tribunal, the entries will have to be made. Against that, an appeal was filed. Appeal also came to be dismissed. In the meanwhile, the respondent filed another writ petition, page 55.
Yes.
In this writ petition, he contended that the order is a fictitious order, and at page 65, the operative portion of the order.
Yes.
Petitioner and the fourth respondent herein are directed to appear before the Deputy Commissioner on 7/11/22 at 11 a.m. without waiting for further notice. Page 65.
Yes.
The Deputy Commissioner shall thereafter hold an inquiry as directed herein and pass orders expeditiously as possible, at any rate within a period of 3 months. Now, in the previous paragraph, the court has directed that whether proceedings have been taken place or form number 7 is filed or not, we have to conduct an inquiry. At annexure G at page 66 is the impugned order. There the relevant reasoning of the Deputy Commissioner at page 73. At page 73, after the remand,
Yes.
the reasoning of the Deputy Commissioner, 73 last para. ಪ್ರಕರಣದಲ್ಲಿ
Yes.
ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಕಲಬುರಗಿ ಅವರ ನಿರ್ದೇಶನದಂತೆ ವಿಚಾರಣೆ ಕೈಗೊಂಡು ವಿಚಾರಣೆಯಲ್ಲಿನ ವಾದ ವಿವಾದ ಆಲಿಸಿ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿದ್ದ ದಾಖಲೆಗಳನ್ನ ಪರಿಶೀಲಿಸಿದಾಗ ಈ ಕೆಳಕಂಡ ಅಂಶಗಳು ಕಂಡು ಬಂದಿರುತ್ತವೆ. ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕಿನ ತಡಲ್ಗಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 203 47 ಎಕರೆ ಸೋನ್ಸೋಮಗೆ 23 ಎಕರೆ 34 ಗುಂಟೆ ಜಮೀನನ್ನು ರಾಮಚಂದ್ರ ಹನುಮಂತ ಕುಲಬಡ್ಡಿ ಇವರಿಗೆ ಶಂಕರಪ್ಪ ಯಮನಪ್ಪ ಇವರಿಗೆ ತಲಾ 12 ಎಕರೆ ಭೂನ್ಯಾಯ ಮಂಡಳಿ ಬಸವನ ಬಾಗೇವಾಡಿ ಆದೇಶ ಸೋನ್ಸೋ ಮಂಜೂರಾಗಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಅಧಿನಿಯಮ 45ರ ಅನ್ವಯ ಭೂಮಿ ಮಂಜೂರಾತಿಗಾಗಿ ಅರ್ಜಿದಾರರು ನಮೂನೆ 7 ಭೂನ್ಯಾಯ ಮಂಡಳಿಯ ಮುಂದೆ ಮಂಡಿಸಿದ ನಂತರ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರವು ಪ್ರಕರಣದಲ್ಲಿ ಉಭಯ ಪಕ್ಷಗಳನ್ನು ಒಳಗೊಂಡು ಹೇಳಿಕೆಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸಿ ವಿಚಾರಣೆ ಕೈಗೊಂಡು ಉಳುವನೆ ಭೂಮಿ ಒಡೆಯ ಎಂದು ಘೋಷಿಸಲು 73-74 ಕೈಬರಹ ಮಾನ್ಯ ಕಾಲಂನಲ್ಲಿ ಅರ್ಜಿದಾರರ ಹೆಸರು ನಮೂದಿದ್ದು ಪ್ರಸ್ತಾಪಿತ ಜಮೀನಿನಲ್ಲಿ ಉಳುಮೆ ಮಾಡುತ್ತಿರುವುದನ್ನು ಸ್ಥಳ ತನಿಖೆಯಿಂದ ಖಚಿತಪಡಿಸಿಕೊಂಡು ಮಂಜೂರಿಸಲಾಗುತ್ತಿತ್ತು. ತದನಂತರ ಅರ್ಜಿದಾರರಿಗೆ ಮಂಜೂರುಗೊಂಡ ಜಮೀನಿನ ಮೇಲೆ ಭೂ ಸುಧಾರಣೆ ಅಧಿನಿಯಮ 53ರ ನಿಗದಿಪಡಿಸಿದ ಪ್ರಿಯರು ವಿಚಾರಣೆ. ಆದರೆ ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಮೇಲ್ಕಂಡಂತೆ ಯಾವುದೇ ಪ್ರಕ್ರಿಯೆ ಜರುಗದೆ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಅಧ್ಯಕ್ಷರದ್ದಾಗಲಿ ಯಾವುದೇ ಸದಸ್ಯರದ್ದಾಗಲಿ ಹಸ್ತಾಕ್ಷರವಿಲ್ಲದೆ ಕೇವಲ ಸಹಿ ಎಂಬ ಶಬ್ದವನ್ನು ನಮೂದಿಸಿದ ಕಚೇರಿಯ ಮೊಹರು ಇಲ್ಲದ ಆದೇಶದ ಪ್ರತಿಯ ಆಧಾರದ ಮೇಲೆ ಸತ್ಯಾಸತ್ಯತೆಯನ್ನು ಅವಲೋಕಿಸದೆ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತವನ್ನು ಪ್ರಸ್ತಾವಿತ ಗ್ರಾಮದ ಭೂ ಮಂಜೂರಾತಿ ನಮೂನೆ 7ರ ರಿಜಿಸ್ಟರ್ ಪರಿಶೀಲಿಸದೆ ಅನಧಿಕೃತವಾಗಿ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಸಂಬಂಧಪಟ್ಟ ಹಿಂದಿನ ತಹಸೀಲ್ದಾರರು ಜಮೀನು ವರ್ಗಾವಣೆಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸುವುದು ಕಂಡು ಬರುತ್ತದೆ. Now, Lord, this he is referring to, he should have verified the original records. He is referring to the Tahsildar's order. Now he is referring to a copy of the land tribunal order, which is at page 34. ಅದರಲ್ಲಿ ಸಹಿ ಅಂತ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. At page 34 ಅಲ್ಲಿ. ಅದು this is a copy of the order. He should have verified the original. ಇದು ಯಾವ್ದ್ರಲ್ಲೂ ಇವರು ಒರಿಜಿನಲ್ ವೆರಿಫೈ ಮಾಡಲ್ಲ ಇವರು.
No, you have the records of the land tribunal that is placed on record. That is produced as annexure B.
Yes, ma'am.
Why don't you get it verified? Whether you looked into this document?
May I submit, my lord?
He goes into the correctness of the land tribunal order. ನೀವು 9 ವರ್ಷ ಇದ್ದಾಗ ಇವರು ಸಾಗುವಳಿ ಮಾಡಿದ್ದೀರಾ ಅಂತ. That issue doesn't arise. He will have to find out whether there is such an order or not.
Oh, you please come to page number 42 for a moment.
Yep.
Page number 42.
42.
Third line.
Yes. 42, para 3 blood.
Third line of page number 42.
The appellant claims to be the landlord of the property in dispute. According to the landlord, the tribunal never passed an order granting occupancy rate in favor of respondent number 4, who was the petitioner in WP number so and so.
So now para 3.
Para 3. The learned counsel or the appellant submits that till this day, concerned revenue authority has not passed any order in pursuance of the order passed in this court on dated 24/2011. If that be so, it is open to the appellant to make an application seeking intervention. Pursuant to this, Lord, he made an application for intervention. Now at annexure E, page 44, they passed an order saying that there is an order by the land tribunal directed.
On what basis? How can you say this? What have you verified before coming to the conclusion that there was no such grant?
May I submit, my lord?
Really? Come to page 74,
Yes.
last but one paragraph.
ತದನಂತರ ನಿಯಮಾವಳಿಗಳನ್ವಯ ಮಾನ್ಯತೆ ಹೊಂದಿರದ ಅನಧಿಕೃತವಾಗಿ ತಯಾರಿಸಿರುವ ಕೃತಕ ನಮೂನೆ 7 ಅಭಿಲೇಖಾಲಯದಲ್ಲಿರುವ ಮೂಲ ಕಡತಲನ್ನಾಗಲಿ
ಅಥವಾ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ
ಪರಿಶೀಲಿಸದೆ ತಹಸೀಲ್ದಾರರ ಕಾರ್ಯಾಲಯದ ಅಧಿಕಾರಿ ಹಾಗೂ ಸಿಬ್ಬಂದಿಗಳು ಶಾಮೀಲಾಗಿ ದೃಢೀಕೃತ ನಕಲು ಪ್ರತಿಯನ್ನು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ನೀಡುವುದು ಕಂಡುಬರುತ್ತದೆ. ಇದೇನು ಫೆಬ್ರವರಿ 30ನೇ ತಾರೀಕೇನು ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು 30
Form
ಡೇಟ್ ಇರ್ಲಿಲ್ಲ ಅಂತ. ಅದೇ ಕರೆಕ್ಟ್ ಅವ್ರು ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ ವೆರಿಫೈ ಮಾಡಿ ನಮ್ಗೊಂದು ಏನೋ ಅದೊಂದು ಸ್ವಲ್ಪ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ರೆ ನಾವು ಹೌದೋ ಇಲ್ವೋ ಹೇಳ್ಬೋದು ಅಷ್ಟೇ. ಇನ್ನೇನು ಇಲ್ದಲೇ ಇದ್ದಿದ್ರಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳೋಕ್ಕಾಗಲ್ಲ.
There is no original record.
Huh?
There is no original record. In fact, they had never filed a form number 7. This is not unfortunately, this is not a stray case. In Bagewadi Land Tribunal especially, this had become a fashion. So a bunch of form number 7 were missing so far as what I have learned is. What they do, they put a seal on it. They file a writ for mandamus against the government without making the owner a party. An order of mandamus is obtained from this honorable court. Thereafter, they create a record there. In fact, speaking of this very form number 7, it was purported to be filed on 30th of February, 1975. That is the first aspect. Secondly, there is no corresponding entry in the register of filing register. There is absolutely nothing. And in fact, my lords,
land record.
Yes, I will check.
in fact, on the last occasion, my lord, this honorable court had called for the records. It had verified it. And thereafter, finding it suspicious.
Also.
No, in another writ petition. In the writ petition I had filed earlier, that records were called for. Otherly, I have produced all the documents.
ಬರ್ಕೊಳ್ಳಿ. The Lord AG is directed to secure
Disposal.
records pertaining to ಎಲ್ಲರೇ CSR 372A:75 before the Land Tribunal, Basavana Bagewadi, as well as the order passed conferring occupancy rights
Alleged.
to the as well as the alleged order conferring occupancy rights.
And Form
The
7
petitioner.
Form 7 register also.
Petitioner dated 9/6/1976. ಎಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಹೇಳಿದೆ.
ಆಯ್ತು.
All records. List on ಯಾವತ್ತು?
Next week.
Thursday next week, yes. This is Halali. Respondent, learned counsel for respondent is absent. Hence list on date. Venkatesh Mallabadi.
There is an
Interim order granted as extended to the next.
Government is directed to produce the original CASRA.
My lord, they are given certified copy. Next week it may be posted. I will produce original Kasra Panima.
Learned AGA seeks time to comply the order dated 21/1/2025. List on
18th, 19th.
Any date, my lord.
any
Next week I
Tuesday,
will produce.
any Tuesday. Ravi B.
18th.
Patil, Sachin Mahajan. Yeah, ready?
Lord, I am filing some papers. Some time, ಸ್ವಲ್ಪ ಎರಡೆರಡು ಮೂರು ಆರ್ಡರ್ ಇದೆ ಅಡಿಯಲ್ಲದು ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು.
ಇದು ಯಾವ್ದು ಸಣ್ಣ ಕೇಸ್ ಹಾಕಲ್ಲ ನೀವು. The learned counsel for the petition seeks time. List on
Next Tuesday. Interim order in operation.
interim order granted early extend to the next date.
Great. 11th. There is some personal inconvenience on 11th. 13th.
Yes. DP Ambekar.
Please.
For mandamus, mainly.
Yes, government. Mandamus for what?
What has happened is, I-
Quashing ಕೇಳಿದಿರಾ?
passing, that is formal ಇದು. They have built a dam, my lords, which is now eroding my land.
Which
Kindly,
is eroding your land.
yes, my lord. Kindly page number 18, annexure C. My land is survey number 93. The water used to flow earlier.
ಅದು
without-
ಯಾವುದೋ ಒಂದು ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ನಿಮ್ದು ಏನಾಯ್ತದು?
Pardon? Yesterday I had gone, Sunday.
ಅದ್ರಲ್ಲೂ ಏನೋ ಎರೋಷನ್ ಅಂತ ಇತ್ತಲ್ವಾ?
Pardon?
Even in that case, there was some erosion.
Erosion is,
ಯಾವ್ದೋ ಒಂದು ಊರಿಂದ ಇದು ಬಳ್ಳಾರಿನೋ ಯಾವ್ದೋ ಒಂದು.
ಇಲ್ಲ ರಾಯಚೂರು.
ರಾಯಚೂರು.
ಅದು ಆಮ್ ತಾಲೂಕು.
ಹ್ಮ್.
In this case, my lord, the survey number 93 abutting, the earlier the stream used to flow. Now they have blocked it by putting a bund there. The photographs of the bund are on next page, my lord, C1 and C2. That is now eroding my land, even C3 and C4 also, my lord. Therefore, my lord, I have filed several representation to measure my land and take necessary precautions so that my land will not be this thing. Otherwise, the outer edge of the stream, that will always be eroding in my land.
In instruction, file the objection.
Therefore, my lord, I just sought for this thing. And all this is held up because ADLR is not coming and surveying.
Just why don't you conduct a survey, mister?
ADLR be directed to conduct a
Identify
survey.
their land so that tomorrow there's, even if there's erosion, they should be compensated suitably.
Yeah.
ಯಾವಾಗ ಮಾಡಿಸ್ತೀರಿ?
Direction.
ಬರ್ಕೊಳ್ಳಿ. It is a case of the petitioner, that is the owner of land bearing survey number 93/1A, measuring 2 acre 38 guntas and 93/1B, measuring 19 guntas, situated at Minchanal village, Vijaypura Taluk. Full stop. He contends that the respondents have respondent number. Yaru?
This thing, irrigation minister, respond to one.
Respondent number
1 and 2.
1, 2 and 3 have installed, though,
Constructed a dam, bund,
constructed a check
Bund.
dam,
check dam.
check dam ಅದು.
ಇದು ಇದೆ ಬಾಂದಾರ್ ಅಂತಾರೆ ಇದರಲ್ಲಿ.
ಬಾಂದಾರ್ ಅಂದ್ರೆ ಏನಂತಾರೆ?
ಬಾಂದಾರ್ is
Water storage.
dam,
Constructed a bund. Constructed a bund to store water. And that the land of the petitioner, which lies adjacent to the bund, is getting eroded. Full stop. He therefore submits that a survey be carried out to identify the limits of the land of the petitioner. Full stop. The learned AGA submits that if need be, steps would be taken to conduct a survey and fix the boundaries of the land of the petitioners. Next para. In view of the aforesaid statement, the respondent number 6 is directed to depute a surveyor to identify the land of the petitioner and fix its boundaries based on authenticated survey maps of the land bearing RS number 93/1A and RS number 93/1B of Minchanal village. This shall be complied within a period of 3 weeks, 4 weeks, 4 weeks, 4 weeks. And a report shall be furnished to this court. List on date, list in the month, the first week of March 2025. All other matters some other day.
One submission, madam. This writ petition can be disposed of.
ಯಾವ್ದು?
This writ petition.
ಯಾವ್ದು?
In
Survey-da?
survey is conducted and it is found that any land is missing.
Let it be, let the report come.
Please.
So I don't want you to send to their doorstep. ನೀವು ಹೋಗಿ ಅಲ್ಲಿ ಕಾಯ್ಕೊಂಡು ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಟ್ಟು ಕಾಸು ಕೊಟ್ಟು not necessary.
Please.
Serial number 69.
ಹಾ.
It's a matter, my lord, where commissioner report is accepted, my lord. Based on that, we have filed the review petition. I am for the respondent.
Yeah.
Last date of hearing, your lordship has heard. And the review petition was filed, my lord, after filing objection, my lord, without passing any order, my lord, based on the review petition, he has filed the writ petition.
ಏನ್ ಮಾಡ್ಬೇಕು?
Day after tomorrow is the
Day after tomorrow is?
LB day, my lord.
ಆಯ್ತು, ಓದ್ತಾ ಹಾಕೊಳ್ಳಿ.
69.
Bill number 40.
64. ಹಾ. ನಾಳೆ ಆಗಲ್ಲ, ಮುಂದಿನ ವಾರ. ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ? ಬಿ ಕೆ ಏರಿಯಾ ಮಟ್ರಿಗೂ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ. ಆಯ್ತು. Grant counsel for the respondent seeks time list in the month of first week of March.
Lordship, serial number 68,
Yes.
day after tomorrow, Lordship.
Why day after tomorrow, madam?
My lord, I have to file a statement of objection.
These are all still 2024 matters.
Lordship, continuously they have taken.
Let it gain some dust.
No, Lordship, that is urgency.
2 weeks maybe.
14 minutes. No
Ah.
confidence matter. It was passed over.
ಹಾ.
Kindly take it up tomorrow minutes.
ಯಾವ್ದು ಎಲ್ ಬಿ ಯಾವತ್ತಿರೋದು?
14.
ನಾಳೆ.
Passed over it is. It could be taken now.
ಅಣ್ಣರಾಯ. ನಾಡಿದ್ದು.
67, ma'am.
Nadida.
Tomorrow.
Nadida.
Tomorrow.
Lord, Thursday I have a problem, Lord. Tomorrow
No,
I'm ready.
tomorrow.
Yes,
We
tomorrow.
waited for you. We
Lord,
waited
I'm
for
very,
you.
my apology, Lord, my apology.
Tomorrow.
I'm very sorry. Yes, I will.
67, madam. R3 may be directed to secure instruction whether there is an inquiry pending as per next year E, ma'am. I have made Lokayak as a party. Then at council for Lokayak
Next week ಬರ್ಲಿ. Let it come next week.
Original record ಆಗ. ಬರಲ್ಲ. ಪಾಟೀಲ್ 2 weeks ಆದ್ಮೇಲೆ ಕೊಡ್ರೆ ಅದು ಸುಮ್ಮನೆ ಇವ್ರಂಗ ಗಡ್ಬಡ್ ಮಾಡ್ಬಾರ್ದು.
65 into motor.
Yes. 2024 matter ಇತ್ತು. 68.
ಆಯ್ತಾ?
ಮತ್ತೆ